Why all this? No problem, sir. It will come Monday. Can't help. Can't help, sir. With great difficulty, I have come today. Give it, yes. Urgency, no?
No, my name is not forthcoming in public or not accepted. Notice has been issued and my accounts has been fixed.
2:30. Monday, fresh matters Monday ಬರುತ್ತೆ ಕೊಡಿ. ಮಂಡೇ ಅಲ್ಲ ಸೀನಿಯಾರಿಟಿ ಎಲ್ಲ ಹಾಕಕ್ಕಾಗಲ್ಲ. ನಿಮ್ ಮುಂಚೆ ಮೂವ್ ಮಾಡಿರೋದು ಇದೆ ತಾನೆ, ಇದೆ ಅಲ್ವಾ? ಅವ್ರದ್ದು ಹಾಕದ್ ಬೇಡವಾ? ಅಲ್ಲ ಅವ್ರದ್ದು ಹಾಕದ್ ಬೇಡವಾ? ಹಾಕ್ಬೇಕು ತಾನೆ. ಸೀನಿಯಾರಿಟಿ ಇದ್ರೆ ಬರುತ್ತೆ. ವೈ give it. ವೆಕೇಟಿಂಗ್ ಸ್ಟೇ ಹಾಕಿದ್ದೀರಾ? ಕೊಡಿ, ಬರುತ್ತೆ, ಇಸ್ಕೊಳ್ಳಿ. ವೆಕೇಟಿಂಗ್ ಸ್ಟೇ ಇಸ್ಕೊಳ್ಳಿ ಮೇಡಮ್. ವೆಕೇಟಿಂಗ್ ಸ್ಟೇದು ನೆಕ್ಸ್ಟ್ ಟ್ಯೂಸ್ಡೇ ವೆಡ್ನೆಸ್ಡೇ ಯಾವ ಥರ ಹಾಕಿ. ವೇಟ್. When do you want it birth ಕೊಡಿ? Today evening. I'll give it 2:30. 2:30. Why?
Seniority wise ಬರುತ್ತೆ.
ಏನು?
ಇವತ್ತು?
All right. So what's the urgency now? Prison, give it, yes. 2:30. Give fresh matters, give madam. Fresh matters alla ಕೊಟ್ಬಿಡಿ. Don't wait for fresh matters, please give. All right, what's the problem? All right, ಈಗ ಅರ್ಜೆನ್ಸಿ ಏನು ಹೇಳಿ ಅಂದ್ರೆ ನೀವು ಸ್ಟೋರಿ ಹೇಳ್ತಾ ಇದ್ದೀರಾ. ಅಷ್ಟೇ ತಾನೆ, ಪರವಾಗಿಲ್ಲ. ಪಾಟ್ನಾ, ವೈ ಪಾಟ್ನಾ? ಸರ್, ಇಲ್ಲೇನು ಪ್ರಾಬ್ಲಮ್? Day after tomorrow. ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ಸ್ ಕೊಡಿ ಅಲ್ಲ. ಎಂಡ್ ಆಫ್ ದ ಲಿಸ್ಟ್ ಇಲ್ಲ ಕೊಡಿ. ಎಂಡ್ ಆಫ್ ದ ಲಿಸ್ಟ್ ಅರೆಸ್ಟ್ ಮಾಡ್ತಾ ಇದ್ದಾರೆ. ಮತ್ತೇನು ವೆಹಿಕಲ್ ರಿಲೀಸ್ ಎಂಡ್ ಆಫ್ ದ ಲಿಸ್ಟ್ ಯಾಕೆ ಸರ್? ಕೊಡಿ. ಟ್ರ್ಯಾಕ್ಟರಾ? ನಾಳೆ ಕೊಡಿ ಸರ್. ಏನ್ ಕೊಡಿ ಆ ಟ್ರ್ಯಾಕ್ಟರ್ ಮಾತ್ರ ತಗೊಳ್ಳಿ. Give all the other names. Let it be, sir. When was it rejected? Monday, sir. Monday or Tuesday? Give it, sir. Fresh matter, alva? Give it, yes. Lordship. ನಾಳೆ ಹಾಕಿ ಮೇಡಮ್. Government official list in 2025 January.
One submission.
Don't project government official here. If it's a poor man, tell me. I will take it at 2:30. Government officials ಗೆಲ್ಲ ಕೇಳಬೇಡಿ. ಕೊಡಿ ಮಂಡೇ, ಅದು ತಗೊಳ್ಳಿ, ಮಂಡೇ ತಗೊಳ್ಳಿ.
Lordship.
ಫ್ರೆಶ್ ಮೆಟ್ ಸೆಟಲ್ಮೆಂಟ್ ಬರ್ದು ಕೊಡಿ, ಯಾವತ್ತು ಬೇಕು ಸೆಟಲ್ಮೆಂಟ್ ತಗೊಳ್ಳಿ ಇವತ್ತು. ಅದು ಕೊಡಿ. ವೆಕೇಟಿಂಗ್ ಎಂಟ್ರಿ ಮಾಡಿರೋ ಡೇಟು ಕೊಡಿ ಮೇಡಮ್ ಅವ್ರಿಗೆ. ಮೇಡಮ್ ದಟ್ ಮದುವೆದೇನೋ ಹೇಳ್ತಾ ಇದ್ರಲ್ಲ, ವೆಕೇಟಿಂಗ್ ಎಂಟ್ರಿ ಮಾಡ್ರು. ಪೋಸ್ಟ್ ದಟ್ ಆನ್ ವೆಡ್ನೆಸ್ಡೇ, ನೆಕ್ಸ್ಟ್ ವೆಡ್ನೆಸ್ಡೇ ಅಂತ ಡೇಟು ಕೊಡಿ ಅದಕ್ಕೆ. ವೆಡ್ನೆಸ್ಡೇ. ಇಲ್ಲಿವರೆಗೂ ಏನ್ ಮಾಡ್ತಾ ಇದ್ರಿ? ಯಾವಾಗ ರಿಜೆಕ್ಟ್ ಆಯ್ತು? 17/9. ಈಗ 17/11 ಹತ್ರ ಬಂದಿದೆ. ಇಲ್ಲಿವರೆಗೆ ಏನ್ ಮಾಡ್ತಾ ಇದ್ರಿ? ಏನ್ ತೊಂದ್ರೆ ಇಲ್ಲ, ಕೊಡಿ. ಮಂಡೇ ಬರುತ್ತೆ, ಕೊಡಿ.
Submission, my lord.
Give it. 1 minute, vacating stay, I'll take wait. ಯಾಕೆ wait ಮಾಡ್ತಿದ್ದೀರಿ? ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ ಕೊಡಿ. ಸೀನಿಯಾರಿಟಿ ಪ್ರಕಾರ ಬರುತ್ತೆ ಕೊಡಿ. You may have moved it 100 times. Should I violate the seniority and put yours at the top? ಬೇರೆ advocates memo ಅಲ್ವಾ ಅದು? Memo alva. You may also be the one who has given a memo earlier. Yes. Give it. ತಗೊಳ್ಳಿ madam, ನಾಳೆ ತಗೊಳ್ಳಿ.
Lordship. Police officials have registered my lord 353 against my lord Umair. My lord, see, having my lord kicked out
Monday,
2
Monday.
years.
Yes.
My lord,
Monday.
my lord, Tuesday is for my lord appearance of accused today 2:30. ಅಲ್ಲ ಅದ್ರಲ್ಲಿ ಏನಾಗಿದೆ 353 ಹೆಣ್ಮಗು ಮೇಲೆ ಹಾಕಿದ ಮಗು 2 years ಮಗು ಇದೆ.
ಆಯ್ತು ಸರಿ ತಗೊಳ್ಳಿ.
Lordship, this honorable court had stayed a matter,
Ah.
but order sheet ಅಲ್ಲಿ passed over for next two, adjourned for next 2 weeks ಅಂತಿದೆ.
ಅದೇ ಆಗಿರ್ಬೇಕಲ್ಲ ಯಾರು?
ಇಲ್ಲ ನಾನೇ ಬಂದಿದ್ದೀನಿ ಸ್ವಾಮಿ.
One submission.
Lord,
6
ನೋಡಿ
weeks
madam.
ಅಂತೇಳಿ ಹಾಗೆ ಸ್ಟೇ ಆಗಿದೆ. ಅದಕ್ಕೆ ಹಾಗೆ extend ಗೆ
ಅದು ಐಜೆಗೆ ಕೊಡಿ. ಇದು ರಿಜೆಕ್ಟ್ ಮಾಡಿ.
Passport matter
ಹಾಗೆ
cannot seek for end of the
6
list.
weeks ಅಷ್ಟೇ ಇರೋದು.
ಯಾರು ಯಾರಿದ್ದು ನೋಡಿ ಮೇಡಮ್ ಅದ್ರಲ್ಲಿ? ಅದು ಯಾರಿದ್ದು ಸ್ಟೇ ಕೊಟ್ಟು ನೋಡ್ಬಿಟ್ಟು
Stay ಇದೆ my lord
Passport
ಇದ್ರಲ್ಲಿ.
matter end of the list, your lordship.
ಎಂಡ್ ಆಫ್ ದ ಲಿಸ್ಟ್ ಪಾಸ್ಪೋರ್ಟ್ ಮಾಡಿ ನಾಳೆ. ಎಸ್
ಸ್ಟೇ ಇದೆ ಇದರಲ್ಲಿ 6 weeks ಅಷ್ಟೇ ಟೈಮ್ ಕೊಟ್ಟಿರೋ ತಾವು. ಅದರಿಂದ ಮೆಮೊ ಮೂವ್ ಮಾಡಿ.
ಎಕ್ಸ್ಟೆನ್ಷನ್ ಅದೇನು ಅಷ್ಟೊಂದಿದೆ?
6 matters ಇದೆ my lord.
ನಾ ಯಾವತ್ತು ಆ ತರ ಕೊಟ್ಟಿಲ್ವಲ್ಲ ಅಷ್ಟೇ. ಯಾರು ಕೊಟ್ಟಿದ್ದು ಸ್ಟೇ?
ಅದು ನಾಗರಾಜಯ್ಯ ಅಂತ ಹೇಳಿ ಕೊಟ್ಟಿದ್ರು ಮೇಡಮ್. ಫೋಟೋ
ನಾಗರಾಜಯ್ಯ ಅಂತ.
PCIR ಆಗಿ.
ಸರ್ ಯಾರು ಕೊಟ್ಟಿರೋ ಸ್ಟೇ? ನಾನ್ ಕೋರ್ಟಾ ಬೇರೆ ಕೋರ್ಟಾ?
ನೀವೇ ಕೊಟ್ಟಿರೋದು ಮೇಡಮ್.
6 ವಾರಕ್ಕ
ಹೌದು ಮೇಡಮ್.
25 ಕೊಡೋದೇ ಇಲ್ವಲ್ಲ.
Swami, Dharwad
Date
matter.
ಕೊಡಿ my lord.
Swami, ಇದು ಧಾರವಾಡ matter ಸ್ವಾಮಿ ಇದು.
1 minute.
ಸ್ವಾಮಿ ಧಾರವಾಡ matter ಇಲ್ಲಿ ಟ್ರಾನ್ಸ್ಫರ್ ಆಗಿದೆ.
ಆಯ್ತು ಕೊಡಿ. ಧಾರವಾಡ ಮ್ಯಾಟರ್ ಟ್ರಾನ್ಸ್ಫರ್ ಆಗುತ್ತೆ ಇಲ್ಲಿ.
ಮೆಲೋಡ್ ಅದು ಧಾರವಾಡದಲ್ಲಿ ತಾವು ಕ್ವಾಶ್ ಮಾಡಿದ್ರಿ ಮೆಲೋಡ್.
ಪೆಂಡಿಂಗ್ ಮೆಮೋಸ್ ಯಾವ್ದಿದೆ? ಪ್ಲೀಸ್ ಗಿವ್ ಆಲ್ ದಿ ಮೆಮೋಸ್. ಪ್ಲೀಸ್ ಗಿವ್ ಆಲ್ ದಿ ಪೆಂಡಿಂಗ್
One matter,
ಪ್ಲೀಸ್ ಗಿವ್ ಆಲ್ ದಿ ಪೆಂಡಿಂಗ್
the
ಮೆಮೋಸ್.
leave of the court, not one matter.
Vacating, I'll take 1 minute. Give all the pending memos. Pending matters, give all the memos. No dates in pending matters, give all the memos.
Melods, my submission is Melods, it is a fresh matter pertaining to
Give
Dharwad.
all the memos in pending matters. Be silly, please wait. Give all the memos in the pending matters.
This case, my lord,
Please give all the memos.
that in
Pending matters, give all.
that in this case,
Except vacating stay application ಇರೋದೆಲ್ಲ ಬಿಟ್ಟೆಲ್ಲ ಕೊಡಿ.
in this case, my lord,
Any case, sir,
No.
give all the memos.
one submission.
Yes, sir.
I have filed this petition in the month of August. So far, it is not listed in fresh matters kuda.
ಕೊಡಿ.
And
ನಾಳೆ
date
ತಗೊಳ್ಳಿ.
is fixed,
ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ ಲಿಸ್ಟ್ ಆಗಿಲ್ಲ ಅಂದ್ರೆ ನಾಳೆ ತಗೊಳ್ಳಿ.
date is fixed
ನಾಳೆ
for
ತಗೊಳ್ಳಿ.
16th ನಾಳೆಗೆ.
My lords,
ಒಂದ್ಸರಿ ಲಿಸ್ಟ್ ಆಗಿ ಅಡ್ಜನ್ ಆಗಿದ್ರೆ ಐ ಆಮ್ ಗೋಯಿಂಗ್ ಟು
ಮೇಲೆ.
ಅಡ್ಜನ್ ಇಟ್. ರಾಜೇಂದ್ರ ರೆಡ್ಡಿ ಅವರೇ,
Please.
ಒಂದ್ಸರಿ ಲಿಸ್ಟ್ ಆಗಿ ಅಡ್ಜನ್ ಆಗಿದ್ರೆ ಐ ಆಮ್ ಗೋಯಿಂಗ್ ಟು
ಇಲ್ಲ,
ಅಡ್ಜನ್
ಇಲ್ಲ,
ಜಾನ್ವರಿ.
ಇಲ್ಲ, ಚಾನ್ಸ್ ಇಲ್ಲ.
my lords,
Lordships kindly.
ಇಲ್ಲ, ಇನ್ನೊಂದು
Give all the memos.
fresh matter.
Matter.
my lords,
Pending, give all the, I am not giving dates in any pending matters. Please give if you want to give. You take back the memo and do.
my lords, end of the list, my lords, my lords,
ED is
Fresh matter ಎಲ್ಲ ಕೊಡಿ sir.
that the ED is harassing the doctor, practicing doctor.
Fresh matter, please give.
my lords, end of the list, my lords,
My
my lords, end of the.
Fresh matters, please give.
My lord, a special court matter.
Fresh matter.
My lords, petitioner is the former chief minister. because
ಎಲ್ಲ ಹಿಂಗೆ chaos ಮಾಡ್ತೀರಾ, ಮೆಮೊ ನಿಲ್ಸ್ಬಿಡ್ತೀನಿ.
My lords, there is a threat of arrest. His son is contesting election. The complaint is a police officer. For end of the list, my lords.
ಆಯ್ತು ಕೊಡಿ, end of the list. Threat of arrest ಇದ್ರೆ end of the list
Not
ಕೊಡಿ.
one.
My lords, end of the list, my lords.
Please don't get into chaos.
Same petition.
Twice has moved memo.
Pending matter.
Fresh matter, Swami. Fresh matter. So 3 victim of the POCSO case, mother of the victim.
ಅದು ನಾಳೆ ಅದ್ ನಾಳೆ ತಗೊಳ್ಳಿ ಮೇಡಮ್.
Not one
My
matter.
lordship,
2022. After that, several civil disputes have arisen and the honorable court has granted an interim order in our favor. Now the complainants after 2 years have filed a complaint to use police machinery to settle the civil dispute.
As it will come on Tuesday. Give it.
my lords,
No urgency for end of the list in that case. Settlement, write and give when do you want?
my lords, end of the list, my lords,
Reporting of
End of the list.
end of the list.
Why?
My lords, this is regarding the drink and drive road traffic accident which happened near Satellite Bus Stand, my lords.
All right.
Sandhya's case, that we had filed a writ petition for the DVR footage. This honorable court had granted to summon the DVR footage.
Hmm.
Now the accused has applied for the bail application.
Hmm.
We had filed a application seeking
You're for
to,
the accused or the complainant?
I am for the complainant, my lord.
Now what happened now?
Now we, in the trial court, we had filed application to contest the matter individually, my lords.
Hmm.
But our prayer has been modified only only with respect to assist the public prosecutor.
That is all you are required to do.
My lords,
Law
kindly.
permits only that, madam.
And
Beyond
the-
that, you can't replace the public prosecutor and stand there, only to
My
assist.
lords, the whole process would read in fractions. My lords, we have a strong objections because till date, no CCTV footage has been.
All right, give it.
For the end of
This,
Your lordship, the
Special
petitioner is,
230 ತೊಗೊಳ್ಳಿ madam.
end of obliged.
Withdrawal memos ಯಾವ್ದಿದೆ ಎಲ್ಲ?
your lordship, the
special
petitioner is a student.
Withdrawal memos ಯಾವ್ದಿದೆ?
It's a reserved matter. It's a reserved.
Reserved matter. What reserved matter withdrawing?
It was reserved for, it's a bail matter. Where
ಯಾವ ಬೇಲ್ ಮ್ಯಾಟರ್ ರಿಸರ್ವ್ ಮಾಡಿದೀನಿ ನಾನು?
four matters were there, three matters were there.
ಪ್ರಜ್ವಲ್ ರೇವಣ್ಣದ ಅದು ಒಂದು ಬಾಕಿ ಇದೆ.
Please, sir.
ಅದು ಅದೇ ಸ್ಟೇಟ್.
We are withdrawing.
That will be posted for pronouncement. ಅವತ್ತೇನಾದ್ರು ಮಾಡಿ.
Milots, Milots says let of arrest, please,
Your
Milots.
lordship, the petitioner is a student, your
Let of
lordship.
arrest, please, Milots.
Why, sir?
Milots, what has happened, please, Milots? The Sessions Court has issued a red corner notice, please, Milots.
Why ರೆಡ್ ಕಾರ್ನರ್ ವರ್ಗೂ ಯಾಕೆ ಹೋಯ್ತು?
Please, Milots, the accused, please, Milots, is an American citizen. He cannot travel, please, Milots. And red corner notice is issued. And FBI has initiated the extradition process there, please, Milots. Your matters, the matter was heard by your lordship, please, Milots. The matter is admitted.
Which one?
Milots, this is relating to one ACON, please, Milots, in US where they send contractors there with the BHL, please, Milots.
So that international fraudsters.
Not internet. DRDO ಅವ್ರಿಗೆ ಒಂದು ಸಪ್ಲೈ ಮಾಡಬೇಕಾಗಿತ್ತು some equipment.
ಆಯ್ತು, ಈಗ ಏನಾಗಿದೆ ಈಗ?
Now, please, Milots, red corner notice is issued and FBI has also issued a extradition process they've already initiated in the US.
Should I stall process of the Federal Bureau of Investigation of the United States?
No,
What's
please,
that?
Milots.
Tomorrow.
Please.
Your lordship, the petitioner,
Give. ಎಲ್ಲ ಕೊಡಿ ಮೆಮೋಸ್ ಮತ್ತೇನ್ ಕಾಯ್ತು?
Your lordship, one
230 I'm not
submission.
taking that.
your lordship,
ನೀವು 10 times ಮೂವ್ ಮಾಡಿದ್ರು ಅಷ್ಟೇ, ಅದು ಕೊಟ್ಟು ತಗೊಳ್ಳಿ ಮೇಡಮ್, ನಾಳೆ ರಿಲೀಸ್ ಮಾಡೋಣ.
one submission, your lordship.
We'll release that from part head. 482 ನಾ?
Lordship, kindly, really.
Agenda was thought on the pretext of engaging senior.
ಯಾವ್ದು, which is that madam? Why is it moving memo for the hearing matters?
Detailed order has been passed already. On the last date, it was disposed of, they sort of adjournment on the pretext of.
Friday post ಮಾಡ್ಸಿ madam. They have
Your
no.
lordship, one humble submission.
We'll see till 12 o'clock. We will go on like this only. Give all the memos.
Your lordship, one submission, your lordship.
If you don't, yes, call the cases.
Lordship, one last submission, your lordship. The
Call the
petitioner,
cases.
the
Nobody-
petitioner, your lordship.
Call the cases.
Stay for vacating memo.
ಎಲ್ಲ vacating stay memos ಎಲ್ಲ ತಗೊಂಡ್ಬಿಡಿ.
The
Call the
matter may
cases.
be posted for final hearing. my lord.
first year.
Call the cases, madam. No, sir. Yes.
With permission, my lords, the case is pertaining to
Can't help.
Dharwad, my lords. May I submit, my lords?
Disposed matter, lordship.
Yeah.
Lordship has- It's a disposed matter, lordship has granted relief to the petitioner father for 30 days. I'm moving for extension, lordship.
CBI.
NIA, I already served the copy, lordship.
ಆಯ್ತು, ಅದು ಕೊಡಿ. All others, if you want to
One
give the
matter,
memo.
my lord, one
Yes,
for
yes.
230.
Call the
please.
cases, madam.
May I make one submission for 230, my lords.
Call the
There is
cases.
One
No,
matter
sir.
for 230, there is.
No, no.
230.
All urgency.
Your lordship, 7A matter, I pray.
All of you end up in getting into chaos here.
I waited so that the chaos gets.
Your lordship, on the 5th of December.
Give the memo. I'm not taking, give all the memos.
My lord,
No
one
dates on any
one
memo.
request, my lord.
Yes.
Serious and the industrial area.
Madam, ಅದು ಡಿಕ್ಟೇಟಿಂಗ್ ಆರ್ಡರ್ಸ್ ಹಾಕಿ. ಎಲ್ಲಿ ಮೆಮೋ? ಇದು ಹೇಳ್ಬಿಟ್ರೆ ಆಯ್ತಾ?
It's reserved for dictation, my lord.
ರಿಸರ್ವ್ ಫಾರ್ ಡಿಕ್ಟೇಷನ್ ಅಂತ ಯಾವ ಸ್ಟೇಜ್ ಇಲ್ಲ ಸರ್. ಮೆಮೋ ಕೊಡಿ. Yes.
230
My lord,
tomorrow.
my lord,
There's some
with the
urgency.
permission,
Mining lease agreement, my lords. Civil case is converted into a criminal thing.
Take bails.
Lords, but the entire family members are being dragged into it.
What to do, sir? None of you listen. I'm telling, please don't get into chaos. Have some discipline. Nobody is bothered. If you go on throwing memos like this, what can I do?
Understand, lords.
I'm also a human being. How much can I take? Tell me. I'm running temperature and I'm sitting here.
I understand. That's the only thing we waited so that the crowd gets
What
ready.
is this, sir? You should have some consent to the bench also. Yeah. I'm also a human being like you. I also have sickness. I also have everything.
That's right. We understand that's why.
What is this?
ಇಲ್ಲ ಅಂದ್ರೆ ನಾಳೆಗೆ at least.
ಅಲ್ಲ ಎಷ್ಟು ಅಂತ ನಾನು ತಗೊಳ್ಳಿ. ನನ್ ಬಂದಿಲ್ಲ.
Otherwise, we would not move.
This is a mining lease
ಸೋಮವಾರ
agreement.
450 ಮ್ಯಾಟ್ರ್ ತಗೊಂಡಿನಿ, ಅದಕ್ಕಿಂತ ಯಾರು ತಗೊಂಡ್ರು?
This CCB gets into such a interest.
It's all right. Everybody have a problem. I'm not telling that. But how much can I take? Can I take every day 500 matters still? And in 450 matters, I don't ask any one of you. I go on passing orders because I would have read the file. Right or wrong, I have done it.
Take my chance tomorrow.
ಅದಕ್ಕೆ not correct.
ನಾಳೆ move.
ಎಷ್ಟು ಅಂತ ಮಾಡಿ.
ಅಲ್ಲ ಏನ್, because of that only we try to move, my lord. I waited so that the crowd gets.
Crowd will never get, sir.
ಅದ್ ಆಗ್ತಾ ಇಲ್ಲ ಅಂತಾನೆ.
chaos ಏನ್ ಮಾಡೋದು ಹೇಳಿ? ಅರ್ಜೆನ್ಸಿ ಇದ್ರೆ ಎಲ್ಲರಿಗೂ ಅರ್ಜೆನ್ಸಿ ಇದೆ. ಎಲ್ಲರಿಗೂ ಅರ್ಜೆನ್ಸಿ. ಯಾಕಂದ್ರೆ ಬೇಲ್ ತಗೊಳಲ್ಲ, ಇಲ್ಲಿ ಬಂದು ಎಲ್ಲ ಅರ್ಜೆನ್ಸಿ ಮಾಡ್ತೀವಿ. When atrocities case, definitely I'll take, because bail won't be granted without hearing the other side. That yardstick I have followed. The moment they say it is atrocities case, I take it at 2:30. So, ನಾಳೆ ಕೊಡಿ, ತೊಂದ್ರೆ ಇಲ್ಲ. ಸ್ವಲ್ಪ ಡಿಸಿಪ್ಲಿನ್ ಆಗಿ ಏನಾರ ಒಂದು ಕೇವಸ್ ಇಲ್ಲದೆ ಮಾಡಿದ್ರೆ ನಾನು ತಗೋಬಹುದು. ಎಲ್ಲ ನನಗ್ ಬೇಕು ನಾನು ಏನ್
ಕೋರ್ಟ್
ಮಾಡ್ತೀನಿ?
ಚೇಂಜ್ ಮಾಡ್ಬೇಕು ಅಂತ ನಾನು ಹೇಳ್ತೀನಿ. ಅಸೋಸಿಯೇಷನ್ ಅಷ್ಟು ದೊಡ್ಡದು ಬೇಕು ನಿಮ್ಗೆ. ಈ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಆಗಲ್ಲ.
But what to do? I am also doing beyond what I can do.
I understand.
It's not concern. I have concern that every advocate's
Your
case should be
lordship set
taken.
the precedent. That's a problem. 700 ಮ್ಯಾಟರ್ ಹಾಕೊಂಡು ತಗೊಳ್ಳೋದು.
ಅಲ್ಲ ಹಾಗಲ್ಲ, that's the thing. Every day I can't do that. I am also definitely concerned about advocate. ಎಲ್ಲಾರ್ದು urgency. How much can I take? That's all. We'll try to take everything. Wait. Yes. Urgency ಇದ್ರೆ ನಾಳೆಗೆ ಹಾಕಿ. ಏನ್ ನಿಮ್ದೇನ್ ಸರ್?
Petitioner is a practicing advocate. Petitioner is a practicing advocate, my lord.
ಮಂಡೇವರೆಗೂ ಕಾಯಕ್ಕಾಗಲ್ವಾ?
It is pending matter, my lord. Monday
ಪೆಂಡಿಂಗ್ ಮಾಡಿ ಕೊಡಿ. ಸ್ಟೇ ಇಲ್ವಾ?
stay this.
This is the problem.
Reason is
ಸ್ಟೇ ಇದ್ದು ಮೂವ್ ಮಾಡ್ತಾರೆ.
TP
ಸ್ಟೇ ಇಲ್ಲದೆ ಇರೋ ಅಷ್ಟೊಂದ್ ಜನ ಒದ್ದಾಡ್ತಾ ಇದ್ದಾರೆ.
TP ಆಗಿ ವರ್ಕ್ ಮಾಡ್ತಾ ಇದ್ರು. ಇವಾಗ ಚಾರ್ಜ್ ಶೀಟ್ ಆಗಿದೆ ಅನ್ನೋ
ಮೆಮೊ ಕೊಟ್ಟಿರಿ.
at least my lord Friday, next week any date.
Next week ನೋಡಿ.
For final hearing, any date may be.
Next week.
ಮೆಮೊ ಯಾಕೆ ಕೊಡಿ?
My lords, my friend advocate Siddham is standing over there, my lords. The matter is pertaining to Dharwad, my lords. It is a fresh matter.
ಧಾರವಾಡ ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ ಏನದು ಧಾರವಾಡದ್ದು?
It is registered under Birds Act, my lords. Your lordship was pleased to quash 4 cases in Dharwad. Subsequently, it has come before your lordship.
ಫ್ರೈಡೆ ಹಾಕಿ.
So, please, my lords, 2:30.
Yes. 2:30.
My lords, Dharwad matter, my lords. So, no, not today, any date.
Yes, sir.
Please, sir, please.
Serial number 25, I undertake to file the wakalat, my lord. Serial number 25, matter listed today, I'll undertake to file the wakalat.
Oh, great submission, sir. 10:30ಗೆ ರೀಚ್ ಆಗೋವರೆಗೆ ವೇಟ್ ಮಾಡಿ. ಮನ್ನಾಪುರಂಗೆ ಏನು ಅರ್ಜೆನ್ಸಿ? ವೇಟ್.
ವಕಾಲತ್ ಹಾಕ್ಬೇಕಷ್ಟೇ.
ಹಾಕಿ ಬೇಡ ಅನ್ನ. 10:30ಗೆ ಐ ಆಮ್ ಗೋಯಿಂಗ್ ಟು ಫೈಲ್ ವಕಾಲತ್ ಅಂತ. ಏನೇನೋ ಶುರು ಹಚ್ಕೊಂಡಿದ್ವಿ.
Matter still number 1.
Serial number 1, I appeal for the appellants, please.
ಈಗ 1 to 10 identical.
1 to 10, not I have served, not copy of the objections yesterday, may just not.
They have filed their objections, they have sent it across, we have received the
May just
objections.
pass on.
I am ready to plead.
All 1 to 10.
Number 2 also.
Serial wise George Civil 1.
1 to 10 are identical. Arising out of the same order? No. Arising out of the same order. ಅದೆಲ್ಲಿದೆ?
Second list.
Second list.
There in the second list.
All right, we'll take that also. ಎಲ್ಲಾದ್ರಲ್ಲೂ ಹಾಕಿದ್ದೀರಾ?
Please.
Plus,
Objection.
the matter is serial number 1, please, Manoj. I am ready, please, Manoj.
Civil Nagesh sir last time ಇಲ್ಲೇ ಇದ್ದಾರೆ. He had made some submissions with regard to the sentence and other things.
Manoj.
ಅದು second list ಅಲ್ಲಿ ಇದೆಯಾ sir?
First list ಅಲ್ಲಿ.
First list.
First list ಅಲ್ಲಿ ಇದೆ, subsequently there too. After my matter is listed.
All right, so ನೀವೇ first ಮಾಡಿ. Yes, sir.
Manoj, the appeal is by accused number 2 and 3, please.
No, one clarification. These are orders, these are petitions arising out of the same order.
Not 6,
Same
not,
order.
All 12 petitions.
not different, not 6 CC numbers. I made a list.
Different
Arising out of the same first information report.
That's different CC numbers.
Different
but
CC number.
Same complaint.
Please.
All similar.
Yes.
ನಾನು ಒಂದು ಚಾರ್ಟ್ ಬೇಕಾದ್ರೆ ಕೊಡ್ತೀನಿ.
ಕೊಡಿ.
I have prepared.
Chart versus chart. Yes.
Just may not make it convenient, may not for.
ಈಗ ಯಾರು ಸ್ಟಾರ್ಟ್
Yes.
ಮಾಡಿ?
Appeal is by accused number 2 and 3, please. Manoj. Accused number two.
I'm holding criminal appeal 2073.
Yes, please. Malas accused number two is Ashapura Maincham
All right.
Limited, a company, please note, which is convicted for offence under 120B, 379 and 420 IPC. Sentence imposed is 9 crore rupees, please note, fine. A1, A2,
120B.
379, 420 IPC.
Uh,
Sentence is 9 crore rupees fine on A2. Be paid jointly and severally along with accused number 1 and accused number 4.
all right.
Then accused number 3, please note, Chetan Shah is the MD of accused number 2. He too is convicted for offence under 379, 420 and 120B. Plus for 120B, he has been sentenced to 5 years imprisonment and 20,000 rupees fine.
All right.
For 379, 3 years imprisonment and 20,000 rupees fine.
All right.
And for 427 years prison.
Uh,
And 9.6 crore rupees fine. Plus the allegation as against the petitioners, the appellants, are to the effect that, and the evidence material on record, please note, is to the effect that they sold locally the material, the iron ore material, please note, to accused number 4. That was subject to verification of the records as per the directions of the Honorable High Court of Karnataka. Plus,
Right.
before even verification of the records, the material was sold. That is an admitted fact, please. Plus, this material, please, which was sold was royalty paid and tax paid.
all right.
Then, please, on page number 11, print page number 11 of the judgment may kindly be looked into, please.
Yes.
Print page number 12. The mine owners sell the iron ore to various traders and intermediaries. A significant quantity.
I am at page 12. Where
On
are
page 12. Type the page, please, page 12 of the judgment. Of the judgment, please,
I am there only. Page 12 ಅಲ್ಲಿ ನೀವು ಓದ್ತಿರೋದೇನಿಲ್ಲ.
Page 12, please, of the judgment.
ಅಲ್ಲೇ ಇದ್ದೀನಿ.
Print page number 62.
Yes, there.
Plus, the relevant portion is right in the center. On 26/5/2010, to a vessel Columbia so-and-so illegally exported about so-and-so iron fine. Messrs. Ashapura Maincham Limited and others, due to the aforesaid act of the accused person, the offence mentioned above was committed by the accused persons. Accordingly, charge came to be filed against all the accused persons. Then, please, according to the finding, please, a loss of 9 crore 5,91,998 was caused to the state exchequer, prisoners. This is without any basis at all.
No, you are not arguing the appeal, sir.
No, I am not arguing the appeal, only with regard to the suspension of the sentence.
Yes.
Unless I will demonstrate before the court as to how the
As
erroneous,
far as I have known, in a criminal appeal,
an erroneous judgment has been.
Suspension of sentence and admission of the appeal. Matter of right. In a criminal appeal. So if decision in a criminal appeal, we will take.
Right of appeal.
That is what I'm telling. I only gave him opportunity to file his objections.
But some of them
He would not dispute that position of law also.
Some of them enjoyed the benefit of anticipatory bail during the investigation. Some enjoyed the benefit of bail during trial.
That's all right. No.
What the apex court has time and
Right,
said is,
right to appeal.
the conduct of the accused during trial has to be seen for the purpose of suspending the sentence is the law laid down by the Supreme Court.
Regular bail of
Is it
crime.
their case? It is the case of the prosecution that at any point of time I misuse the liberty that has been granted to me during the trial of the case. That's the issue.
Yes.
But that is the law laid down by the
No,
Supreme
I
Court.
just gave him opportunity to file his objections.
There is
not
absolutely
the
no
Position of
basis
law,
to
he is
bail.
also aware, but let me hear you. No problem.
Please,
ಅಷ್ಟೇ ಅಲ್ವಾ ನಿಮ್ದು? appeal ಅಲ್ಲಿ ಏನು argue ಮಾಡೋದ್ ಬೇಕಾಗಿಲ್ಲ.
Allah, I can demonstrate what exactly is the error.
No, for suspension of sentence or admission of the appeal, what senior counsel C.V. Nagesh ಅವರು ಹೇಳಿದ್ದಾರೆ.
Just, please.
I guess so.
That's all.
If unless he disputes the position and tells me that no, appeal should not be admitted, it's a matter of, not a matter of right.
Probably, the next question that may arise for my lord's kind consideration is with regard to the, while ordering this sentence of imprisonment to be suspended, whether am I required to pay the huge amount of fine that has been imposed?
That will hear him.
That probably you will not.
Probably will, on that
have
we
to
will-
hear us.
on that we'll hear.
On that your lordship
Yes,
may have to hear us.
On that particular issue, please, Manoj, my humble submission would be, the trial judge arrives at a conclusion. ಅವ್ರು ನಿಯರ್ ಮಾಡಿ ಮಾಡೋಂಗಿತ್ತಂದ್ರೆ ಅವ್ರು ನಿಯರ್ ಮಾಡಿ.
ಅದಕ್ಕೆ ಅವ್ರು ಹೇರ್ ಮಾಡೇ ಮಾಡ
ಆಯ್ತು.
ಅದನ್ನ ಸರ್ ನಿಮ್ದೇ. ಎಸ್ ಸರ್.
ಎಲ್ರಿಗೂ ಅಷ್ಟೇ.
It is one member, represented by one of the partner, my lord, which is list number 2, my lord, second matter.
All right, yes. For list number 2 ಅಲ್ಲಿರೋ 2 matter, these 10 matters arise out of the same case.
Now the partner and the firm is the limited lord. And then you lord, that if my lord, only facts, my lord, it will be very helpful for you lord to give a dictation. Lord, transportation of iron ore from Hospet, my lord, to Velikere Port was going on. Lord, a huge dump was there in Velikere Port. We extend of about 5 to or 8 lakhs, my lord, difference, my lord, they change words, my lord, this is. Initially it was 5 lakhs, later, my lord, it was changed to 8 lakhs. About 5 lakh metric ton of iron ore which was there, my lord.
On the merit of the matter, when we hear the appeal, we will consider that.
But here one aspect, your lordship, to determine, my lord, with regard to fine is concerned. My lord, the other proceedings are pending with regard to illegality is concerned. With regard to illegality of iron ore is concerned, special CC 105 is still pending for trial. It is not decided. This, my lord, Supreme Court directed, my lord, this case pertains to those after seizure by the forest authorities who have removed it without the order of the court. In the teeth of the order of the court, who have removed it, please investigate. This FIR, my lord, is in respect of 17/2012 registered by CBI. My lord, regarding, my lord, removal, my lord, or export of this iron ore without the order of the court is the question. My lord, what offence constitutes? My lord, it will not be a theft also, it will not be a criminal breach of trust also. It is at best, my lord, to the extent of disobedience of the order of the court. Or without permission of the court, my lord, the iron ore has been exported. My lord, iron ore belong to the exporter. My lord, these our accused, my lord, they had sold already. My lord, they have no liability at all. It was on a FOR basis, my lord. They sold 1 lakh metric ton of iron ore. On delivery, my lord, their burden, my lord, is completed. They have not removed. They have not exported. Thereby, my lord, that either the offence of 379 or 420 does not apply to our accused. Quantum of fine also they are not liable to pay because the material, iron ore material is not illegal.
No, that we will see. That is quantum of fine is a part of the final order. We will hear on that also.
With this, my lord, since the sentence is the maximum.
We will fix a date for its final hearing, and on that date, close the proceedings. Yes, Prasanna Kumar?
Please, not, this is a case, not.
C.V. Nagesh sir, something else.
ನಾನು ಚಾರ್ಟ್ ಕೊಟ್ಟಿದ್ದೀನಿ. I am only on the question of the payment of fine amount. But
ಯಾವ ಚಾರ್ಟ್ ನಿಮ್ದು?
yes.
Yes, sir.
ಇದರಲ್ಲಿ conviction is under section 300.
You are appearing in criminal appeal?
Well, 2080 first.
All right.
I am an accused in all the 6 cases.
All right. Madam, 2080.
And I am the purchaser of the property. Well, every payment is made by me through a crossed account pay negotiable instrument or by way of bank transfer. But the payment so made by me is spoken to by the prosecution witnesses. I have even given, my lord, how much payment I have made and who are the witnesses who would speak with regard to the payment which the seller has received from me. The total payment I have made is 61 crores. Well, if I am required to pay certain amount by way of fine, does it not amount to double payment which I am required to make? I have not only made payment to the person from whom I have purchased the iron ore, but also if I am required to pay certain amount by way of fine, that amounts to double payment. My lord, the law on the point is this, my lord. The first judgment of the Supreme Court is in 2018, volume 15, Supreme Court cases 139. Well, not that your lordship has no jurisdiction to ask me to deposit the fine amount. Kindly have a look at paragraph 36 of this judgment. This would be in 2018, volume 15, Supreme Court cases 139.
Paragraph.
In Satyendra Kumar Mehra versus State of Jharkhand.
Paragraph.
Paragraph 36, my lord. Kindly go to paragraph 36. And even their lordships would deal with section 357. Even in the instant case also section 357 is there. And in the event of the fine amount being declined, the state government should be compensated. That is the order which came to be passed by the trial court, presumably in exercise of its jurisdiction under section 357. We, however, make it clear that the appellate court, while exercising power under section 389 CRPC, can suspend the sentence of imprisonment as well as a fine without any condition or with conditions. There are no fetters on the power of the appellate court while exercising jurisdiction under section 389 CRPC. The appellate court could have suspended the sentence and fine both, or could have directed for deposit of fine or part of fine amount. This is my lord's jurisdiction as an appellate court. Well, the second judgment is the latest judgment of the Supreme Court in 2024. This is in 2024 SEC Online SC 3036.
Yes, sir.
May I request your lordship to kindly turn to paragraph 8 of this judgment. While suspending the sentence, especially the sentence of fine, the appellate court can impose conditions. Whether the order of suspension of sentence of fine should be conditional or unconditional depends on the facts of each case and especially the nature of offense. For example, when there is a sentence of fine imposed, well, it is only an example under 138. For example, when there is a sentence of fine imposed while convicting an accused for the offense punishable under section 138 of the NI Act, depending upon the facts of the case, the appellate court may impose a condition of depositing the fine amount or part thereof while suspending the sentence. However, the approach of the court may be different in case of offenses punishable under the IPC and cognate legislations. Whenever a prayer is for suspension of the sentence of fine, the appellate court must consider whether the sentence of fine can be suspended unconditionally or subject to conditions. However, the court has got to keep in mind that if a condition of the deposit of an amount is imposed while suspending the sentence of fine, the same should not be such that it is impossible for the appellant to comply with it. Such a condition may amount to defeating his right of appeal against the order of conviction, which may also violate his rights under Article 21 of the Constitution.
Impossibility ಯಾರ್ದು ಇಲ್ಲ ಬಿಡಿ. ಎಲ್ಲ ಪಾಸಿಬಿಲಿಟಿ ಇದೆ. So that sentence clear.
ಅಲ್ಲಲ್ಲ ನಾನು ಯಾಕೆ ಹೇಳ್ತಾ ಇದ್ದೀನಿ ಅಂದ್ರೆ
Yes.
60 ಕೋಟಿ.
ಅಲ್ಲ ಗೊತ್ತಾಯ್ತು, ಫೈನ್ 9 ಕೋಟಿ.
ಫೈನ್
ಡೆಪಾಸಿಟ್
Jointly.
ಅದು
ಸೇರಿ distribution.
ಓ ಎಲ್ರು.
Not each.
ಇರೋದು ಅಲ್ಲ, ನಂದೊಬ್ಬಂದೇ 18 ಕೋಟಿ ಬರುತ್ತೆ ನಂದು. ಆಯ್ತೆ. ಅಂಡ್ ಜೊತೆಗೆ ನಾನು I have brought to your lordship's kind notice. Now, my lord, the chart itself would indicate that I have made the payment to the persons from whom I have purchased.
So that we will see. That's a
ಅಲ್ಲ,
matter.
ಎಲ್ಲ ವಿಟ್ನೆಸ್ಗಳೆಲ್ಲ ಹೇಳ್ತಾರೆ, ಅದನ್ನು ಹೇಳಿದ್ದೀನಿ ನಾನು, ತೋರಿಸಿದ್ದೀನಿ ನಾನು, ಚಾರ್ಟ್ ಅಲ್ಲೇ ತೋರಿಸ್ಬಿಟ್ಟಿದ್ದೀನಿ ನಾನು.
Scrutinizing the evidence and other things will come when we hear the appeal. Now it is whether the fine should be stayed or not. Sentence to be suspended in an appeal. Appeal is a matter of right.
That is what the 2024 would say.
Where? Justice Oak ಅವ್ರದ್ದು.
Justice Oak.
Appeal is a matter of right. Appeal is a matter. He will not dispute that position also. Appeal is a matter of right. But
And my lords, what the Supreme Court has said is, for the purpose of consideration of bail, the conduct of the accused appellant during trial needs to be taken, excepting that nothing else and nothing more, where he has a right of appeal. Did I violate the liberty that was granted to me in any manner whatsoever?
ಇದ್ರಲ್ಲೇ ಇದೆಯಾ?
That is, yes, my lord. That is in 2009 Supreme Court cases, 767, paragraph 24. Have a look at paragraph 24, my lord. This is the only consideration. Taking into consideration the overall view of the matter, and in particular the offence alleged and the sentence imposed, my lord, the offence alleged and the conviction is for an offence under section 420 and 379. My lord, if I may say so with utmost respect, my lord, I am sure your lordship would certainly agree with me. These are all offences which are actually triable by the court of the magistrate. Since my status is that of either a former legislator,
what
a
you have
member of
gone
parliament, a special court came to be constituted pursuant to the actions of the Supreme Court, and I am tried there. In the normal course of things, my lord, the magistrate would certainly grant the benefit of bail for an offence under.
So you were out on anticipatory bail throughout?
Yes.
Then
Some are on anticipatory bail, some are on regular bail. My lord,
we'll hear the question of
taking into consideration in overall view of the matter, and in particular the offence alleged and sentence imposed, and further taking into consideration the acquittal of the other accused persons who are also charged sheeted in the same offences as that of the appellants, and further taking into consideration the conduct of the appellants during the trial before the Sessions Court when they were on bail, in our view, the High Court could have suspended the sentence and granted bail to the appellants. Therefore, this court would be justified in invoking its jurisdiction under Article 136 of the Constitution and granting the bail. But what needs to be seen here is the conduct. I'm sure the public prosecutor who is representing the state does not dispute the fact that my conduct during trial was exemplary.
Now we'll hear it. Yes, sir.
Not,
You have any contrary view to say that admission of appeal is not a matter of right or suspension of sentence is not a matter of right?
not in fact, no, this is not a case.
Fine, Vishwagi, we'll see what is to be
Please,
done.
no, I have studied all the judgment which my
All right.
senior
All
friend not cited. But I wanted to not bring the same judgments to your lordship's kind notice.
Yes.
No, the first will not 2024, which my learned senior friends stated, your lordship will not para 8 again. CBA versus Ashok Sirpal.
Yes.
Not at the first, not the 4 lines of para 8 says, it depends on facts of each case.
Correct.
And especially the nature of offense. And not it becomes the condition of deposit amount is impossible, that has to be considered.
That will.
But now your lordship may kindly consider not the facts of this case. Not this is a case where initially an FIR came to be registered. The goods, not the iron ore was seized.
You are arguing only on the.
Only on not whether or not they should be not directed to deposit fine or not.
Only on fine.
Only on the.
So suspension of sentence and admission of the appeal, you accept that it's a matter of right.
Under 389, the other day I submitted your lordship that he has no right of audience. Since,
on the
since
fine
I said, I bow my head for my lord's direction, your lordship ordered notice to him.
No, there is
Let us see section 389, proviso to section 389. It is only a matter between the court and the appellant.
That is correct.
Principles of natural
Therefore, he
justice
can't argue
go.
the merits and he can't say I have objection.
Principles of natural justice go beyond may not
On
the
fine, I will
statute.
hear it.
Please.
Beyond may not the principles of
that.
natural justice. But
In
would
fact,
go
your
beyond may not
lordship
the
has curtailed all
statute.
of us from taking your lordship to the merits of the matter.
No, merits of the matter.
Certainly take your lordship also to the merits of the matter. Demonstrate, my lord, the falsity of the judgment. I shall show to your lordship.
No,
if my lord
Prasanna Kumar
permits me. Charge it up.
Allah, that is true. That cuts at the root of the matter. We'll see when we hear the matter.
Charge it up.
Admission of
379 allegations. 420 go ಒಂದೇ. 420 sentence ಇಲ್ಲ ತೋರಿಸ್ತೀನಿ ನಾನು 120 big sentence ಇದೆ ಹೇಗೆ ಬರುತ್ತೆ ಅದು 420 kindly have a look at the judgment.
We'll hear him on the fines.
Please,
I'll give a date for hearing the appeals also.
Please.
Not the FIR came to be registered. The iron ore monad was seized, reported to the jurisdictional magistrate. Magistrate monad would order not the retention of monad this iron ore, not by the complainant. Under the teeth of the order of the learned magistrate, not these items, not this iron ore is shifted.
That is admitted.
That's admitted.
Yes.
Transported. No, not they say that this is not an offense. Not that your lordship are going to not hear,
Yes.
not at the end of the trial. Now, the first contention not is that they were on bail during trial. They were not misused. Whether that is a not condition in a case where not this is not a case where not some poor man steals not bread when he is hungry. This is a case where this is a case where The men in power may not have misused the
So,
power and may not
if that
looked at
yardstick is
the
to be,
natural resources.
if that yardstick is to be applied, Bhajan Lal's judgment was concerning a chief
Of course,
minister.
of course. Not while directing them, whether not they should be asked not to deposit
So it is
sentence or
applied even
otherwise.
to the poor man. Bhajan Lal is applied even to the poor man.
But whether they should be asked to deposit sentence or otherwise.
See, that I will decide.
Therefore, not your lordship may have to consider under what circumstances. Not it depends on case to case basis. Not what is this case, the facts of this case. We should not pursue your lordship not to ask them to deposit the fine amount. Not my first submission is not in a similar set of case. Not this is a case where not there are 6 cases, not as against not few of the accused person. In each of the cases, they are not sentenced to 7 years. So it is virtually 42 years for each of these appellants. The learned trial judge has not passed any order
on
saying
running.
that this will merge with the other one. Sentence of imprisonment is different.
Left it to this court.
Yes, not to this honorable court. But in 2008, part 5 SEC, I just not pass on. Hey, ಅವ್ರಲ್ಲೇ ಆಗಿಲ್ಲ ಕಾಪೀಸ್ ಸರ್ ಕೊಟ್ಟೆ ಸರ್
Paragraph?
not paragraph number. Not this is a case, not your lordship will find, not from page 3 onwards, not page
This
724.
regarding fine?
Not eitherly, not different, CCs were there, not similar to the case on hand. From page 724, your lordship will find. Not different, sentences.
All right.
Exactly, not similar to the case on hand. But Honorable High Court was pleased to suspend the sentence. But what the apex court would say, what is that para number 11? This is also a case of cheating, not on 420. It is true that the parameters to be applied in cases where life or death sentence is imposed may not be applicable to other cases, but the gravity of the offense, the sentence imposed, and several other similar factors need to be considered by the court. The fact that the accused was on bail during trial is certainly not a relevant factor. This position has been fairly considered by the learned counsel of the respondent. The reasons indicated by the High Court for grant of bail, in our opinion, do not satisfy the parameters. It needs to be pointed out that the trial court, considering the gravity of the offense, has directed the sentence to run consecutively, not similar to the case on hand. This aspect has also not been considered by the High Court. In the circumstance, the impugned order in each case is indefensible and deserves to be set aside, and we direct so. Not in a case of this nature, where the learned trial judge had ordered.
Here, sentence was not suspended.
Sentence was suspended with that has been not set aside. For the reason that, the learned special judge has said that the sentence should run consecutively. Though it is 7 years in each
here
case.
Nothing is said.
No, though it is 7 years in each case, it's virtually 7 years into 6 cases. 42 years. Therefore, my first submission is, since the sentence imposed is not 7 years, but 42 years though cumulatively, it may not be a case where they are entitled to. Then with reference to deposit of fine amount, not the 2024 as well as this 2018, which my learned senior friend cited, Satyendra Kumar Mehra. But in that judgment, your lordship may kindly.
That's with regard to fine.
Paragraph number 16.
With regard to fine, right?
With regard to fine.
Yes.
Not a submission was made in this judgment that if I am directed to deposit fine, which is virtually the compensation amount under 357. 357(2) says no, that cannot be disbursed to the state or to the complainant. Apex court said that is not a ground for suspension of sentence of fine. It depends on facts of each case, and it will not amount to automatic suspension of imposition of fine. It depends on facts of each case. Therefore, this was in this 2018, entire fine was asked to be deposited, and Apex Court did not interfere with the order.
All right. Sentence was suspended.
Sentence was suspended, of course, but not about the fine amount.
Now, what is the fine amount in all these cases?
I have, in my chart, I have given as to how much each person may have to pay.
Now, 2082.
2082 in the first page of the chart that I have not brought to your lordship's kind notice.
Yes.
A1 is 6.03 crores there. In all, there are
accused. 2082 ಯಾರ್ದು?
No, 2080 ಮೇಲರ್
2082.
2082 ನಮ್ದೇನೆ.
Yes, sir.
ಅದರಲ್ಲಿ I have, for the purpose of buying the property, I have paid 4 crores 56 lakhs 18,660 through a negotiable instrument. That is spoken to by PW 29.
Now,
He
what is,
admits.
what is the fine imposed now?
The fine that is imposed upon me is 6 crores.
No, not on one person, it is not, not on all the persons.
None
In the,
moving
in
there
that criminal, in that, CC.
2082
Each
ಈಚ್ ಅಂತ ಹೇಳಿಲ್ಲ, ಕಾನ್ಸಿಕ್ಯೂ ಎಲ್ಲರೂ ಸೇರಿ ಅಂತ ಹೇಳಿದ್ದಾರೆ.
Company,
ಈ total
company
amount-
and the managing director.
Total amount ಎಷ್ಟು ಬರುತ್ತೆ ಎಲ್ಲ? each case?
6.03 crores ನೋಡಿ,
ಇದರಲ್ಲಿ
ಅದರಲ್ಲಿ ಒಬ್ಬೊಬ್ಬರಿಗೆ 1.51 crores, not 40 lakhs, 40,000. 1.51 crores,
ಹಾ.
40,000. ಅದು ನಾನು ಚಾಟ್ ಅಲ್ಲಿ ಕೊಟ್ಟಿದ್ದೀನಿ ನೋಡಿ, ಇನ್ ಮೈ ಚಾಟ್ ದಟ್ ಐ ಜಸ್ಟ್
ಅಮೌಂಟ್ ಹಾಕಿದ್ದೀರಾ?
ಹಾಕಿದ್ದೀನಿ ಅದರಲ್ಲಿ.
ಓ A1 ಜಾಯಿಂಟ್ ಅಂಡ್ ಸೆವರಲ್
ಇದನ್ನ
ಎಲ್ಲದರಲ್ಲೂ ಜಾಯಿಂಟ್ ಅಂಡ್ ಸೆವರಲ್?
ಜಾಯಿಂಟ್ ಅಂಡ್ ಸೆವರಲ್, ಜಾಯಿಂಟ್ಲಿ ಹೌದು. ಯಾರ್ಯಾರು ಜಾಯಿಂಟ್ಲಿ ಇದೆ, ಕೆಲವು ಪಬ್ಲಿಕ್ ಸರ್ವೆಂಟ್ ಇದ್ದಾರೆ, PC ಹಾಕಿದ್ದಾರೆ.
18 crores ಬರುತ್ತೆ ನಮ್ದು.
ಹಾ.
As against me, as the managing director of this company.
ಈ ಪಬ್ಲಿಕ್ ಸರ್ವೆಂಟ್ಸ್ ಎಷ್ಟು ಇಂಪೋಸ್ ಮಾಡಿದ್ದಾರೆ?
ಪಬ್ಲಿಕ್ ಸರ್ವೆಂಟ್ಸ್ ಗೆಲ್ಲ ಬಹಳ ಕಡಿಮೆ ಇದೆ.
Jointly and several.
ಜಾಯಿಂಟ್ಲಿ ಸೆವರಲ್ ಲೆಕ್ಕ ಹಾಕಿದ್ರೆ
Jointly and several.
ನಾವ್ ಯಾರ ಹತ್ರ ಹೋಗಿ ವಸೂಲ್ ಮಾಡ್ಕೊ, ನೀನ್ ಇಷ್ಟು ಕೊಡು ನಾನು ಇಷ್ಟು ಕೊಡು ಅಂತ ಚಂದ ವಸೂಲ್ ಮಾಡಕ್ಕಾಗತ್ತಾ?
ಅಲ್ಲ, ಅದನ್ನ ಅಫೆನ್ಸ್ ಮಾಡೋದಕ್ಕಿಂತ ಮುಂಚೆ ಅವ್ರು ಯೋಚನೆ ಮಾಡಿದ್ರೆ ಚೆನ್ನಾಗಿ.
ಸರಿ, ಅಫೆನ್ಸ್ ಆಗಿದ್ಯಾ ಅನ್ನೋ ಪ್ರಶ್ನೆ ಸಾಹೇಬ್ರು ಯೋಚನೆ ಮಾಡ್ತಾರೆ. ಅಲ್ಲ, ನೀವ್ ಹೇಳೋದು ಅಫೆನ್ಸ್ ಆಗ ಮುಂಚೆ ಈಗ ಸಾಹೇಬ್ರು ಯೋಚನೆ ಮಾಡ್ತಾರೆ.
ಅಂದ್ರೆ ಏನಾಗುತ್ತೆ ಅನ್ನೋದು
ಅಲ್ಲ,
ಗೊತ್ತಿದ್ರೆ
ತೋರ್ಸುದು ನಾ ತೋರ್ಸ್ಬಿಡ್ತೇನೆ ಎಲ್ಲಿ ಮಿಸ್ಟೇಕ್, ಚಾರ್ಜೇ ತಪ್ಪು
ಎಲ್ಲ ಆಗ್ಲಿ.
That is deposit before this court,
ಅಷ್ಟೇ.
not to be dispersed.
Not to be dispersed to the state.
That will see.
As
will
as
answer.
far as I am concerned, I am not liable to pay any fine at all. Because of the reason, the order passed by the High Court, there is no violation by me. I sold the material, I purchased the material
All
locally,
we will hear the
locally,
matter.
and sold it in local area, please.
ಆಯ್ತು.
SMP and local.
See, by the next date, all of you file your respective synopsis, list of authorities, whatever is to be made. I will fix a date for hearing. Before the end of this year itself, I will fix a date for hearing.
Till
These
such
matters
time
should
the
not
payment
lie,
of,
these
sentence-
matters should not lie for a long time, having suspended sentence and admitted the appeal.
The purpose of not Ashwin Kumar Upadhyay's not judgment.
Since your lordship is going
The
to
very purpose
fix,
not of.
So that is why I will fix a date.
since my lord is going to fix a date for final disposal,
Yes.
till such time, my lord, the sentence of payment of fine also could be suspended
That
because
I-
your lordship is going to dispose it of in another few days to come.
We'll see. That
Why should this payment be made?
we'll see. I'll pass orders tomorrow.
Please.
Yes. Because I'll just go through these judgments and.
Best.
Because there are 12 matters.
ಹೌದು, first is still
ಆ
1 to 10.
dictation ಅರ್ಧ ಗಂಟೆ ಆಗುತ್ತೆ ಅದಕ್ಕೆ.
ಹೌದು, your last one. 2035. There was a marriage in the family. I asked for-
Tomorrow we'll do it. ಯಾವತ್ತು ಮ್ಯಾರೇಜ್? Today is the marriage. Or I'll pass orders in the afternoon.
In the afternoon.
Afternoon. I have to see,
DPO.
yes. ಅದು ಮುಕುಲ್ ರೋಹತ್ಗೆ ರಿಪೇರ್ ಆಗಿದೆ ಅದೇ.
That is the matter. He is unwell, so he couldn't come.
ನಮ್
That's all right.
ನಾನು ಇನ್ನೊಂದು ಮೆಡಿಕಲ್ ಲಿವರ್ ಸಿರೋಸಿಸ್ ನಮ್ಮವನಿಗೆ. He is admitted in the hospital.
ಇಲ್ಲ,
ಅವರೇ ಕಳಿಸ್ಬಿಟ್ಟಿದ್ದಾರೆ.
That we will ಮಧ್ಯಾಹ್ನ
ಅಲ್ಲ.
pass ಮಾಡಿ.
The
I'll-
jail authorities
I'll
themselves are sent him to the hospital.
I'll
Liver
pass-
cirrhosis.
Pass orders before the end of the day.
Please.
ಮಧ್ಯಾಹ್ನ just go
Like-
through it. Both ಅದು ಎರಡು second list
List number
ಎರಡು
2, serial number 2. List number 2, serial number 2. There are,
before the end of the day will pass.
please.
Madam.
Respondent number 2 in this case. Madam.
Yes, sir.
For the respondent,
ಹೇಳಿ.
appellant petition, objection, no objection ಸ್ವಾಮಿ ನಮ್ದೇನು.
ಯಾವ್ದಕ್ಕೆ ಅಲೋ ಮಾಡಕ್ಕ?
ಅಲ್ಲ, ಅವ್ರಿಗೆ ಕ್ವಾಶ್ಗೆ ಹಾಕಿದ್ದಾರೆ.
ನೋ ಅಬ್ಜೆಕ್ಷನ್.
No objection.
ಯಾಕೆ?
ಅಲ್ಲ, ನಾವು ಎಜುಕೇಶನ್ ಪರ್ಪಸ್ ಅಬ್ರಾಡ್ಗೆ ಹೋಗ್ತಾ ಇದೀನಿ ಸ್ವಾಮಿ ಹಾಗಾಗಿ.
ನೀವು ಅರ್ಜೆನ್ಸಿಲಿ ಇದ್ದೀರಾ?
ಅಲ್ಲ, ನಾನು ಅಬ್ರಾಡ್ ಎಜುಕೇಶನ್ ಪರ್ಪಸ್ಗೆ ಅಬ್ರಾಡ್ ಹೋಗ್ತಾ ಇದೀನಿ ಸ್ವಾಮಿ.
Consensual relationships.
ಹೌದು.
The petitioner is before this court calling in question Proceedings in CC 20537 of 2023 registered for offenses punishable under section 376, 420, 504 and 506 of the IPC. The heard so and so. The facts in brief, Germain, are as follows. The second respondent is the complainant. The complaint is registered on 24/4/2023, which becomes a crime in crime number 110 of 2023 for the aforequoted offences. The gist of the complaint is that the petitioner and the respondent, petitioner and the second respondent complainant were in a relationship for close to 4 years between 2019 to 2023, and during the said period have also had physical relationship on the pretext of marriage. The petitioner is alleged to have breached the promise of marriage, and therefore the crime has sprung for the offences of rape, cheating, intimidation, inter-alia. The police, after investigation, filed a charge sheet against the petitioner for the aforequoted offences. The filing of the charge sheet is what has driven the petitioner to this court in the subject petition. The learned counsel appearing for the petitioner would, by taking this court through the documents appended to the petition, submit that the acts between the petitioner and the respondent complainant were all consensual for 4 years, albeit it was on a promise of marriage. The marriage did not take place. That would not mean that the offense of rape would spring on consensual acts between the two. He would submit that this court or even the coordinate benches of this court have held that the breach of promise of marriage would not become an offense for punishable under section 420 of the IPC. He would therefore seek quashment of the proceedings. The learned counsel appearing for the second respondent would submit that record ಮಾಡ್ಲಾ ನಿಮ್ಗೆ ಇಂಟ್ರೆಸ್ಟ್ ಇಲ್ಲ ಅಂತ. The learned ಇದು settlement ಬಂದಿತ್ತಾ ಇದು? The learned counsel for the respondent submits that she is not interested in prosecuting the petition on the ground that she has secured employment outside the shores of the nation, and the present petition is becoming present crime is becoming an impediment for her to travel abroad for the purposes of education, and would leave the decision to the hands of the court. The learned HCGP would, however, refute the submissions of the petitioner to contend that the charge sheet has been filed by the police after investigation for offences punishable under section 376 and 420 of the IPC, and therefore there should be no question of quashment of the proceedings. It is for the petitioner to come out clean in a full-blown trial. The learned HCGP would submit that a direction can be given to the concerned court to conclude the trial within a time frame, and the case should not be quashed. I have given my anxious consideration to the submissions made by the respective learned counsel and have perused the material on record. The relationship between the protagonists of the petition is an admitted fact, as the petitioner and the complainant were in love for close to 4 years between 2019 to 2023. During the said 2023, the relationship had blossomed into becoming physical, getting physical as well, and therefore the allegation is that on the pretext of marriage, the petitioner has indulged in sexual activities with the second respondent. The breach of, as observed herein above, the breach of promise of marriage has resulted in the registration of the crime. Since the entire issue has now sprung from the complaint so registered by the petitioner, I deem it appropriate to notice column number 10 of the FIR, which captures the gist of the crime. It reads as follows, page 11. The police, after investigation, have filed a charge sheet. The summary of the charge sheet as obtaining in column number 17 reads as follows. Page 38. Mark Posh. if the charge sheet and if the gist of the complaint and the summary of the charge sheet are read in tandem, what would unmistakably emerge is a relationship between the petitioner and the complainant for over 4 years, and all acts during the set period of such relationship being consensual cannot be dubbed to become an offense of rape or an offense of cheating only because the marriage did not only because the talks for marriage did not fructify into a marriage. The issue need not detain this court for long or delve deep into the matter. The apex court in the judgment 2023 SEC online SC page 89, Naim Ahmad versus so and so, considering the very aspect as held as follows. The same is reiterated by the apex court in its latest judgment in the case of Lalu Yadav versus so and so, 2024 SEC online SC 2287. ಅದರಲ್ಲಿ ಪ್ಯಾರಾಗ್ರಾಫ್ಸ್ ಹೇಳ್ಕೊಳ್ಳಿ, ಬೇಕಿತ್ತು ನೆನ್ನೆ ಒಂದು ಕೊಟ್ಟಿದ್ದೇನೆ. So the apex court answers the offense of rape and consensual acts in the aforesaid judgments and holds that all acts on consensus for over a certain period of time cannot become an offense of rape. Insofar as the offense of cheating is concerned, as obtaining under section 420 of the IPC, the apex court in the aforesaid judgment, i.e. in the case of Naim Ahmad, considers this very aspect and holds that breach of promise of marriage would also not amount to cheating. In the light of the elucidation by the apex court in the aforesaid judgments and the facts being unequivocal as narrated herein above, the petition deserves to succeed, failing which it would result in miscarriage of justice and it would become an abuse of the process of the law and result in miscarriage of justice. For the aforesaid reasons, allowed cost.
Petitioners come. What we've done is, there were multiple synopses and we just put everything together in one place. Essentially, there are only two things of your lordships. Sorry for the inconvenience. Lordships are unwell.
No, you're unwell. All right, yes.
I'll just try to keep it as simple as possible. If lordships.
No, that's all right. My illness should not render you case becoming.
No, it's not fair, my lord, that we keep imposing on your lordships.
Tell me, yes.
But we have done two things. One is there is a synopsis filed on
Now, what is the problem in the case? You tell me.
I'm sorry, my lord.
The gist of the
Yes,
problem.
I'll just take. The petitioners before your lordships are in 2 or 3 categories. Most of them were investors. Some of them were not even directors. What would happen is that the complainant starts first a partnership, thereafter a company. He says that he will develop a certain product, which is in biomedical, my lord, the field of diabetes control something, and induces us to invest. Investments are made. Thereafter, it is seen that he has not done anything. He instead starts another company and does this COVID relief some work. So therefore, we said we want our money back. At that point, he said, look, you keep the company. He exits the company by transferring shares, as also, my lord, by executing an asset purchase agreement because of assets that the company procured. Upon this, what he would first do is, perhaps somebody told him or whatever it so may be, he, my lord, goes and files a civil suit saying that the asset purchase agreement that he has executed is not binding, it is null and void. That suit, my lord, is filed in Anekal and he obtains an interim order. Against that interim order, we prefer a writ petition under 227 before this honorable court. This honorable court would render a finding in that interim order saying that it appears that even on a reading of the cause of action paragraph, his only remedy would be for recovery of money. This is the gist of what the order.
Justice Shyam Prasad.
Well, absolutely, my lord, I'm so grateful. Yes. Now, my lord, basis that order of my lord Justice Shyam Prasad, that interim order gets stayed. Now, after that, he does the following. He approaches the NCLT asking for cancellation of shares in a combined petition under 59 for change of the register of members, as well as 241, 242 for operation mismanagement. He thereafter withdraws that with liberty to file a fresh petition. Till date, nothing has been filed. He also brings into force Section 9 of the Arbitration Conciliation Act by filing 3 petitions, one by himself and one through his wife and another associate. All 3 are eventually dismissed. Now, after the filing of these civil proceedings and after the initial setback, what happens is
that he files, my lord, the first of the criminal proceedings. That is stayed by taking note of, as your lordships indicated, Justice Shyamprasad's interim order, my lord, in the writ petition that we had preferred. After that, suppressing that, he files a second complaint, suppressing the fact that there is a stay order on the first complaint. That is taken note of by this court in the second quashment petition and in the second interim order granted in the series of petitions that are filed. Thereafter, my lord, in every successive petition, he would disclose everything, but all of these facts lead back to the very same root cause, except one case where there is a alleged allegation of somebody having called him and abused him. Even there, insofar as the petitioners whom Lord Mr. Sanjay Krishna is appearing for and consequently I am appearing for, there is no direct allegation against them. The only allegation is that the person who made the phone call and abused him were informed by these three persons about these proceedings, about these transactions. That is what he would say. So therefore, there is no direct allegation against the three persons, my lord, even in that case. Every other case goes back to the very same set of facts. According to him, he has to get some money. According to him, he has to get the shares back. According to him, he has to get the assets back.
And now I'm holding criminal petition 4522 of 24.
Please, yes.
Where is the complaint in this?
May I just make one request to the court master? If the court master could supply a synopsis filed in criminal petition 1869 of 22, dated 8th November.
Captures every case?
It captures, my lord, everything. And in addition to that, in that same petition, I've also filed a list of dates on 11th November. If your lordship sees these two, it captures everything. The list of dates is the chronological.
I just want to see the complaint.
Yes, of course. May I just show your lordships the first of the
complaint is identical in all the cases?
They are not identical. But by and large, they go back to the same facts.
That's why. Now
that's what I'll point that out.
4522 of 24.
Please, I will just first take.
Now, where is the complaint here?
Yes, I'm pointing that.
Is it a private complaint?
May I just, would your lordships permit me to take your lordships in the sequence of the complaints filed? Would that make it easier for your lordship?
So one complaint you should,
I'll just show
then I'll permit you to do.
I will most certainly, my lord. I'm sorry, is your lordship holding the criminal petition, my lord, or the synopsis?
Criminal petition 4522 of 24.
Okay. Page 33 in that. Please be kind enough to take page 33. I'm very grateful.
So it's a private complaint.
It is filed as a private complaint.
Referred
In this,
for
please be
investigation.
kind enough to come to paragraph C at page 35, at the bottom of the page. This again goes back to his he says he was forced to leave the company. I can show your lordship there is a finding by the Section 9 court saying it cannot be said to be a forced resignation. It was voluntary. But why I'm pointing out to paragraph C is, again, it goes back to the same facts. Thereafter, may I draw your lordship's attention to, very quickly, if I may take.
No, you said it's recovery of money, but
Yes,
where is it?
My lord, yes. Please look at, for a minute, insofar as this complaint, my lord, please look at all the previous cases are narrated. Please come to page 47, paragraph 35. And paragraph 34, the paragraph before that.
All right.
In fact, in the second of the complaints filed, this is not, my lord, the second, this is, I think, the fifth of the complaints. In the second of the complaints, he categorically says he has been cheated of 24 crores. It is this same money, my lord, that is being referred to.
All right. Now come to your synopsis.
Please, my lord. May I draw your lordship's attention to the synopsis tendered to your lordship in criminal petition 1869 of 22 on 8/11/24 and a synopsis and a list of dates filed on 11/11/24. There are two. Lordships take the two in pattern.
I'm having 11/11/24 synopsis.
Yes, synopsis and list of dates. That is just a chronological narration of facts. Also, there is a bundle with all the documents, my lord, in one place. That is filed on 8/11.
That's filed on
8/11. This is termed as synopsis of submissions.
This is the entire thing.
Yes,
all right.
Everything is available in this.
Right.
Please permit me to show your lordship, my lord, the chronological list of dates. I don't trouble your lordships with for now.
Yes.
Please take the synopsis, my lord. I'll just tell your lordships what we have done so that it's easier for your lordships. Please be
What
kind
is
enough
this?
to see.
Proof of service, is it? What's happened?
Yes, my lord, sorry.
ಇದು ಯಾಕೆ ಹಾಕಿದ್ರಿ ಇದು?
I'm sorry, I did not realize it's filed, my lord, I'm sorry.
Yes.
I'm-
Your WhatsApp chats. Where is the necessity to file this?
But I'm
Yes.
told without that registry doesn't accept. I'm sorry, my lord. That WhatsApp should not have been filed. I'm sorry.
Alright.
Email perhaps, but not WhatsApp. I'm
Yes,
sorry.
yes, thanks.
Sorry. Lord, please look at index, of course, just narrates what each of the documents are, and more or less it's in chronological order. Please come to page 1, my lord. I'll just tell your lordships how it has been classified, so it's easy for your lordships to appreciate. Please look at synopsis of submissions made on behalf of the petitioners, your lordships have, my lord. First is, under the category, reference to civil disputes pending on the same cause of action with respect to which criminal proceedings under challenge have been initiated. All of these proceedings were prior in time to the first of the criminal complaints. That is 13/8/21, a suit is filed. Then on page 3, 13/9/21, a civil, this company petition is filed in the NCLT. Page 4, 9/11/21, the first of the section 9 petitions is filed.
All by the same complainant?
No. Item 4, your lordship should see, the second is filed by his wife. Second section 9 petition is filed by wife. Third one is filed by his close associate.
So it is wife?
In fact, he is the
husband?
GPA holder of, my lord, this gentleman, Mr.
Your lordship,
Karnataka.
there are 3 complaints in this case. One is me, my
There are
wife.
3 complaints.
Yes, all the 3 of them are the ones who are the complainants, my lord. All of those details are also placed. Now, please be kind enough to come to page 6, item 6. A second company petition is filed by the petitioner acting as power of attorney holder for this gentleman, Mr. Kanabiran. Be that as it may.
And what have, or all proceedings are pending?
No, Lord, section 9, all 3 are dismissed. Those orders are placed before your lordships in this bundle. NCLT permitted to withdraw with liberty to file afresh. Till date, we have no notice of a fresh petition being filed. Suit that he files at the beginning, which, my lord, I pointed out, Justice
Recovery of
Ramprasad,
money.
plaintiff is returned, and to our knowledge, no new suit has been represented, or rather, the suit has not been represented.
Now, crime is registered after all those proceedings or during those proceedings?
My lord, after the suit, after the NCLT, and after the section 9 is the first of the complaints filed. Please be kind enough to come.
No, after filing or after dismissal?
After filing, not dismissal. I must.
So during the pendency of the complaint,
Yes,
those
yes,
section 9 are dismissed?
yes.
NCLT has permitted him to
Yes,
withdraw?
withdraw. Plaint is now returned. Plaint
Returned.
return order is in 2023.
All right.
Please be kind enough to come to page 7, my lord. The second category of documents and information placed for your lordship's kind consideration.
Page?
Page 7 of this synopsis compilation, my lord,
This
of the documents. Yes. So,
Page 7.
yes. Reference to the criminal proceedings initiated during the above civil proceedings. That makes it clear, my lord, to your lordship. All of the criminal proceedings are indicated. I must point out to your lordship, thereafter, page 11, there are further complaints that we have found some information about online, not served notice on us yet. Page 11, your lordship should see, these are complaints that he continues to file even after your lordships have not been hearing the matter. At the list at page 11, your lordship should see reference to other criminal proceedings which are not subject matter of the present criminal proceedings. These are all items 1 to 4, notice is not served on us. I am told in item 5, a notice was issued by the police, which we have answered. I must also draw your lordship's kind attention to one other relevant fact according to us, my lord. Please be kind enough to look at point D at page 12.
Yes.
This is a complaint that we had also filed against him in 2021. Police would close this by saying, look, it's a civil dispute. A complaint I give is a civil dispute, a complaint he gives, my lord, is entertained. Thereafter, my lord, a suit is also filed by us. That suit is still pending adjudication before. And I think the section 11 petitions for appointment of arbitrators are filed by him and are still pending consideration.
Yes.
I'm sorry, my lord. There's one other fact I must bring to the court's notice. Idalva, my lord, please be kind enough to come back to page 11, my lord. I can just show your lordship that order alone. What he would do is, in the section 9 petition, after
page 11
of the, my lord, yes, this compilation, item 4, 6/1/24, your lordships have that entry.
Yes.
he would file a petition under section 340. Application under 340 in the section 9 code, commercial code,
Why? Perjury?
alleging perjury. A similar application was already dismissed. He suppresses that and files a second one that is also dismissed.
Alright.
That is, my lord, these are the
Now, what is the grievance of the complainant?
grievance of the
Multiple proceedings,
complainant.
all right.
I'll just tell you what it is. Grievance of the complainant is, he has been told, these are all investors who have lot of money. You file these cases, many of them live in the US, they have businesses here, they will come and pay you lots of money, don't worry. Is what
I'm asking what is his grievance?
his grievance is only this, that
You're telling his purport.
I'm sorry.
I'm not asking of the purport of.
We are just I'm getting 3, 4, 7, and 8. Grievances are 4, 4. He says he was forced to resign as director. 1.
Director of what? All of you were
We're directors of same company.
company.
Biomedics.
All right.
He says 1 grievances, he was forced to resign as a director. Second, he says his shares were transferred at less than market value.
All right.
Second grievance. Third is, he said that subsequently he said that there's a threat to his life by some of the other directors.
All right.
Then finally, my lord, he also says that he says, my lord, undervaluation of shares, threat to his life, resignation as director. And he said there is a violation of the asset purchase agreement, some assets which are owned by him in a partnership concern.
All right.
He says the company is using. Each
That's-
of these points have been addressed by the civil court, the arbitrator, and the question so far as the valuation of shares has already been referred to the arbitrator.
But I must also add one more point that he has raised at a subsequent, not in the first or second or third complaint, in the fourth complaint, I'm sorry, he raises, he says that there is a forgery that has been done.
Yeah.
Really troubling a lot.
No, that's all right.
Fourth complaint that he files, he says that there is a forgery of his signature in the share transfer. Frankly, it cannot be done for the reason that under the company rules, there is no occasion for me to forge a share transfer form like that. Be that as it may, my lord, that is now an addition to the list of grievances. The last of the grievances is, like I said, there is a phone call abusing him, but that abuse is not directed insofar as the complaint is not directed insofar as the petitioners. The grievance is X calls him, one Mr. Murali Krishna, somebody
No.
calls him
I will hear him now.
at the instance of.
Yes,
So,
sir.
Yeah, just one situation. 17/8/2022, the first PCR against me. The suit is 13/8/2021. The company petition is 13/9/21. The first arbitration application is 9/11/21, 17/11/21, 27/1/22.
All right, let him finish.
Much prior.
Now, don't disturb him. Yes, sir.
Lordship, firstly, I would like to correct our learned friend. Commercial arbitration application, it was dismissed and we have challenged at this High Court and the concurrent bench issued notice to all of the respondents
All right.
on last Friday.
No problem.
And return of plaint, that is also, a writ petition is filed in this High Court and in that case also, notice is issued to all of the petition. Now,
Return of plaint, CRP is filed.
Huh?
CRP is filed.
yes.
All right.
Your Lordship, now, after summing up all these arguments,
Ah.
3 questions that arises before this honorable court is
Yes.
whether the dispute is civil in nature. When did the criminal motion enter to this dispute?
Ah.
And whether we file multiple criminal proceedings based on same cause of action.
All right.
Your Lordship, before coming to this, I would like to kindly come to my synopsis filed on 18th September.
In which petition, sir?
I have filed in common
In common?
synopsis,
Case number is it?
1869.
1869 ಅಲ್ಲ?
Ah.
All right. 1869 ನೋಡಿ.
18th September.
ಇದರಲ್ಲಿದ್ಯಾ? ಇದು ಇವ್ರದ್ದಿಲ್ಲ ಶ್ರೀಕಾಂತ್. ವಕಾಲತ್. ನೋಡಿ.
Your Lordship, in this, I request you to kindly come to page number 31.
ಸಿನಾಪ್ಸಿಸ್ ಇದೆಯಾ? One minute, it's not.
18th September.
18 September 23, 24, sorry. Yes.
18 September 24.
Yeah, it's here.
Page number 31, Your Lordship. First, I will address this question. When did the criminal motion enter to this dispute? Page number 31.
What entered what?
Lordship,
When did crime enter into
when
civil?
did the criminal motion enter to this
Criminal
dispute?
motion enter the civil
Yes,
motion.
they are telling we have given criminal color to a civil dispute.
All
That
right.
needs to be answered, Your Lordship.
Yes, sir, please.
Your Lordship, I request you to kindly come to page number 31. In that, Your Lordship, a list of events. I have given list of events.
Yes, sir.
27 March 2021, Your Lordship. This
Yes.
was the time when the dispute arose between me and the petitioners, where one of the accused, he circulated the circular resolution for board members to give our assent. On the very next day, Your Lordship, I told, no, I can't sign this term sheet because there was so many irregularities going on in the company. Since you're not addressing that, I'm not going to sign this. Later, Your Lordship, on 10/5, sorry, 9/4, in page number 33, Your Lordship. Page number 33, 9/4.
Yes.
I was asked to attend a informal meeting. There, Your Lordship, when I attended that informal meeting, I was asked, return the investors' money. Why should I return the investors' money? You have invested that through buying shares. If you want, sell the shares and go out of the company. Further, Your Lordship, on 10/5, Your Lordship, page number 34. One of the complainant by name Amuda, she resigned from Biofi, which is undisputed fact. But why she resigned? Because of the toxic environment created in the company. Since the sexual harassment of women was not addressed. Yes, so many women employees were sexually harassed by one of the accused. That was not addressed by the directors.
Who has complained?
I raised by name Dr. Amuda.
No. She did not complain.
No, it complained to board of directors.
No. You said many women were sexually harassed.
Yes.
Did those women complain? Where?
Those women complained to me.
Oh, to you?
To me, because I was one of the board of director. Since
What action you took? Resigned?
I raised my voice against that, but no action was taken against that person. So I resigned.
Where is the document to show that you raised this concern also to them?
Your Lordship, that document is not there, but I will produce that. I will produce the document. It is very much there.
Ultimately, you wanted to raise your voice in.
I documented that. I will produce. On 8/6, Your Lordship, in page number 34, I received a mail from one Sriram Vellur, who is an employee, to attend by sending a mail on 8/4, Your Lordship. So 8/6, in page number 34, it is there.
Yes.
Sriram Vellur, he sent me a mail, the minutes of meeting. In that minutes of meeting, it said that, yes, you resign immediately or purchase all the investors. Why should I resign immediately if I'm unable to purchase the investors? Because prior to that, I sold my shares and gave debt to these people to develop the company.
Where is the criminality?
Lordship?
Criminality.
It will come. It will come. In the same page, 8/6/2021, the same page. Your Lordship, I received one more mail to attend a meeting at one of the petitioner's house by name Mr. Ravi Girimachi. There I went. It was also an informal meeting. There I was told, if you don't resign, later don't regret because you're having family. And if any trouble happens to them, we are not responsible. And if one of the petitioner is having link with underworld, one of the petitioner, he will definitely take care of you. So on that day itself, Your Lordship, I went and gave complaint at Sarjapura police station, a oral complaint. It was not accepted.
Where is the copy of the complaint?
It was not accepted. It was an oral complaint. Oral complaint. I will come to that also.
Where is oral complaint? I have not heard.
Oral complaint. It was an oral complaint. They told Sahib Rulla, ಮಾರನೇ ದಿನ ಬನ್ನಿ.
So
Okay, next
orally
year.
rejected.
Yes,
All right. Oral versus oral.
yes, it was not good. On 9/6, by that time in midnight, I received so many threatening calls by them. So again, the next day I went to police station. They told, come with a lawyer and a written complaint.
Which police station will tell that?
It was
Lawyer ಜೊತೆ ಬನ್ನಿ ಅಂತ ಅವ್ರು ಯಾಕೆ
ಹೌದು,
ಯಾವತ್ತೂ
ಹೌದು.
ಹೇಳಲ್ಲ.
in
ಮತ್ತೆ
Prajaapura
ಕಂಪ್ಲೇಂಟ್
police
ರಿಜಿಸ್ಟರ್ ಆಗಲ್ಲ ಅಂತ
ಇಲ್ಲ, I will address that in
Lawyer
further.
ಬರ್ಬೇಡಿ ಅಂತ ಹೇಳ್ತಾರೆ ಅಷ್ಟೇ.
Sir,
ಲಾಯರ್ ಕರ್ಕೊಂಡ್ ಬರ್ಬೇಡಿ ಅಂತ ಗೊತ್ತು,
ಇಲ್ಲ.
ಕರ್ಕೊಂಡ್ ಬನ್ನಿ ಅಂತ.
I will address that also. It is there. In a written document, it is there.
Yes.
The written document, it's there. I will address that also. On 9/6, since I was threatened by them, since I was induced in fear, I sent my resignation. And on the same day, your lordship, they sent me a blank SH4 forms, and I was again induced in fear to put signature to that blank SH4 forms. Further, your lordship,
Where have you questioned that induced resignation before which fora? Before which fora have you questioned that induced resignation? Have you questioned that at any time other than crime?
exactly.
Eh?
I question.
Where?
Before DYSP office on 29/6.
ಅದಲ್ಲ ಸರ್, you forcibly resignation ತಗೊಂಡ್ರು ಅಂತ ಹೇಳಿದ್ರಿ. You understand Kannada?
Yes, yes. ಅರ್ಥ ಆಗುತ್ತೆ.
Your main argument is that forcibly resignation ತಗೊಂಡಿದ್ದಾರೆ. If resignation has been taken out of inducement, where have you questioned that action of taking the resignation out of inducement other than registering the crime?
In this arbitration application.
Which is that? That's pending, dismissed.
Dismissed. It was, they told to withdraw that complaint, withdraw that application.
Hello,
by
whatever it
giving
is, it is now
disposed,
dismissed.
disposed.
All right.
Disposed.
Now carry on.
Your lordship, on 29/6/21. Page number 36. Page number 36, 29/6/21.
Yes.
I visited DYSP office stating, see, my complaints are not been accepted.
Okay.
I gave a written complaint. That written complaint can be seen from page number 89.
All right.
Have produced that written complaint. Further, your lordship, my complaint was not accepted, but immediately the next day, 36, one of their employees went and lodged complaint against me at the same police station, and a NCR is also registered regarding this. And the police officials told, yes, you people compromise the matter instead of taking any cognizance. But that compromise did not come at all. It is secondary.
So if you go on registering crimes after crimes, who will come forward for settlement?
I'm not, this is just a third complaint.
Just third.
Third, because 2 complaint, it is not at all accepted. And this is the first time they have come at police station. First time we have met face to face at police station.
You made them come to the police station.
For compromise, your lordship.
For compromise.
Compromise.
Yes. Police stations have become that these days. Yes.
ಅದಕ್ಕೆ ಲಾಯರ್ ಕರ್ಕೊಂಡು
Oh, compromise.
Your lordship, on 30th June, they issued NCR. Later, after that, your lordship, on 3rd August, I received an email from one of the petitioners stating that he is going to sell all my assets. So, in order to protect those
So
assets.
here criminality steps in.
Yes, this all criminality.
This is
steps.
where you bring in 384.
Yes.
All right.
After this, when they sent me mail that they will sell all the assets, I went and filed first OS at Anekal Court and obtained injunction order. Temporary
What happened to that? Still pending?
No,
That
it
plaint
got
returned.
returned. The plaint got
For what?
returned.
Want of jurisdiction?
Yes, it got returned and we have challenged it at this High Court, and it is pending still. Your lordship, once I obtained this interim order, before that, obtaining that interim order itself, they already made a sale negotiation with a person. And they received an advance check also, advance check of 12.5 lakh rupees.
Crores.
12.5 lakh.
Lakh.
Lakh. Another Valakshastra. For this, they received an advanced check also. By keeping their check in hand, your lordship, they appeared before this Honorable High Court and they filed writ petition and they gave undertaking by saying that they won't intend to remove any assets
All right.
and obtain interim order.
Justice Shyam Prasad.
Please. Yes.
All right.
Yes, that one. They obtained interim order. And there also, they misled this honorable court and they made your lordship to make a error in the interim order. I will come to that also. I will definitely come to that. I will justify my words, your lordship.
Please.
Your lordship, on 13/9/21.
You are going back 22 lidri. Why do you go back 21?
No, it is after filing my first civil suit, after filing this writ petition and all.
All right.
On 30/8/2021, they filed first civil suit against me for declaratory suit, that is. Later, your lordship, on 13/9/21, this is very important date because they registered FIR against me.
Important date.
Yes. They registered FIR against me, not me. I didn't register the first FIR against them. They registered FIR against me. Until now,
13/9/21.
Yes, 13/9/21 in page number 38 it is.
Yes.
They registered FIR against me on the same subject matter as in OS number 2.
What happened to that?
It was filed, B report was filed by police.
That has become final.
No, they have challenged it. They have challenged that B report.
What was the allegation against you in that?
Your lordship, the same.
Same.
What they have filed in OS number 2 for declaratory suit, that they have filed again. They have they gave a criminal touch to that and filed FIR against me. That became resulting in filing B report. Further, your lordship, on 9/12/21, your lordship, they filed one more FIR against me and my father.
All right.
9/12/21 in page number 40.
Yes.
Page number 40, 9/12/21.
Yes, sir.
They filed second FIR against me. Your lordship, they filed FIR by stating that we questioned the modesty of a woman of their company.
Questioned?
Yeah.
What questioned?
Means the modesty of that woman
All right.
is harmed.
Yes.
That's what. Your lordship, finally, that was also withdrawn because on that day, me and my father were 540 kilometers away from this place. When we submitted that, they withdrawn that. Your lordship, then comes my first FIR, which was registered. That is on 3/1/22, your lordship.
All right.
In page number 41, it is there, 3/1/22. So here it ends that before filing any civil suit, I already approached police station and my complaints were not accepted. Even I approached DYSP also, hierarchy also. My complaints were not accepted. So after filing all these civil suits, I was successful after 6 months to register one FIR. That purpose was, my first purpose was copyright infringement.
63.
Section 63.
All right.
Yes. How does copyright infringement becomes a civil dispute? Your lordship, kindly come to page number 20 in that only. Page number 20, your lordship.
Yes. You should speed up.
Yeah. I'm very sorry, your lordship.
Yeah.
Your lordship, my products, my patents, this trademark, this product, everything, it is manufactured by me, designed by me, and I'm having copyright. But what they have done, Biofi, their respondent company, copyright infringement happened. So first FIR was filed, and in that, your lordship, they brought the interim order of writ petition. Now I will come to the interim order your lordship passed in that, because to say that error. Your lordship, in fifth paragraph, your lordship, I would like to read. In the light of the order passed by this court in WP number so and so, which clearly directs the claim of the complainant is a claim for money.
Yes.
A money claim is now sought to be given a color of crime by the present proceedings. Your lordship, this was never said by Justice Shyam Prasad in their interim order. This was their submission, because I would like to read that interim order also.
Where is the interim order? Page?
Your
Which
Lordship,
page is the interim order?
your interim order in 1869.
Justice Shyam Prasad or interim order? Yes, ಯಾವ page ಅಲ್ಲಿ ಇದೆ?
In my comparison. Page 59 of my comparison. I'm sorry, 59 is the final order, the one before. Page 53 in the shuru agate, 55 is where
Final
the
order ಏನಾಯ್ತು ಅದು?
final order, my lord,
Without deciding anything on merits, it was remanded back to the
was
trial court.
direction to the trial court to decide all applications without expressing any opinion on that.
All
55
right,
the order.
so that interim order merges with this.
And this interim order, it clearly says, first, heard Shri Aditya Soni, learned senior counsel, so and so appearing for this, has granted interim order ex parte injunction restraining the petitioner at the instance, so and so. The civil court is persuaded to grant interim order as aforesaid only because the asset purchase agreement with the first petitioner, which is binding and acted upon, is described as a non-binding nominal agreement. The interim order is despite the plaintiff's assertion demonstrating that these respondents are not in possession of subject
That's all right.
premise.
What's your submission now?
Your Lordship, this is not,
Advocates waiting. Yes.
you are not, Your Lordship, the recordings of the judge. This is the submissions of the petitioner counsel made.
Yeah, petition itself is disposed now.
Yes, it is
So
disposed.
don't worry about it.
But based on this, Your Lordship,
These interim orders are taken.
yes, interim order is taken. Your Lordship, the last question, whether we.
But you
fight-
must know that submissions are not denied or declined to be accepted.
yes,
Interim
yes,
order
yes,
is
yes.
granted.
But before that, they did not approach this court with bona fide intention. By having a check in hand, they approached this court. That is the reason. Now they are facing a triple C, civil
Triple
contempt
C?
petition, civil contempt petition.
What is
They
the
are
triple
facing
C?
Civil contempt petition.
Civil
I
contempt.
beg
say
your
what?
pardon for that.
Triple C. Yes.
Your Lordship, so coming back to this page number 20, Your Lordship, the first FIR, it was lodged because of copyright infringement. And they filed criminal petition 1869 by A1, A2, A3. The second crime, Your Lordship, it is 103 of 2022.
Yes.
In this criminal petition 5357 and the criminal petition 5842 is filed. This was because they threatened me and my family and induced fear to give the resignation. So the next is, Your Lordship, CC number 32678. This was challenged through criminal petition 1734, criminal petition 2084, criminal petition 7407. Your Lordship.
So same interim orders repeated in every case.
Yes, exactly. I'm saying not on one cause of action, we have filed all these things. Each and every case is having different cause of action. One is copyright infringement, one is criminal conspiracy and inducing in fear. Other one is fraud, the forgery. Other one is fraudulent transfer of my shares. There are different cause of action, Your Lordship. And it's not about one complaint, Your Lordship, it is 3 complaints. One more thing is 100 employees lost their job because of the conduct of these petitioners, Your Lordship.
Employees have complained?
No,
Women employees have complained of sexual harassment?
no. My lord, what happened was that those complaints, there was the complaint that my lord refers to was withdrawn because the complaint appears to be that the complainant and his father. That is
clarification.
resolved. That is resolved between them.
We'll post
Your
it on
Lordship,
20
just one
23rd.
submission. Just one submission. I would like to read this one order.
What order is that?
One
Interim
judgment
order.
of Rajasthan High Court.
Oh, good.
Excellent.
You're a left-hander. Yes, give it. Yes, sir.
Your Lordship, page number 5, para number 8. Page number 5, para number 8. The parameters of governing the exercise of jurisdiction. bestowed upon-
482.
Yes.
I'm aware. I thought you were telling me something.
No, because there's one allegation made by them that this is a civil dispute and not a criminal dispute. Well, pertaining to that, Your Lordship, this judgment is very much required.
Why Rajasthan, sir? I have myself written, Supreme Court has written.
Very much. Very much.
Why do you want to go to Rajasthan?
Very much so.
Season is good now, but
Smog ಇನ್ನಲ್ಲಿ
smog.
ಅಲ್ಲಿ ಇಲ್ಲಿಲ್ಲ ಇಲ್ಲಿ ಕ್ಲಿಯರ್ ಇದೆ
All right. Legal smog and illa.
ಇಲ್ಲ ಇಲ್ಲ
We'll post it on 23rd. It's a working Saturday. I'll
Please.
dictate on that.
Can I just take
For the hearing.
less than 1 minute for my just 3 submissions to clarify.
Yes.
Point number 1, He says that we gave a complaint against him. There was only one reason. He resigns on 9/6/21 and thereafter executes assignment deeds assigning the property of the company, which is the reason our complaint was given. Anyway, that is closed. Second, as far as we know, the section 9 orders have not been challenged. Notice has been ordered in the section 11 petition and not in the appeal. At least anyway, we have not received notice. Third is that the criminal contempt petition that my learned friend referred to, which I pointed out is dismissed, was filed on 19/6 after my lord this court.
That is dismissed.
That is also.
No, civil C is not.
I'm sorry,
Contempt-
criminal
civil
contempt. I stand corrected.
Criminal
Criminal
contempt.
contempt is filed. Sorry, civil contempt is filed. Criminal miscellaneous is dismissed, my lord, on the ground of having already been dismissed by the court.
That was a perjury application, your lordship. And just one
Three-
thing I
That
would
is
like.
340 application.
Let's 3/4.
I would like to add one important thing. They told about asset purchase agreement. It is binding, but asset purchase agreement is not binding because the one common basic principle every one of us learn is that an agreement must be made between two competent parties. Your lordship, that asset purchase agreement happened on 1/1/2020 between me and one of the managing director who is standing as petitioner. But your lordship, that petitioner on that date was not at all managing director. He got appointed as a managing director on 16th August 2020. So he was not a competent party and it is
We'll
not
see.
also stamped also.
That is a
It was
subject matter of a
unstamped agreement.
suit and that plaint has been returned anyway, my lord. Let it.
We'll see. Now,
Dr.
which is the suit pending between you on the same cause of
We have
action?
filed a suit against him.
He has no suit against
No,
you?
that plaint has been returned.
We have challenged that.
Anyway, that we'll see. Yes.
I have not received any notice. Bandak barli ashte. That's all.
ಏನ್ ಮೇಡಮ್ ಏನಂದ್ರೆ
23rd.
yes.
So.
ಏನಿದೆ? ಹಾ, ಮತ್ತೇನಿದೆ ಬೇಕು? ಇದು MPML ಇದೆ ಅದಕ್ಕೆ. Next.
PCP and ET, my lord. I have it next week, my lord.
ಯಾವ್ದು?
PCP and ET.
PCP and DT. ಒಂದು ಕ್ಲೋಸ್ ಮಾಡಿದ್ವಲ್ಲ? She was not.
AP for the petition in the first matter. My lord, the petitioner, my lord, is a radiologist, my lord, working in government hospital.
ಒಂದು ರೇಡಿಯಾಲಜಿಸ್ಟ್ ಕ್ಲೋಸ್ ಮಾಡಿದ್ವಲ್ಲ?
ಹೌದು, because she was pregnant.
Pregnant.
Was not at the spot, my lord. that-
ನೀವು ಇರ್ಬೇಕಾಗಿಲ್ಲ.
ಅಲ್ಲ, ಅದ್ರಲ್ಲಿ
We'll take it next week. Yes. At the request of the learned additional, stay ಇದೆ ಅಲ್ವಾ?
Stay there.
At the request of the learned additional SPP, list the matter on 28th. Interim order subsisting will continue to the next date of hearing.
ಅಲ್ಲ, ನಮ್ಮದ್ರಲ್ಲಿ ಏನು ಇಂಟರ್ ಮಾಡ್ರಿ ಇಲ್ಲ sir.
ಯಾವ್ದ್ರಲ್ಲಿ ಏನ್ ತೊಂದರೆ ಆಗ್ತಾ ಇದೆ ಈಗ?
ಫಸ್ಟ್ ಮ್ಯಾಟರ್ ನಲ್ಲಿ 60.
ಎರಡರಲ್ಲೂ ಇದೆ ಎಂಟ್ರಿ ಮಾಡಿದ್ರು. ಎಂಟ್ರಿ ನಾನೇ ಕೊಟ್ಟಿದ್ದೀನಿ. Yes.
14.
Police report unserved.
This matter is settled between the parties, not.
Settled.
Yes, ma'am.
ಏನು
I think wakalat for
Compromise.
respondent number
498 ಏನ?
376 and not 420 is there, not both are the doctors, not adults. Not so.
ಸೆಟಲ್ಮೆಂಟ್ ಆಗಲ್ಲ, ಕಮನ್ ಮೆರಿಟ್ಸ್ ಅಂತ ಹೇಳಿದ್ರೆ
ಅಲ್ಲ.
ಗೊತ್ತಾಗದೇನು? Both are doctors.
Yes, madam.
So there can't be a settlement. We'll answer it on merits.
But Sivan, not so.
Come on, merits. You want time, I'll give you time.
Yes, madam.
ಓದ್ಕೊಂಬರಕ್ಕೆ. ಸೆಟಲ್ಮೆಂಟ್ ಮಾಡಲ್ಲ 376 420.
Like
ಎಷ್ಟು
that,
ವರ್ಷ
not
ರಿಲೇಶನ್ಶಿಪ್?
Consensual, not the.
ಕನ್ಸೆನ್ಶುವಲ್ ಗೊತ್ತಪ್ಪ.
2.5
376 I
years.
can't settle it.
2.5 years here. Both are living together. 2 years. 6 months.
14/1/21 na?
Yes, madam. 10/5/2021 to 2023.
10/5/2021 ಇಂದ
19/11/2023.
Instagram problem.
ಇಲ್ಲ sir.
Met through Instagram.
Yes. ma'am.
Met through Instagram.
Will not settle it. Why did you get the accused and the complainant here? Settlement ellaಗುತ್ತೆ. Where is the complainant?
Complaint is here.
Complainant is present.
Complaint is
Accused.
here.
Who is the complainant?
Complainant is not one R Devi comment.
That's all.
Respondent number 2. But she is present.
Will not settle it by this way. We'll answer it on merits.
Not of the.
You want time for that? You take.
Yes, madam.
Don't get the parties.
Your honor has passed on orders in 76, madam.
ನಂದೇ ಬೇಕಾದಷ್ಟಿದೆ. ಬೆಳಗ್ಗೆ ಮಾಡಿದ್ನಲ್ಲ ಈಗ. Serial number 2 was that only. 2 na ಏನದ? That also settlement I declined and I passed orders on merits. Friday ಹಾಕ್ತೇನೆ. ಇವತ್ತು ವೆಡ್ನೆಸ್ಡೇ ಅಲ್ಲ?
Only thing is, my lord, in this 323 also involved.
Three?
ಹೊಡೆದಿದ್ದಾರೆ ಮಾಡಿದ್ದಾರೆ ಅಂತ allegation.
323.
Not for that, my lord, there is no material and also no injury certificate.
No doctor
Lords, may I request-
Eyewitness ಎಲ್ಲ ಇದೆ.
Huh?
4 eyewitnesses are there for the incident.
323 ಗೆ. All right, we'll see. 323 proceedings continue ಮಾಡಕ್ಕೆ ಹೇಳ.
ಅಲ್ಲ, ಒಕ್ಕಲ
Register ಹಾಕಿ. List the matter on 19th. No, 19th, the fresh matters day ಅಲ್ಲ? 20th is fresh matters list. Come on, merit sir. ನೀವೇನ್ ಬರಲ್ಲ ಬಿಡಿ.
in the fresh matter.
Fresh matters. ನಂದೇ ಜಡ್ಮೆಂಟ್ ಇದೆ ಮೇಡಮ್ ಎಲ್ಲ.
ಹೌದು ಸ್ವಾಮಿ, I brought it.
ಇವಾಗ ಬೆಳಗ್ಗೆ ಕೊಟ್ಟಿರೋದು ಅಷ್ಟರಲ್ಲಿ ರಿಲೀಸ್ ಮಾಡಿರ್ತೀನಿ.
For the petitioner, my lordship. The respondent number 2 has love marriage with the son of.
Love marriage da.
House.
Love marriage da.
With the son of petitioner number 1 and 2, my lordship. And clearly she has stated in her written complaint, my respectful, page number 21, my lordship.
ಅದು 2621 498.
498. But allegation
husband ಇಲ್ಲ.
Husband ಹಾಕಿಲ್ಲ.
Husband ಇಲ್ಲ. A22, A6. But allegation is on all the accused.
Omnibus.
Omnibus.
ಸ್ಪೆಸಿಫಿಕ್ ಓವರ್ ಟ್ಯಾಕ್ಸ್ ಇದೆಯಾ? ಕೊಡಿ, ಪೇಜ್ ಹೇಳಿ.
Page number 40, my lord.
ಇದ್ಯಾಕೆ ನನ್ನ ಬಂದಿತ್ತ ಮುಂಚೆ?
Column number 17.
Oh, this had come before me. Yes, sir.
Para number 2 ಅಲ್ಲಿ.
Page
40. Column number 17 of the charge sheet.
And the petitioners along with the respondent number 2 were not residing at no point of time.
One minute. ನಿಮ್ ಪೇಜ್ಗೂ ಇಲ್ಲಿಗೂ ತುಂಬಾ ವ್ಯತ್ಯಾಸ ಇರುತ್ತೆ. ನೀವು ಪೇಜ್ ನಂಬರ್ ಸರಿಯಾಗಿ ಹಾಕಲ್ಲ, ಕರೆಕ್ಷನ್ ಮಾಡಿರಲ್ಲ.
Charge sheet
4 ಪೇಜ್ ಇದೆ ಒಂದೊಂದಕ್ಕೆ.
column number 17. Para number 2 onwards, my lord. Para number 2 ಅಲ್ಲಿ last four lines.
A1 ಅವರು 2-3 ಅವರ ಮಾತು ಕೇಳಿ
ಹೌದು.
ಬಡೆ
ಕೈಯಿಂದ
ದಿನನಿತ್ಯ ಫೋನ್ ಕಾಲ್ ಮಾಡಿ 2, 3, 4, 5, 6 couple were residing separately, sir. Husband and wife are residing separately. ಫೋನ್ ಮಾಡಿ ಇನ್ಸ್ಟಿಗೇಟ್ ಮಾಡಿದ್ದಾರೆ ಅಂತ is the allegation. ಹೌದಾ?
ಹೌದು. A2 ರವರು ಸಾಕ್ಷಿ 1ರವರಿಗೆ ಕೈಯಿಂದ ಹೊಡೆದಿತ್ತು. A3 ರವರು ಕಾಲಿನಿಂದ ಹೊಟ್ಟೆಗೆ ಹಾಗೂ ಕಿವಿಗೆ ಹೊಡೆದಿರುತ್ತಾರೆ.
A2 and ಅಲ್ಲ 4, 5, 6.
4, 5, 6. A4 ಮತ್ತು A5 ರವರು ಸಾಕ್ಷಿ 1ರವರ ಕೂದಲನ್ನು ಹಿಡಿದು ಎಳೆದಾಡಿ ಬೆನ್ನಿಗೆ ಬಲವಾಗಿ ಗುದ್ದಿರುತ್ತಾರೆ.
ಭಿನ್ನಾಭಿಪ್ರಾಯ ಉಂಟು ಮಾಡಿ.
ಅದು ಸೆಕೆಂಡ್ ಪ್ಯಾರಾದಲ್ಲಿದೆ ಸರ್. Column number 17 ಅಲ್ಲಿ ಸೆಕೆಂಡ್ ಪ್ಯಾರಾದಲ್ಲಿ ಲಾಸ್ಟ್.
498 is not the only allegation. 342 ಇದೆ.
Yes.
All right. 1 additional SPP, 1 HCGP, 2 emergent notice. List after 4 weeks pendency of this petition will not come in the way of further proceedings against these petitioners before the concerned court.
Stay there. ಅಲ್ಲೇ.
Dismiss ಮಾಡೋ ಕೇಸ್. ಅದಕ್ಕೆ ನನ್ನ ಮುಂದೆ 3ನೇ ಸರಿ ಬಂದಿರೋದು.
Lordship, all the documents have produced by these petitioners, rent agreement, living separately.
No problem. Yes. Next.
16.
Please, your lordship, I am for the petitioner in item number 16. Your lordship, I am.
1 minute. Will not come in the way ಆದ್ಮೇಲೆ. Post the matter for admission in its usual course. Yes.
Your lordship, in item number 16, I am for the petitioner. Your lordship, I am seeking an adjournment. The main counsel is not well. He is suffering from dengue.
List the matter. At the request of the council appearing for the petition, list on 9th December in the fresh matters list. Next.
17.
Wait, your lordship.
ಏನ್ 3 ಮ್ಯಾಟ್ರ್ ಇದು?
This is the Bowie Corporation, madam.
ಕೊಡಿ.
I placed the flow chart of how money has been transferred.
ಎಸ್ ಸರ್, ಹೇಳಿ. ಫ್ಲೋ ಚಾರ್ಟ್ ತಗೊಂಡು ಏನ್ ಮಾಡ್ತೀರಾ ನೀವು? ಮೆರಿಟ್ಸ್ ಮೇಲೆ ಹೇಳಿ. Yes.
Merits ಮೇಲೆ ಅದೇ last time they were permitted to go on with the investigation, file the investigation report before this court.
ಅದಾಗಿದ್ಯಾ?
ಆಗಿದೆ 30ನೇ ತಾರೀಕು. ಎಲ್ಲ ಕೇಸಲ್ಲೂ they were permitted to go on with the investigation.
Investigation is on?
Investigation is going on. They are not supporting the they are not cooperating with investigation.
ಅವ್ರು
They
ಕೇಳೋ
come,
sorry, I'm sorry.
they come with, in fact, my lord, we have videographs. We want a thumb impression to record, to identify. They come with a plaster to the hand.
Why, sir?
And then if you ask any,
Sorry, my lord.
I'll dismiss it straight away if you
I'm
don't
sorry, my
cooperate
lord,
with the
for this
investigation.
submission. ಅವ್ರು ಕೇಳೋ
ಬೇಕಂತ ಪ್ಲಾಸ್ಟರ್ ಹಾಕೊಂಡ್ಬರೋದು ಇವೆಲ್ಲ ಮಾಡೋದ್ ಮಾಡ್ಬೇಡಿ.
ಯಾವ್ದು ಮಾಡಲ್ಲ. ನಾಳೆ ಫಿಕ್ಸ್ ಮಾಡಿ ಸ್ವಾಮಿ, ನಾಳೆಯಿಂದ ಒಂದ್ ವಾರ ವಿಡಿಯೋಗ್ರಾಫ್ ಮಾಡಿ ಸ್ವಾಮಿ, ಒಂದ್ ವಾರ ಡೈಲಿ 11 ಗಂಟೆಯಿಂದ 5 ಗಂಟೆವರೆಗೂ ಅಲ್ಲೇ ಕೂತಿರ್ತೀವಿ.
and if we ask any question,
ಅವ್ರು
they say
ಕೇಳೋ
only ask this crime, don't ask other crime. All crimes are
ಅವ್ರು ಏನ್
interlinked.
ಕೇಳ್ತಾ ಇದಾರೆ, ಹಳೆ ಇನ್ವೆಸ್ಟಿಗೇಷನ್ ಆಫೀಸರ್ಗೆ ಎಷ್ಟು ದುಡ್ಡು ಕೊಟ್ಟಿದ್ದೀರಾ ಅದನ್ನ ಹೇಳಿ. ಹಳೆ ಇನ್ವೆಸ್ಟಿಗೇಷನ್ ಆಫೀಸರ್
ಇಲ್ಲ ಅಂತ ಹೇಳಿ.
ಕೊಟ್ಟಿ ಅದನ್ನ
ಕೊಟ್ಟಿಲ್ಲ ಅಂತ ಹೇಳಿ.
ಕಂಪ್ಲೇಂಟ್ ಕೊಡಿ ಫಸ್ಟ್, ಆಮೇಲೆ ಇನ್ವೆಸ್ಟಿಗೇಷನ್ ಮಾಡ್ತೀವಿ. ಐ ಆಮ್ ಫೈಲಿಂಗ್ ಅಫಿಡವಿಟ್ಸ್ ಟು ದಟ್ ಎಫೆಕ್ಟ್.
No, I'll place the entire,
I have
if you lordship
appeared
want to
before
peruse,
this
my lord, I'll
multiple
place the videos of
Videograph, produce it.
ವಿಡಿಯೋಗ್ರಾಫ್ ಮಾಡಿ ಸ್ವಾಮಿ.
Your
I
lordship see the
hesitate to
demeanor
be-
of the accused before sitting before the IO at the time, as if they are dictating what to investigate, what not to investigate.
Wait.
Let's from 7, 10, 20.
One ನಿಮಿಷ. The learned additional SPP on instructions would submit that the petitioners are not cooperating with the investigation, but on appearing before the investigating officer.
Let's
According to ಅವ್ರು ಹೇಳೋದು ಹೇಳ್ತಾರೆ.
ಅಲ್ಲ ಯಾವತ್ ಅಪಿಯರ್ ಆಗಿದೆ ಅಂತ.
According to the learned additional SPP, the accused, when asked to appear before the investigating officer to seek thumb impression, they would cover the thumb with a plaster on the pretext of some wound, and therefore are not cooperate, and therefore have deliberately covered it with the plaster and not cooperating with the investigation. This has been the modus operandi of the accused, is the allegation of the additional SPP. The learned counsel appearing for the petitioner would seek to file certain affidavit with
From
regard to their
20
appearances before the investigating officer and cooperation with the crime. He would, however, refute the entire submissions made by the learned additional SPP. He would also submit that they would appear before the investigating officer from tomorrow, even for a week on day-to-day basis. Let the investigating officer complete the investigation. In the light of the said submission, ನಾಳೆಯಿಂದ ತಗೊಳ್ಳಿ ಇವ್ರನ್ನ.
ಮೇ ಮೇಕ್ ಎ ರಿಕ್ವೆಸ್ಟ್ ಮಾಡೋದು. ಅವರು ಹಳೆ ಇನ್ವೆಸ್ಟಿಗೇಷನ್ ಆಫೀಸರ್ ಏನ್ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಕೊಟ್ಟಿರೋ ನೀವ್ ಹೋಗಿ ತಗೊಂಬನ್ನಿ ಅಂತಾರೆ. ಹಳೆ ಇನ್ವೆಸ್ಟಿಗೇಷನ್ ಆಫೀಸರ್ ಹತ್ರ ನಾವು ಹೋದ್ರೆ ನಾನೆಲ್ಲ ಇನ್ವೆಸ್ಟಿಗೇಷನ್ ಪೇಪರ್ಸ್ ಅವ್ರಿಗೆ ಕೊಟ್ಬಿಟ್ಟಿದ್ದೀನಿ.
There was an issue with the investigation officer,
I tell
therefore
you.
investigation officer.
Earlier investigating officer hatra you have access or they have access?
No, we are asking the information which they have.
Whatever information you have.
Send it
you
to
will
the old investigation officer, including the original records.
The learned, therefore, the petitioner shall appear before the investigating officer from tomorrow. From tomorrow at the time indicated by the investigating officer.
My lords may fix the time. 11 ಗಂಟೆ. My lords may fix at 11
at 11 a.m. At 11 a.m. and cooperate with the investigation as and when they are asked to appear before the investigating officer.
So should we see, in fact, we have flow chart of when they appear, when they enter into CID office, how many times they come before the investigation officer.
ನಾನು ಅದನ್ನೇ ಕೊಡ್ತಾ ಇದ್ದೀನಿ.
It is open for the prosecution to videograph the investigation and place it before the court on the next date of hearing.
Only in October, my lords, I have appeared 5 days.
ಎಷ್ಟು ದಿನ ಬೇಕು?
ಈ ಪ್ರೀವಿಯಸ್ ಇನ್ವೆಸ್ಟಿಗೇಷನ್ ಆಫೀಸರ್ನ ಅವರೇ ಕರೆಸ್ಬಿಟ್ರೆ ಗೊತ್ತಾಗ್ಬಿಡುತ್ತೆ.
Whenever they appear, they will make them sit for the whole day. They will do nothing. By instruction, my lord, they have not given any original document as they claimed before to the earlier investigation
They will
officer.
give
No
everything.
documents have been given. If they provide all
ಅವರೇ
the
acknowledgement
documents,
ಕೊಟ್ಟಿದ್ದಾರೆ.
let them give that, let them give that.
ಕೊಡಿ ಎಲ್ಲ.
ಇದನ್ನು
ನಾಳೆ
ಅವ್ರಿಗೆ ಕೊಟ್ಟಿದ್ದೀವಿ.
ನಾಳೆಯಿಂದ ಎಲ್ಲ ಕೊಡಿ. And if you want, you videograph.
Yes.
I'll take this on. When do you want?
Next week, my lord.
List the matter on 23rd for further hearing. Sorry. The
Old
proceedings-
investigation officer who has sent
The
out.
proceedings of investigation taken place till the said date be placed before the court on the next date.
In fact, there are some issues with the old investigation officer. Therefore, investigation officer has been
Their
changed.
internal issue, they are
All
making
right,
us
let
suffer, my
but
lords.
I am
They are
not,
bound to.
I am not on
Yes,
that. Whatever cooperation, if they don't cooperate, you tell
Yes.
me, we'll do it. Yes, we'll post it for the hearing.
Plus, investigation officer ಇದು ಸ್ಟೇಟ್ಮೆಂಟ್ ನ ಪ್ಲಸ್ ರೆಕಾರ್ಡ್ಸ್ ಅನ್ನ ತಗೊಂಡು ದಟ್ ಇಸ್ ಡನ್ ಇನ್ ದ ಇಯರ್ August 2023.
ಕೊಡಿ ಅವ್ರಿಗೆ.
ಪೂರ್ತಿ ಒಂದು set ಕೊಟ್ಟು all
set ಕೊಡಿ ಅವ್ರಿಗೆ. If everything is there, don't, you complete the
And
investigation.
2023, my lords, I have appeared 21 times.
The very
From
fact under
2020
investigation matter, they have access to the statement
ಅವರೇ
recorded.
ಕಾಪಿ ಕೊಟ್ಟಿರೋದು ನಾವು
ನಾ-
ಇನ್ವೆಸ್ಟಿಗೇಷನ್
I-
ಆಫೀಸರ್
I-
ಕೇಳಿದೀವಿ
copy
ಕೊಟ್ಟಿದ್ದಾರೆ.
ಕೊಟ್ಟಿರೋದು
That itself is, my lord, shows something else.
Earlier investigating.
Yes.
Earlier investigation.
You've changed the line.
We have already changed.
Yes.
So this itself shows something.
They have some personal
Anyway, we'll-
internal issue, present investigating officer and the old investigating officer. That is the reason why they
Sir,
are,
whatever you do, the truth should come out,
Yes.
Ashta, that is all.
Yes.
Do it.
we are supporting for every cause, my lords. ಅಲ್ಲಿ ಅವ್ರ ಪರ್ಸನಲ್ ಇಶ್ಯೂಗೆ ನಮ್ಮನ್ನ ಬೆಳಗಿನ ಸಂಜೆವರೆಗೂ ಕಾಯಿಸ್ತಾರೆ. ನಾವು ಬೆಳಗ್ಗೆ 11 ಗಂಟೆಯಿಂದ 5 ಗಂಟೆ.
ಅವ್ರ ವರ್ಷನ ನಮ್ಮ ಸ್ಟೇಟ್ಮೆಂಟ್ ಅಲ್ಲಿ
ಆಮೇಲೆ ನಾವ್ ಯಾವ ಸ್ಟೇಟ್ಮೆಂಟ್ ಕೊಡ್ತೀವಿ ಅವ್ರು ರೆಕಾರ್ಡ್ ಮಾಡಲ್ಲ. ಅವ್ರಿಗೆ ಏನ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ಬೇಕು ಕೊಡ್ಬೇಕು, ತಗೋಬೇಕು.
Videography.
Let's in one of the cases, my lords, in Ramakrishna, the order has not been modified.
ಯಾವ್ದದು?
ಅದ್ರಲ್ಲಿ ಇಂಟ್ರಿಮ್ ಸ್ಟೇ ಹಂಗೆ ಇದೆ ತಾವು ಕೊಟ್ಟಿದ್ದು.
17.2 ಅಲ್ಲಿ ಕೆಜಿ ಬೇರೆದಲ್ಲಿ ಏನ್ ಆರ್ಡರ್ ಇದೆ ಅದನ್ನ ಅಲ್ಲಿಗೆ ಹಾಕ್ಬಿಡಿ.
ಬೇರೆ ಇನ್ನೆರಡರಲ್ಲೂ ಮಾಡಿಫೈ ಆಗಿದೆ ವಿಚ್ ವಿ ಆರ್ ಕೋಆಪರೇಟಿಂಗ್. 17.2 ಅಲ್ಲಿ ಆಗಿದೆ.
ಅದು ಬೇರೆದ್ರಲ್ಲಿ ಆಗಿರೋದು ಸೇಮ್ ಆರ್ಡರ್ ಮಾಡ್ಬಿಡಿ, ಲೆಟ್ ದೆಮ್ ಕೋಆಪರೇಟ್. ಇದು ಈ ಆರ್ಡರ್ನ ಕಾಮನ್ ಆರ್ಡರ್ ಅಂತ ಮಾಡ್ಬಿಡಿ.
18.
Appear for the petitioner, my lord, short accommodation, my lord.
At the request of the council appearing for the petitioner, place the matter on 9th December in the fresh matters list. Yes.
19.
I request your lordship to take the second petition first.
ಏನಿದು?
But it's a 460, 465, 468 and 420.
ನೋಟಿಸ್ ಆಗಿದೆಯಾ?
ಆಗಿದೆ ಅವರು ಅಪಿಯರ್ನು ಆಗಿದ್ದಾರೆ.
ಓ ಸುರೇಶ್ ಪಿ.
But I request your lordship to take 9067. 9067.
90? Yes, I'm holding that.
Connected. But the first petitioner is the second wife.
Saras, yes.
The second petitioner is the the first petitioner's daughter.
All right.
Yes. But the second respondent is the first wife's daughter
All
of
right.
Nagaraj.
All right.
Look, the
Oh, he's now deceased.
yes, now deceased.
Ah.
The allegation in the complaint that are two charges. The ink page number 19.
Gift deed.
Gift deed ಅನ್ನಲ್ಲಿ ಒಂದು ಕೊಟ್ಟಿದ್ದೀರಿ. That is
Gift deed ಯಾರು ಎಕ್ಸಿಕ್ಯೂಟ್ ಮಾಡಿರೋದು?
gift deed in favor of Saraswati
Executed by Nagaraj.
by the deceased Nagaraj. It's a registered gift deed.
All right.
Thereafter, he sells to the accused number 3.
All right. First ಬನ್ನಿ.
Yes.
Gift deed.
Gift deed.
ಆಮೇಲೆ
The second charge is insofar as the Likita, petition number 2 is concerned, that after the death of her father, that she has forged form number 29 in respect of a car, Baleno car, and transferred the car in her name. That is the second allegation against the second petitioner. It is not interlinked between the petitioner number 1 and 2.
ಸೆಕೆಂಡ್ ಪೆಟಿಷನ್ ಏನು?
Second petition of vehicle release. That we filed an application for vehicle release before the trial court. That came to be rejected on the ground that there is a list between the parties. Therefore, I cannot
All right.
order for release of the vehicle.
So these petitions are one by the daughter and one by mother and daughter.
Yes.
All right.
Millet, I have produced the registered gift deed, Millet, ink page number 19.
Now what is the problem?
The problem is, Millet, now even Millet, after the execution of the registered sale deed, they allege that this gift deed
Now,
has been made
accused
by
number,
infusing.
now you two, who are the donees,
Yes.
have sold the property to accused number 3.
Accused number.
When was that done?
That is, I have produced Millet ink page number on 17/3/2022. The gift deed is on 9/12/2019.
3 years later, you sell it.
Yes.
When did he die?
Millet, he died on one. 18/4/2021.
What is the date
At
of?
the
what is
time
the-
of
1 minute, what is the date of gift?
9/12/2019. Before, it is a self-acquired property.
Yes.
Yes. Self-acquired property.
Date ಕೇಳ್ದೆ ಅಷ್ಟೇ.
Yes. That's only the allegation in the complaint and the FIR.
ಸೂಟ್ ಹಾಕಿಲ್ವಾ?
Please,
ಸೂಟ್ ಏನ್ ಹಾಕಿಲ್ಲ.
suit ಹಾಕ್ಲಿಲ್ಲ. ಅವ್ರು suit
ಹೌದು.
ಹಾಕ್ಲಿಲ್ಲ.
ಏನ್ ಅಲಿಗೇಷನ್ ಇದರಲ್ಲಿ?
Kindly turn to page number para 2. 6/7/18 ಬೆಂಗಳೂರಿನ ಸುವರ್ಣ ಶುದ್ಧ ನೋಂದಣಿ ಕ್ರಯಪತ್ರ ಮೂಲಕ ಖರೀದಿ ಮಾಡಿ ಅಲ್ಲಿಂದ ಅವರ ಜೀವಿತದವರೆಗೂ ಮನೆಯಲ್ಲಿ ವಾಸವಾಗಿದ್ದರು. ಮನೆಯ ಖರೀದಿಯ ಸಮಯದಲ್ಲಿ ಒಟ್ಟು ಕುಟುಂಬದ ಆಸ್ತಿ ಪೈಕಿ 2 ಹೆಣ್ಣು ಮಕ್ಕಳಿಗೆ ಮತ್ತೊಂದು ಅಂತಸ್ತು ಮತ್ತು ನನಗೊಂದು ಅಂತಸ್ತು ಅಂತ ಹೇಳಿದ್ದಾರೆ.
ಈಗ ಅವ್ರಿಗೇನ್ ಕೊಟ್ಟಿಲ್ವಾ?
ಅವರಿಗೆ ರಿಲೀಸ್ ಡೀಡ್ ಹ್ಯಾಸ್ ಬಿನ್ ಎಕ್ಸಿಕ್ಯೂಟೆಡ್ ಅಂಡ್ ಕ್ಯಾಶ್ ಹ್ಯಾಸ್ ಬಿನ್ ಗಿವನ್.
Release date executed by whom?
The father in favor of one Mohan Raju. Out of the sale proceeds, they have
Mohan
given.
Raju ಯಾರು?
Mohan Raju is mother's brother, father's brother, his brother.
Who has executed release?
The late father and their family members in favor of their brother.
No. Now this is Uma is the daughter of the first.
According to them, there is
Daughter
no
of the first
property.
wife.
There is no properties given to them. According to
That is what. What is given to them, I am asking.
Yes, is correct. According to them, no property has been given, and we would say that the money in terms of money cash has been given. Even by going to the recitals of the complaint, it is gift deed, self-acquired property.
Allegation is forgery, yeah?
Forgery. Registered document ಮೇಲೆ ಇಂಡ್ಯೂಸ್ ಮಾಡಿ ಬರೆಸ್ಕೊಂಡಿದ್ದಾರೆ ಅಂತ. That is a matter of civil court jurisdiction.
Yes, sir.
My lord, Nagaraj had married Srimati Yashoda Devi in the year
Yashoda Devi.
1987. She is the first wife of Nagaraj.
All right.
Out of the wedlock, there is no issues.
From the wedlock.
ಮಕ್ಕಳಿಲ್ಲ ಫಸ್ಟ್ ವೈಫ್ಗೆ.
ಮತ್ತೆ
Thereafter.
ಉಮಾ ಯಾರು? ಉಮಾ ಯಾರು?
Kuma is the second respondent here, second.
You said no issues from the first wife. Uma yaru?
First wife. Thereafter,
Uma yaru, sir?
second wife daughter. Saraswati P. Saraswati P.
Saraswati P
Is the
has 2 daughters, huh?
yeah.
ಯಾರ್ಯಾರು?
Uma and Leela.
ಲೀಲಾ?
Leela.
ಇಲ್ಲಾರು ಲಿಖಿತ ಅಂತಿದ್ದಾರೆ?
ಅವರು ಬೇರೆ.
No, I produced the document.
There is a dispute.
Aadhaar card, page number 42. ಸುಮ್ಮನೆ ಹೇಳ್ಬಿಡ್ತಾರೆ.
ಈಗ ಎಂಟ್ರಿ ಮಾಡಿದ್ಯಾ?
Interim order, not to precipitate ಅಂತ ಇದೆ. The investigation in so far as
ಪೆಂಡಿಂಗ್ ಇದೆ. ಒಂದರಲ್ಲಿ ಬಂದಿದೆ ಫೋರ್ಜ್ ಅಂತ ಫಸ್ಟ್.
ಯಾವ್ದ್ರಲ್ಲಿ ಬಂದಿದೆ ಫೋರ್ಜ್ ಅಂತ?
vehicle ನಲ್ಲಿ it has been come to light that it has been forged.
Whose signature is forged?
The
Nagaraj
late fathers.
Okay.
Late fathers.
ಇದರಲ್ಲಿ
ಏನು
Pending.
ಬಂದಿಲ್ಲ.
when do you get that FSL?
I'll, in another matter, I'll secure the record. In this,
ಅಲ್ಲ, get the records and everything. The learned HCGP is directed to secure the report of the FSL, or which is the subject matter report of the FSL hyphen the subject matter of both these in the subject matter of both these petitions by the next date of hearing without fail. Yes, list the matter on 28th in the fresh matters list. The interim protection that is granted earlier shall continue till the next date of hearing.
Yes, if it is come to light that the second petitioner done, I will withdraw the petition insofar as because the allegations are different in respect of
True.
mother
ಈಗ
and
ಅದು
daughter.
FSL ಅಲ್ಲೂ ಅದೇ ಬಂದ್ರೆ
ಆಯ್ತು.
ನೋಡು.
ಒನ್ FIR.
ಅಲ್ಲ, ಒಂದು FIR ಅಲ್ಲಿ
In this case, my lord. Last occasion, your lordship directed to produce the wound certificate, but there is no wound certificate produced in the charge sheet, my lord. In the index of the charge sheet, they are not mentioned about the wound certificate, my lord. No such injury is sustained by the
354.
Yes, my lord. Only on the petition number 1 has lodged a complaint against his son and other persons against on 9/12/2022, my lord. With the counter blast the same.
No wound
lodged
certificate
complaint.
at all?
certificate is
ಹಾಗಿದ್ರೆ ಹೋಗ್ತಾ ಇದ್ರು.
323.
323 ಏನಿರಲ್ಲ.
I have secured the records.
In the
The
meantime.
complaint has stated that there are sustained injuries,
Next.
but in the charge sheet, there is no whisper about the
Next.
injuries.
State, sir. Yes.
Bless.
For the petitioner, my lordship. Petitioner, the accused, my lordship. I have filed 311 application for rendered the evidence on behalf of the accused. Manager, bank manager. Now 2013 to 13 and 14 ಅಲ್ಲಿ we have transacted with the complainant. The
Documents ಕೊಟ್ಟಿಲ್ವಾ ಅವರು?
ಸುಮ್ಮನೆ
Documents ಕೊಟ್ಟಿಲ್ವಾ?
ಕೊಟ್ಟಿಲ್ಲ ಸುಮ್ಮನೆ.
Bank documents ಕೊಟ್ಟಿಲ್ವಾ?
ಕೊಟ್ಟಿಲ್ಲ.
Some of the documents.
My lord, kindly allow me to make a submission, my lord. My lord, he had filed a previous application in application under section 91 CRPC and 27/11/2023, my lord, wherein which exactly sought for the same document.
Rejected.
That was rejected and he did not challenge it before any court, my lord, even before your lordship, my lord.
Please, my lordship.
And the second thing, my lord.
ಅಂದ್ರೆ ಇದು ಸೇರುತ್ತೆ. Yes.
My lord, second thing, while rejecting the same application, the honorable trial court placed its reasoning on two things, my lord. One, the cause of action arised in 2020. That with by.
So what is the problem in summoning the bank manager?
Well, they are nowhere related to the transaction that is there in the present case, my lord.
Ian, what do you want to prove by getting?
My lordship, I have transferred the amount in favor of the complainant's account. The complainant is not produced the documents. One document exhibit D3 is produced before the trial court. In Canara Bank, I have transferred the amount 7 lakhs. I have
check amount ಎಷ್ಟು?
ಚೆಕ್ ಅಮೌಂಟ್ ಇರೋದು 20 ಲಕ್ಷಕ್ಕೆ ಹಾಕಿದ್ದಾರೆ, 10 ಲಕ್ಷಕ್ಕೆ.
ಆಯ್ತು.
ಅದರಲ್ಲಿ 7 lakhs ನಾವು ಮೊದಲು ಚಿಟ್ ಅಮೌಂಟ್ ಇತ್ತು. ಚಿಟ್ ಅಮೌಂಟ್ಗೆ 2014 ಅಲ್ಲಿ ನಾವು ಟ್ರಾನ್ಸಾಕ್ಷನ್ಸ್ ಇತ್ತು, ಕ್ಲೋಸ್ ಮಾಡಿದ್ವಿ ಅದನ್ನ. ಅದಕ್ಕೆ ಈ ಆಕ್ಸಿಸ್ ಬ್ಯಾಂಕ್ ಇಂದನೂ ಅಮೌಂಟ್ ಹೋಗಿದೆ. ಪ್ಲಸ್ ಜೊತೆಗೆ ಈಗ
ನಿಮ್ಮ ಹತ್ರ ಇಲ್ವಾ ಬ್ಯಾಂಕ್ ಸ್ಟೇಟ್ಮೆಂಟ್? ನಿಮ್ಮ ಹತ್ರ ಬ್ಯಾಂಕ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ಇಲ್ಲ?
ಬ್ಯಾಂಕ್ ನಂದು NP ಆಗಿದೆ ಬೇರೆ ಲೋನ್ ಅಕೌಂಟ್ ಇಂದ 2016 ಅಲ್ಲಿ. ಅದಕ್ಕೆ ನನಗೆ ಯಾವ್ದು ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಕೊಡ್ತಾ ಇಲ್ಲ. ಅದರಿಂದ ನಾನು ಸಮನ್ ಮಾಡಿದೀನಿ. ಇವ್ರಿಗೆ ಏನ್ ತೊಂದರೆ ಆಗಲ್ಲ. ಇವ್ರ ಫೇವರ್ ಆಗಿದ್ರೆ ಇವ್ರು ಬಂದಿದ್ರೆ ಬರ್ಲಿ, ಇಲ್ದಿದ್ರೆ.
Kindly allow me to make a submission.
That is not the.
All right, stop, please.
My lord, petitioner approached my bank respondent in 2020 for a business loan of 20 lakhs, my lord. And the same was placed before the loan sanction committee and it was disbursed on 11/3/2020, my lord. 20 lakhs were disbursed. And EMI was fixed at 1,66,667 rupees.
All right.
After borrowing the loan, he did not even pay one single installment, my lord.
All right.
After that, recovery officer from the respondent bank went in search of him, and when they approached him, he issued a check for a part payment of 10 lakh rupees, my lord.
All right.
Same was produced and it was bound, it was returned, dishonored, my lord. A legal notice was served on him. Instead of answering to the legal notice, he sent a letter to the bank asking for a moratorium benefits. And he also sent a mail to the advocate who sent the legal notice asking for a time to respond. After 15 days of statutory time, he did not reply, he did not pay. Then without alternative, I filed an application under, I filed a complaint under the 138 of NI Act, read with 200 of CRPC,
Yes,
my
sir.
lord.
Anything else?
My lordship.
Well, there is no merits in the case, my lord.
My lordship. I have
Bank manager summoning.
And the case is also posted for the arguments, my lord. Accused arguments, my lord.
ಅದರಲ್ಲಿರ್ತಕ್ಕಂಥ ರೆಕಾರ್ಡ್ಸ್ ಕೊಟ್ಟರು, ಬ್ಯಾಂಕ್ ಇಶ್ಯೂ ಮಾಡಿದ್ರು ನನಗೆ ಸಾಕು ಸುಮ್ಮನೆ. ಐ ಹ್ಯಾವ್ ಫೈಲ್ಡ್ ಎ ಲಿಸ್ಟ್ ಆಫ್ ವಿಟ್ನೆಸ್ ಅಟ್ ದ ಟೈಮ್ ಆಫ್ ಮೈ ಡಿಫೆನ್ಸ್ ಎವಿಡೆನ್ಸ್. ದಿ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ವಿತೌಟ್ ಲುಕಿಂಗ್ ಟು ದ ಲಿಸ್ಟ್ ಆಫ್ ವಿಟ್ನೆಸ್ ದೇ ಕ್ಲೋಸ್ಡ್. ದಿಸ್ ದಿ ಸಮ್ಮರಿ ಪ್ರೊಸೀಡಿಂಗ್ಸ್ ನೀಡ್ ನಾಟ್ ಬಿ ರಿಕ್ವೈರ್ಡ್ ಟು ದಿ.
Why you did not challenge the 91 order?
91 ಆರ್ಡರ್ ಇದ್ದಿದ್ವಿ. ಅವರು ಸಮನ್ ಇಲ್ಲ, ಬರೀ ವಿಟ್ನೆಸ್ ಮಾಡಿದ್ರೆ ಆಗಲ್ಲ ಅಂತ. ದೇ ಆರ್ ಓವರ್ಆಲ್ ಸ್ಟೇಟೆಡ್.
Documents ಇಲ್ಲ ಅಂತ ಹೇಳಿದ್ರೆ ತಾನೆ?
No. 91 application.
Where is the order under 91?
91 order.
Right. In statement of objection, I have placed the application objection on the order of trial court, my lord.
Where is this?
My lord, annexure R3, my lord, at page number 17 of statement of objection, my lord.
1 minute. Where is the objection? R3.
Yes, my lord.
R3 ಯಾವ್ದಿಲ್ಲ. There is no R3 to your objections.
My lord, statement of objection.
That's what statement of objections ಇದೆ ಇಲ್ಲಿ. There is no R3.
Annexure R3, my lord, at page number 17.
Sir, your statement of objection is only 4 pages.
Lord, I have filed the statement of objection.
Will not
yesterday only.
of course, sir.
My lord.
But this is my wakalat. I have produced the statement of objection yesterday, madam. I have one more copy in. Yesterday, my lord, on 12th.
Registry to put up the statement of objection so filed by the petitioner. List the matter day after tomorrow in the fresh matters list. Yes, next.
22.
Intermode idre continue ಆಗುತ್ತೆ.
Petitioner, my lord, 138-311 application. I am the complainant. I sought to summon the bank manager, my lord.
The bank manager don't.
On the ground, my lord, the defense urged by him.
Documents ಕೊಟ್ಟಿಲ್ವಾ?
ಕೊಟ್ಟಿಲ್ಲ.
ಮತ್ತೆ?
Documents ಅಲ್ಲ. The transaction is, my lord, under a sale agreement, he gives me the original sale deed. That original sale deed I have produced before the court. The cross is, my lord, that the original sale deed is a fair color Xerox and the original.
Why the bank manager?
Because he contends, my lord, that the original sale deed is in the custody of that bank. That the document which I have produced.
Endorsement ಕೊಡ್ಲಿ ಅವ್ರ ಬ್ಯಾಂಕ್ನವರು.
ಇಲ್ಲ ನಂದಲ್ಲ ಅವ್ರು ಹೇಳ್ತಾರೆ ಡಿಫೆನ್ಸ್.
ಆಯ್ತು endorsement. Let the bank give an endorsement that the sale deed is in the custody of the bank. As simple as that.
Kindly, the trial court recorded that, my lord, this is only a dispute regarding, my lord, whether already the exhibit P8 is colors I took
No.
attention.
The 311 application is allowed.
Rejected.
On the ground, my lord, that
Your application.
my complaint, the complaint, the application is rejected. On the ground, my lord, that I'll verify if the document is original or not. When I require it, I'll summon it.
Take an endorsement from the bank that.
That is his bank. I'm the complaint. He's the accused.
91 application is not filed, ma'am. To summon the document, no application is filed.
In the cross, this is for summoning of witnesses, my lord, on summoning the document. Because I don't know under which contract it's been given. The contention, my lord, in the cross examination, my lords may see the cross examination.
You can always secure an endorsement saying that the bank is in the custody
That
of
is
the
the
bank.
accused
So
will have to do. He's not doing. He simply cross examines me saying that, my lord, this is a fake document. Kindly see the cross examination.
Get the documents, get the endorsement from the bank, sir.
Yes, my lord.
Otherwise, I'll allow this
I'll
application.
kindly appreciate, my lord. This court, the trial court has recorded that, my lord, it can be easily, we can assess that whether it's a genuine document or, my lord, is most important, my lord, in the entire case, my lord, the witness.
What is the amount involved?
40 lakhs.
40 lakhs.
Under an agreement of sale, I pay 40 lakhs. I transfer the amount. He hands me the original sale deed. Now he's contending the sale deed which he has given to me is a Xerox copy. That is not the original. The original has been mortgaged to a bank.
It's fact also, my lord, it is true that original document is in the custody of the bank.
Why did you give the?
My lord,
What
court has
copy
record.
did you give it to him then?
Well, court has
Crime
record.
register ಮಾಡಿಲ್ವಾ?
ಇಲ್ಲ ಸ್ವಾಮಿ, ಅವರು
Crime register ಮಾಡಿಲ್ವಾ?
ನಾವು ನಮ್ಗೆ 138 ಕ್ರಾಸ್ ಮಾಡಿದಾಗ ಗೊತ್ತಾಗಿದೆ. ಅದಕ್ಕೆ
ಅಲ್ಲ 420 ಮಾಡಿಲ್ವಾ ಇವ್ರು?
420 ಮಾಡಲಿಲ್ಲ.
ಅಲ್ಲ, ನಾವು ಅವ್ರು ಕೊಟ್ಟೇ ಇಲ್ಲ. ಆಕ್ಚುಲಿ ಕಲರ್ ಜೆರಾಕ್ಸ್ ನ ಅವ್ರು ಪ್ಲೇಸ್ ಮಾಡಿದ್ದಾರೆ. ಅಂದ್ರೆ ಸ್ವಾಮಿ ಒಂದೇ ಡಾಕ್ಯುಮೆಂಟ್ ಇವ್ರು ಪ್ಲೇಸ್ ಮಾಡಿರೋದು ಕಲರ್ ಜೆರಾಕ್ಸ್, ಒರಿಜಿನಲ್ ಬ್ಯಾಂಕ್ ಅಲ್ಲಿ ಇದೆ ಅಂತ ಇಟ್ ಇಸ್ ಅವರ್ ಕೇಸ್. ಟ್ರಯಲ್ ಕೋರ್ಟ್
Original bank ಅಲ್ಲಿ ಇದ್ರೆ then this requires the manager.
My lord, one submission.
Will allow the application.
My lord, one submission, my lord. It is not their case, my lord, that it is necessary for the jurisdiction of the case. One of my trial court has.
It is your defense that it is with the bank,
Yes, ma'am.
correct?
Yes, ma'am.
And you have given him a copy of the sale deed after receiving 40
We have
lakhs.
not given, it is disputed, we have not given the document.
What 40 lakhs receive ಆಗಿದೆಯಾ?
No, my lord, we disputed the entire amount, but we are not executed the agreement, my lord. Original document at the time of
138 agreement ಬಗ್ಗೆ ನೀವು ನೋಡ್ತೀರಾ?
That is the defense that we have taken, that under an agreement of sale, we had paid 40 lakhs. He gave the sale deed was sale transaction was cancelled. He paid us 40 lakhs by way of a check.
My lord, in the cross examination admitted that, but contents of the agreement he doesn't know. The PW admitted that the content.
Allow this application.
My lord, one submission.
No problem.
My lord, one submission.
Why are you fighting? Bank ಅಲ್ಲಿ ಇದೆ ತಾನೆ?
ಇದೆ ಸ್ವಾಮಿ.
Manager ಬಂದು ಹೇಳ್ತಾರೆ ಬಿಡಿ ಬ್ಯಾಂಕ್
My
ಅಲ್ಲಿ.
submission, my lord. I am not disputing, my lord, that it is not my I have no problem if the court allowed. My point is, my lord, the convenience of the parties, my lord, cannot be considered.
Convenience, it is your defense. You have put up that it is bank. It is in this
My lord,
custody.
the court has recorded that, my lord, of the observation. For a moment.
I will hear it, buddy. Yes, list the matter on 23rd. Interim order subsisting will continue to the next date of hearing. Next.
Same stage, madam. Same stage.
Same stage. Yes.
23.
ಯಾಕೆ ಲೇಟ್ ಆದ್ರೆ ಬೇಡ ಅಂತನ ಅಡ್ಮಿಷನ್ ಲಾಕಿ.
Second respondent, Tahildar filed complaint 192 KLR madam. Without giving any notice, madam. We filed complaint.
Lalitha Shastri covered.
Please.
List after 2 weeks. Interim order subsisting will continue to the next date of hearing.
24.
Petitioner, my lords. Petitioners are A3 to A5, my lords. Offense under section 419, 465. The implicator is based on the confession statement of A1 and A2, my lord.
Yes,
Please, my lord.
investigation papers.
Security.
Idea,
It is.
ಕೊಡಿ. Tuesday, fresh matters.
Madam.
ಕೊಡಿ.
Meanwhile,
Tuesday, next. ಈ Tuesday, ಬರೋದು. Next. ಬರಲ್ಲ ಇರ್ಲಿ.
25.
ಮನ್ನಾಪುರಂ. ಅವ್ರು ವಕಾಲತ್ ಹಾಕ್ಬೇಕಂತ.
Date may be fixed.
Learned counsel so and so undertakes to enter appearance for the respondent registry to print the name of so and so as appearing for the respondent. List on 10th December. The fresh matters list. Interim order subsisting will continue to the next year. Thanks.
26.
You appear for the respondent, my lord, in the first petition and petitioner, my lord, in the second petition.
Case, counter case scenario.
Case and counter case.
Federalist idea.
What? Before we just get into the matter, my lords.
Settle ಆಗಲ್ವಾ?
Settle who other settle ಮಾಡುವ.
ಮಾಡ್ಕೊಳ್ಳಿ.
6-7 ವರ್ಷದ bill. I'll make an attempt.
Make an attempt ಅಲ್ಲ, make an attempt. Illder will dismiss both.
Make an attempt. What is not followed here, my lords, 1 minute. There is a slew of directions which has been issued. The course correction methods which have been issued by this honorable court. Series of cases. So sorry. No, my lords, in terms of that, there was a circular which was also issued in as a mandate in this case, counter case.
ಏನ್ ಸೇಮ್ ಇನ್ವೆಸ್ಟಿಗೇಟಿಂಗ್ ಆಫೀಸರ್ ಅಲ್ವಾ ಇದ್ರಲ್ಲಿ?
Either.
ಮತ್ತಿನ್ನೇನು?
A fact finding minutes condition is missing. I'll just pass on the last condition in that circular minutes, which might actually be the.
ಹೊಡೆದಿದ್ದೀರಾ, ಹೊಡೆಸ್ಕೊಂಡಿದ್ದೀರಾ. Sit and settle. Let the wounds heal. Yes.
Please.
Records. Yes, sir.
Secured.
Make an effort for settlement.
I will. They are brothers.
That is why they are brothers.
They are
ಅಂತಲೇ.
brothers. They are brothers.
Make an effort for settlement. Yes.
Records till whatever date it may come back.
Settlement ಗೆ records ಇಟ್ಕೊಂಡಿರಿ.
But in the
Can
second
there
case,
be-
there is no interim order.
One ನಿಮಿಷ. Both will grant
Please.
to facilitate settlement. ಇಲ್ಲಾಂದ್ರೆ I will dismiss both. Yes. List the matter on 6th December. Both the parties would submit that if
The
time is
interim-
granted,
Yes.
the talks of settlement could be triggered and explored. Therefore, list this matter, first Bharatbadi, therefore list this matter on 6th December as the warring parties are siblings in the case at hand and it is a case and a counter case. Therefore, the matter could be settled. If matter could be settled, list the matter. For to facilitate such talks, there shall be an interim order of stay of further proceedings qua these petitioners in both these cases. ಎಲ್ಲರೂ ಅವರ್ ಡಿಸ್ಮಿಸ್ ಮಾಡ್ತಾರೆ.
Please.
27.
11 application has been dismissed by in the revision.
ಕಂಪ್ಲೇಂಟ್ ನೀವು?
I am the complainant. On my complaint,
ಎಸ್ ಜಗದೀಶ್.
charge sheet has been filed by filing a PCR.
Direction.
ರೆಸ್ಪಾಂಡೆಂಟ್ ಇದಾರಲ್ಲ,
Not necessary.
ನಾಟ್ ನೆಸರಿ ಅಂತ ಹೇಳಿದ್ರೆ ಇವತ್ತಾಗಲ್ಲ, ನಾಳೆ ಮಾಡ್ತೀವಿ. ಲಿಸ್ಟ್ ಟುಮಾರೋ ಇನ್ ದಿ ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ಸ್ ಲಿಸ್ಟ್. ಎಸ್, ನಾಳೆ ಮಾಡ್ತೀವಿ.
Very well.
They can delete the name of the
Huh?
They can delete the name of the respondent.
ಅಷ್ಟ್ರಲ್ಲಿ ಮಾಡಿ ಅದು.
I will file.
Learned counsel for the petitioner submits that the complainant is not a necessary party to the relief that
Accused matter.
accused is not a necessary party for the relief that he has sought as it is only rejection of a 311 application filed by the complainant. Therefore, deletion of the respondent is permitted. Accused is permitted. List tomorrow in the fresh matters list.
I file the. No file.
28.
Petitioner minutes. Short accommodation.
List after 2 weeks.
Now the date may kindly be fixed. Budzak matter squarely covered. It's a Budzak matter.
List
Squarely
after 2
covered.
weeks. Yes. Next.
Interim order may kindly be extended.
Idea.
This one against both petitioners because squarely covered by your lordship's judgment.
But said covered.
The only issue, Buds Act say
ಅಲ್ಲ ನನ್ನ
complaint has to be filed. Lordship may have it Week after next.
The
my lord.
matter on 6th December. Yes.
Grateful.
Next.
Intermodal candidate.
Intermodal subsisting will continue to next week.
29.
Petitioner, my lord. Lord, in this case, my lord, at the time of FIR, my lord, these petitions are not in the list, my lord. In the
319
FIR,
application.
319 application, 490 FN.
one
Others
one
have dropped
submission, my
Iವರು
lord,
ಯಾರು? Who are you?
sisters, my lord. Now A1 expired, husband is expired, my lord, A1.
The petitioners accused 2 and 3 are before this court calling in question an order passed by the concerned court on an application filed by the prosecution under section 319 of the CRPC, dragging them back into the web of proceedings. They are said to be the sisters of the accused number 1 husband, who is now no more.
He is expired on 23/9/20, my lord.
Who is now no more. A perusal at the order or the evidence that led the sisters to be back into the web of proceeding is not enough circumstance as is held by the apex court for dragging back the accused who are let off while filing the charge sheet into the web of proceedings. There shall be an interim order of stay spread for till the next date of hearing.
Produce the evidence.
Huh?
There's no evidence copy, but only based on order.
Matter settle ಆಗುತ್ತೆ ಸ್ವಾಮಿ ಫಸ್ಟ್ ವೀಕ್ ಅವರು ಇಲ್ಲಿ ಏನಾಗಿದೆ ಅಂದ್ರೆ
ಘಟನೆ ಇಲ್ಲ ಬಿಡಿ ಅಂದ್ರೆ
ಇನ್ನಿಬ್ರು
Perusal of
ಆ
evidence.
perusal ಅಲ್ಲ
Perusal of order.
perusal the order ಅಂತ ಮಾಡಿ ಅಷ್ಟೇ. ಎಸ್
30.
ಎಸ್ ಕಲ್ಯಾಣ್.
This case may not be appealed filed by the petitioner or dismissed for non-prosecution, my lord, page number 20.
List on 20th in the fresh matters list. Interim order subsisting will continue to the next date of hearing. Next.
31.
Same, identical.
Same order. Yes.
Much.
32.
30 and 31 notice is not at order.
ಬೇಡ ಏನಕ್ಕೆ?
Please,
ವಾರಂಟ್ ತಲೆ.
please. 32, please, my lord. Petition by accused number 2, please, my lord. Though this petition, my lord, is residing in the very same address during a SOP period, my lord, stay with the.
Sir, 354 yes, sir.
Now, proceedings quash ಕೇಳ್ತಲ್ಲ ಸ್ವಾಮಿ. Only particular order,
What order?
please, my lord, page number 25, my lord. Page number 20, my lord, copy of the order.
What order is that?
23/8/2024. On that day, my lord, it is stated that, my lord, accused number 2, notice to accused number 1,
Where do I get that order, sir?
page number 20, please.
20.
Please, 20. Typed copy, please, my lord, is at 25. Accused number 1 present notice to surety of accused number 2 served surety by name Narayana Swami son of so and so called out absent. Hence, office is hereby directed to register criminal Mr. so and so against a surety. Is a reissue NBW against accused number 2 and 3 notice to surety. So,
Yes, ಹೇಳಿ.
my lord, page number, please, my lord. 13, my lord. Order dated 21st August 2021. Though this petition, my lord, since from his birth, my lord, residing in the very same address, my lord, as per Aadhaar card, page number 67. The police report, my lord, A2 left address 2 years ago as per Sharaf police.
Yes, look into the papers.
I'll secure the
Secure instructions.
petition ready to appear before the learned magistrate.
The learned HCGP to secure instructions with regard to the passage of the impugned order. List the matter on 20th. ಈಗ ತೊಂದ್ರೆ ಏನಾಗಿದೆ? NBW.
16th.
Warrant hanging on the head of the petitioner shall remain stayed till then. Yes, next.
Great.
ಯಾವ್ದೋ ಒಂದು
33.
KDB. Yes, sir.
Lord, this is the allotment of land by the
I'll
gate.
fresh matter like we'll hear it.
Well, I think it was
There's
not,
some
it
urgency.
was not reaching, that is why.
Last time, Lord, on the last date of hearing,
we had paid the entire amount towards allotment of the land by KDB.
ಹಾ
ಈ ಮೊನ್ನೆ our endorsement ಅಲ್ಲಿ court has orally instructed us to return the amount ಅಂತ ಹೇಳಿ return ಮಾಡಿ.
ಇಲ್ಲ, on whose volition did you pay? ಯಾರು ಕೇಳಿದ್ರು?
We had paid earlier pursuant to the interim order granted here.
Interim order is not.
Interim order ಏನ್ ಗ್ರಾಂಟ್?
Interim order
ದುಡ್ಡು
not
ಕೊಟ್ಟಿ
in
ಅಂತ
the
ಕೇಳಿದ್ದ?
first round of litigation when it was there. We
That
took
was
it.
dismissed.
But
That was
no, that we
disposed.
got it revived.
Revived ಹೌದು, ಬಟ್ ನೀವು ದುಡ್ಡು ಕೊಟ್ಟಿದ್ದು ಅವಾಗ್ಲೇ ಈಗ್ಲಾ?
ಅಲ್ಲ ಅವಾಗಲೇ ಕಟ್ಟಿದ್ದೀವಿ. That is, we have paid the money in 2022, June 2022.
And why do you use that oral instructions? Who gave you oral instructions?
That's a mistake, that must be a mistake, my lord.
Put it on the court.
No, we'll withdraw the letter, my lord. It's a mistake, my lord.
Oh, when did I give you oral instruction to?
We didn't hear also.
ನೋಡ್ಬಿಡಿ ಇದನ್ನ.
ಅಲ್ಲ, no, if I remember.
No, I don't think
he
so.
said-
That's correct, incorrect, my lord.
He said without asking, they have paid.
They have returned the money back, my lord.
Ah.
The rest.
Why do you want to put the?
No, they say
For
they
the
have
court-
returned because your lordship.
ಇಲ್ಲ,
says
ತಪ್ಪಾಯ್ತು.
they returned.
That's not an issue.
Let it
We'll
be
withdraw it.
withdrawn. Yes.
Your lordship may record that also, my lord.
The learned Advocate General appearing for the respondent board submits that the letter, the reference to the oral instructions of the court made in the communication is erroneous. The
Erroneous.
same would be withdrawn and appropriate communication would be issued if necessary. Again, problem in further
ಇದ್ರಲ್ಲಿ
hearing.
ಏನಾಗಿದೆ ಅಂದ್ರೆ the land was allotted in our 3
That I know, he got it revived and other things.
Yes, and my lord, the government initially extended the lease period from 10 years to 99 years.
I'll post it on 23rd. We'll hear it on 23rd.
Saturday, madam.
Working Saturday, sir.
Even working Saturday, no bad. Okay, leave it at that.
Saturday ಬೇಡ, ನಮಗೂ ಬೇಕು.
You better.
It's for judges, madam.
Oh, judges only, not the advocate. List on 22nd.
22nd.
Yes, list on 22nd at 4 PM.
Please.
Anyway, it's for further hearing
Please.
at 4 PM.
For the hearing.
For further hearing.
Passover, my lord. Senior zone is like in another court hall.
List on Tuesday in the fresh matters list. Yes.
35.
Hearing for petitioner, my lord. I'm requesting for time, my lord.
Lord, in this case,
Next week.
ಏನಿದು?
the original, the applicant was the mother of the presiding officer who had granted the land. The sitting MLA as on the date. And the kindly see the statement of objection had produced the documents. As on the date, my lord, he has
Bagay hukum.
Yes, my lord. He has manipulated the documents. The Tahsildar.
You are the Tahsildar?
Please.
Yes.
Correct ಆಗಿದೆ, ಏನ್ ತೊಂದರೆ ಇಲ್ಲ.
Next week.
Interim ordering no, coordinate bench.
The documents, he had taken charge as a Tahsildar on 28/11/2017 as per their own document. Kindly see the annexure R1, Lord. He had issued a Tiluvalike Patra on predated, that is on 16/11/2000.
No, all these people are involved in that
Yes.
grant of lands to all and sundry.
Next week, my lord.
I have
My senior-
dismissed that petition, sir. Bagair Hukum committee.
Bagair Kanun.
Saying it is Bagair Kanun. Bagair Hukum committee has acted Bagair Kanun. Yes.
Next week, my lord. I'll try to convince, my lord.
Try to list the matter on 20th at 4 PM for further hearing. Yes.
Interim order. may be expected.
Interim order subsisting will continue to the next date. It will go, sir. Definitely go.
I'll try to convince.
Yes. Breather ಅಷ್ಟೇ ಅಲ್ಲಿವರೆಗೆ. Yes, next.
36.
Please, my lord. The interim order in this case, but as for the prayer is for re-investigation, my lords, the government has said they have no objection, but your lordship directed me to do the points, my lords. In the meanwhile, I humbly pray that the notice, my lord, 1 to 4 learned government advocate may be directed to take notice, my lords. 5 notice, my
ಯಾಕೆ
lord.
ನೀವು ಪಾಯಿಂಟ್ ರೆಡಿ ಮಾಡಿಲ್ವಾ?
Not ready, my lords. Not ready. Your lordship.
What was your colleague doing?
Please, we'll get it.
Yes. Ready ಮಾಡ್ಬೇಕಲ್ವಾ?
Please, my lords. By next week.
Should do it, madam. Yes. List on 27
Please.
in the fresh matters list. Notice ಅಲ್ಲ ಆಮೇಲೆ ಫಸ್ಟ್ ಅವ್ರನ್ನ ಅಕ್ಯೂಸ್ ಹಿಯರ್ ಮಾಡ್ಬೇಕಾಗಿಲ್ಲ
That's why it's
reinvestigation.
not my duty to bring to the notice.
I asked you to list out the lacunae.
Please.
Yes.
Interim order to continue.
Will continue. Yes, interim order continues to the next day.
Great.
Appearing for petitioner, my lord. NI Act 138.
Huh?
NI Act 138 section.
ಗೊತ್ತು, yes.
And stayed.
Yes, sir. Objection ಹಾಕಿದ್ರಾ?
Objection ಹಾಕಿಲ್ಲ.
ಹಾಕ್ಬಿಡಿ. File your objections. Same, 4th December.
Stay, my lord.
4th December, anti-murder subsisting will continue to the next date of hearing. Yes, Suyog. Atrocities Act.
Respondent number 2 in this matter, my lord. I'm
Ah.
Bakalar. So the interim order has been passed in this
Yes.
matter, my lord.
Atrocities Act.
Others, Swami, my lord may actually see the charge sheet. The injury that has been sustained by the respondent number 2, the wound certificate has been placed on record. The record.
Injury by this man.
Yes, my lord.
Oh.
My lord, the complaint is very clear, my lord. It's against two people.
Mother and son.
Acid Ravi and this.
Acid Ravi.
Accused number 1. Accused number 1 and the second. The
Accused number 1 is not before the court.
No. Against two of them, my lord. Only against two of them, the allegations are there in the complaint.
Against whom?
Against both of them, my lord. Ella kade ibru ant heltare. My lord, may please see page 28.
Legally, they draw the petitioner, my lord.
And
just
my lord,
because it's
this
public.
petition, if my lord may also see, after getting injured, he goes to the, is taken to the hospital. Even in the records over there, my lord, he names these people. If my lord may please see the wound certificate at page 71.
Let's see, you file your objections, Chris. ಹಾಕಿದ್ದೀರಾ?
ಇಲ್ಲ, I'm filing ವಕಾಲತ್ ಇವತ್ತು.
ಆಯ್ತು, Learned Counsel.
My lord, the charge sheet speaks for itself, my lord.
No. See, background we should always see. It's not.
Page 71 may please be seen. Wound certificate 1 ನೋಡಿದ್ರೆ ಅದ್ರಲ್ಲಿ.
ಅಲ್ಲ, wound cert 324 ಇರೋದು.
Please, my lord.
323, 324 we will see. But Atrocities Act ಅಲ್ಲಿಂದ ಬರುತ್ತೆ.
ಎರಡ್ ಸತಿ there are two places where he says that this is the petitioner who calls us by our caste name.
We'll see.
And one ground that has been taken, my lord, is that there is a civil dispute. I may draw my lord's attention to section 8B of the Atrocities Act. My lord, because that would be relevant over here. Firstly, my lord, there is no civil dispute over here. ಹೋಗಿದಾರೆ, ಅವ್ರು ನಿಲ್ಸಿದ್ದಾರೆ, ಯಾಕೆ ಟ್ರೆಂಚ್ ಹಾಕ್ತಿದಾರೆ ಮಧ್ಯ ರೋಡ್ ಅಲ್ಲಿ, ಹೊಡೆದ್ರು ಬಡದ್ರು, ಅವ್ರನ್ನ ಜಾತಿ
ಮಾಡಿದ್ದಾರೆ.
That's the case, my lord.
All right, let's see. You file your wakalat, I'll give a date. List on 4th December.
4th
in the
December.
fresh matters list.
Great.
You want to file objections, you file, or you can make submissions. Yes.
Maybe I'll
Interim order subsisting will continue to the next date of.
I'll just summarize more.
ಮಾಡಿ, ತೊಂದರೆ ಇಲ್ಲ. ಅವತ್ತು 4th.
Of course, my lord. Hello, can I file my wakalat, my lord, please?
I can. Who stops you, sir?
ಅಲ್ಲ, ಇಲ್ಲಿ ಕೊಡ್ಬೋದಾ ಅಥವಾ registry ಅಲ್ಲಿ?
ಮಾಡಿ.
Connected matter also there, interim order. One more connected.
ಯಾವ್ದ್ರಲ್ಲಿ ಇದೆ? Interim order ಎರಡರಲ್ಲೂ ಇದೆಯಲ್ಲ? ಎರಡು 4th December.
Connected A1.
Acid Raviಗೆಲ್ಲ ಕೊಟ್ಟಿರೋದು.
ಅಚ್ಚಾ.
Same petitioner has filed 2 petitions.
Okay.
ಎರಡರಲ್ಲೂ ವಕಾಲತ್ ಆಗ್ತಾ ಇಲ್ವಾ ನೀವು? ಒಂದ್ರಲ್ಲಿ atrocity ಇದೆ, ಒಂದ್ರಲ್ಲಿ atrocity.
Because the first matter is stayed, my lords. On the second day, they register, my lords.
I stayed that matter.
Please.
ಯಾವ್ದು atrocity ಇದೆ. Next day another complaint is registered on the same cause of
I will
action.
take instruction on that.
So that has to go ultimately.
On the basis of the charge sheet only, I am making some.
ಅದರಲ್ಲಿ, but next day another complaint is filed.
I'll get some.
39.
Fine.
4th, my lord.
4th, yes.
Great.
Yes.
39, 14%.
This is my reply to their reply.
Reply to their reply?
They have filed a reply.
Ah.
They have told all lies in that.
Lies? Okay, yes. ಶಾಂತಿ ಭೂಷಣ್ ಅವ್ರು ಏನಿದೆ?
Please, your lordship, I kindly.
Reply ಕೊಟ್ಟಿದಾರ ನಿಮ್ಗೆ? Reply to reply?
I have received it, my lord. The case is not as what is being projected, my lord. If your lordship may kindly see, my lord. The petitioner was blacklisted for a reason, my lord, violating.
We'll continue at 2:30.
Please.
Yes. Back at
2:30.
ನಮ್ಗೆ 2:30ಗೆ ಬರೋದು.
Held in mediation center
When do you want it?
tomorrow. Please.
One main matters ಮೇಲೆ hearing ಆಗಬೇಕಿತ್ತು ಸರ್.
Huh?
ಇಲ್ಲಿ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಇಸ್ ಎ ಚೈಲ್ಡ್ ಫ್ರೆಂಡ್ಲಿ ಕೋರ್ಟ್ ಅಲ್ ಮೇಲೆ ಇದು ಬಂದ್ಬಿಟ್ಟು ಸೆಕ್ಷನ್ 307 ಡ್ಯೂರಿಂಗ್ ದಿ ಟ್ರಯಲ್ ಅಡಿಷನಲ್ ಚಾರ್ಜಸ್ ಹ್ಯಾಸ್ ಬಿನ್ ಫ್ರೇಮ್ಡ್ ಫಾರ್ 338.
ಏನ್ ಬೇಕು ಸರ್ ಈಗ?
ಒಂದು ಫೈನಲ್ ಇಯರಿಂಗ್ ಪೋಸ್ಟಿಂಗ್
ಫೈನಲ್ ಇಯರಿಂಗ್ ಪೋಸ್ಟಿಂಗ್
ಅದಕ್ಕೆ ಅದು ಚೈಲ್ಡ್ ಫ್ರೆಂಡ್ಲಿ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಸ್ವಾಮಿ ವಾರನೂ ಕೇಸಸ್ ಹಾಕೊಂತ ಇದ್ದಾರೆ.
ಈಗ ಪೆಂಡಿಂಗ್ ಮ್ಯಾಟ್ರಾ ಇದು?
ಹೌದು ಪೆಂಡಿಂಗ್ ಮ್ಯಾಟರ್.
ಮುಂದಿನ ವಾರ ಯಾವಾಗ ಕೊಡಿ?
ಡೇಟ್ ಮೇ ಫೈನಲಿ ಬಿ ಫಿಕ್ಸ್ 19th ಇದೆ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ.
ಅದೇನ ಆರ್ಡರ್ ಆಗಿದೆ ನೋಡಿ ಮೇಡಮ್. Pronouncement.
List number 3, pronouncement of order. Bill number 1.
Appearing for the petition.
Kerosene.
Nice.
Dismissed. Dismissed. Kerosene ನಾವು ಇಂಟ್ರೆಸ್ಟ್ ಇರತ್ತಾ?
Number 2.
Have not accepted the interpretation of 35A to become a ground for reference to CBI. If I permit that, then every banking institution may ask. DSP Act will become redundant. Dismissed.
Have a look at it. May just have a look at it.
It will be uploaded in 30 minutes.
Please.
ಯಾಕೆ ನಿಮ್ಮ ಅಗೇನೆಸ್ಟ್ ಬರೆದಿದ್ದೇವೆ ಅಂತ? It will be uploaded immediately. I have already signed.
Yeah, Prasanna wanted to say something.
Want something?
ಹುಷಾರಿಲ್ಲ ಅಂತ ಹೇಳಿದ್ರು ಬೆಳಿಗ್ಗೆ, ಅದಕ್ಕೆ ಕಾನ್ಸ್ಪೆಂಟ್ ಮಾಡಿ ಸಾಹೇಬ್ರಿಗೆ ಹೋಗ್ಬಿಡು ಅಂತ ಹೇಳಲ್ಲ ಅಂತ ಹೇಳಿ. ಅದು ಇದ್ದೇ ಇರಲ್ಲ, ಗಲಾಟೆ ಮಾಡ್ತಾರೆ ಬೇಡ.
That may not be possible. Let's see. Yes. Good. That those criminal appeals, I'll pass the order later.
Please.
By 4:30, I will pass the order.
ಚೇಂಬರ್ಗೆ ಹೋದ್ಮೇಲೆ ಬೇಕಾದ್ರೆ ಮಾಡ್ಬೋದು. ಸುಮ್ಮನೆ
ಅದರಲ್ಲಿ
ಇಲ್ಲ ಬೇಡ, ಇಲ್ಲೇ ಮಾಡ್ಬಿಡು.
ಮ್ಯಾರೇಜ್ ಇದೆ.
ಮ್ಯಾರೇಜಾ?
ಅರ್ಜೆನ್ಸಿ
ಆಯ್ತು, ಮ್ಯಾರೇಜ್
ಮತ್ತೆ ನಾಳೆನೇ ಮ್ಯಾರೇಜ್ ಇದೆ ಅದಕ್ಕೋಸ್ಕರ.
ನಾಳೆನೇ ಮ್ಯಾರೇಜ್.
ಹುಷಾರಿಲ್ಲ, ನಾನು ನಿಲ್ಲಕ್ಕಾಗಲ್ಲ, ಬರೋಕ್ಕಾಗಲ್ಲ ಅಂತ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿದ್ದಾರೆ.
ಎಲ್ಲಿ?
ಇಲ್ಲಿಂದ ಇಲ್ಲಿ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕುವ ಹೇಳಿರೋದು.
ಅಲ್ಲ
ಅಲ್ಲಿ ನಾನು ಮ್ಯಾರೇಜ್ ಹೋಗ್ಬೇಕು, ಅಲ್ಲಿ ಅಟೆಂಡ್
ಅಲ್ಲ
ಮಾಡ್ಬೇಕು.
IFR ಇಂಟರ್ವ್ಯೂ ಹಾಕೊಂಡಿದ್ದು ಅದೆಲ್ಲ
ಏನೇ
ಪ್ರೊಡ್ಯೂಸ್
ಹೇಳಿದ್ದು?
ಮಾಡಿದ್ರು.
ಮಾಡಿಫಿಕೇಶನ್ ಆಫ್ ಪ್ರೇಯರ್.
ಅಲ್ಲ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದ್ ಸ್ವಾಮಿ ಎಲ್ಲ
ಯಾರನ್ನ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡ್ತೀರಾ?
ಇನ್ವಿಟೇಷನ್ ಕವರ್ ಅಲ್ಲೆಲ್ಲ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದ್ದೀನಿ ಅದರಲ್ಲಿ. IFR ಇಂಟರ್ವ್ಯೂ ಅಲ್ಲಿ
ಪ್ರೈಮರಿ ಗ್ರೌಂಡ್, ಮೆಡಿಕಲ್ ಮತ್ತೆ ಮ್ಯಾರೇಜ್ ಅಟೆಂಡ್ ಮಾಡೋದು.
ಆನ್ಸಿಲರಿ ಗ್ರೌಂಡ್ಸ್ ಇದ್ದೇ ಇರುತ್ತೆ. ಮಾಡ್ತೀನಿ ಟುಮಾರೋ ಮಾಡ್ಲಾ?
ಅಲ್ಲಲ್ಲ
ಮ್ಯಾರೇಜ್ ಟುಮಾರೋ ಮಾಡ್ತೀನಿ. ಮಾಡಿ ವಿಲ್ ಓನ್ಲಿ ದಿ ಆಪರೇಟಿವ್ ಪೋರ್ಷನ್ ವಿಲ್ ಅಪ್ಲೋಡ್ ಇಟ್.
ಪ್ಲೀಸ್
ಇಲ್ಲ ಅದು ಕೊಟ್ಬಿಡಿ, ಮಾಡ್ಬಿಡ್ತೀನಿ. ಕೊಟ್ಬಿಡಿ ಮಾಡಿ. ಬಂತಲ್ಲ ಬರ ತಗೊಂಬಂದ. ಹಾಂ, ಒಂದೆರಡು ನಿಮಿಷ ಮಾಡ್ತೀನಿ. ವಿಲ್ ಕಂಟಿನ್ಯೂ ದಿ ಲಿಸ್ಟ್. ಫೈಲ್ಸ್ ಬಂದ ತಕ್ಷಣ
ಪ್ಲೀಸ್.
Just continue. Number 39.
93 my lord.
ಏನದು?
Officer supposed to be.
93 ಯಾವುದು? Why were they asked to be present?
Last time there was a direction issued to a inquiry at the hospital, my lord, that Ayurvedic doctor allegation is that he conducted a surgery in an hospital.
Correct.
That's
Fake doctor case, my lord.
Fake doctor case.
and mistake, my lord, that our office has not communicated to him. Anyway, subsequently, my lord, they've gone and verified all the records. The record speaks.
What?
He has not done it.
He has not done any surgery.
I'll produce the video, my lord. Video is, we have to take the statement and whatever the video
We'll take it on record.
placed all the documents.
1 minute. You have personal rivalry, that is known. Wait, sir.
They've extracted and verified all the registers.
The learned additional SPP was directed to secure a report from the hands of the jurisdictional police police inspector with regard to the allegations of the complainant against the petitioner. The report is secured and is placed before the court. The
Inspector, madam.
the inspector of police who has drawn the report is also present before the court. In that light, is also present before the court. The his presence is noticed and his presence in future proceedings is dispensed with. The report is taken on record. List the matter on 23rd.
My lord, one submission. my lord.
Order, my lord.
Interim order subsisting will continue.
One
to-
submission.
Earlier, not to take precipitative action, to stay the investigation, I've asked for interim order.
Wait, yes.
There's no impediment for him to continue the investigation. There's no stay granted by this.
Now I will grant.
Lord.
List the matter on 29th in the fresh
Can
matter.
be disposed, my lord, on the.
Wait,
on the
sir.
merits.
Not
not-
according to your wish. Wait, sir. List the matter on 29th in the fresh matters list. Till such time, further investigation against the petitioner shall remain stayed. Yes. File your objections.
I've already filed, my
Oh,
lord,
very good. We'll do it.
with all the documents.
No problems. Yes. Now, month.
Pass for matters. Bill number 1.
ಯಾವ ಕೇಸಲ್ಲಿ ಮ್ಯಾರೇಜ್ ಇದೆ?
Criminal appeal 2035/24. List number 2, serial number 2.1.
List number 2.
Serial number 2.1.
ಫೈಲ್ ಬಂತ ಕೊಡಿ ಫೈಲ್ಸ್ ಅಂತ. ಸೆಕೆಂಡ್ ಲಿಸ್ಟ್ ಪ್ರೇಮ್ ಚಂದ್ ಗರ್ಗ್, ಅದರಲ್ಲಿ ಮಹೇಶ್ ಕುಮಾರ್ ಇಲ್ಲ. In each case will pass separate orders.
Please.
ಇದು 2038 of 20. Oh, sorry. 2038 ಆಯ್ತು 5 amendment.
2035.
2035 of 2024. The appellant in the case at hand is accused number 3 in special CC 54 of 2014. Is convicted for offences. Where is the order? Page fast. Shankar, ನಿಮ್ದ ಡಿಕ್ಟೇಟ್ ಮಾಡ್ತಿರೋದು. Where is the order? Next case ಕೊಡಿ. ಅದು ತಗೊಳ್ಳಿ. Next case ಕೊಡಿ.
Main matter.
ಅಲ್ಲ ಇದು ಹಸ್ಮತ್ ಪಾಷಾ ಸರ್ ಕೊಡಿ.
1995.
ಅದು ಹಂಗೆ ಇಟ್ಟಿರಿ ಮೇಡಮ್. ಈಗ ಒಂದು ಕೆಲಸ ಮಾಡಿ, ಬ್ಯಾಚ್ ಏನ್ ಬೇಡ. ವಿಲ್ ಪಾಸ್ ಅ ಕಾಮನ್ ಆರ್ಡರ್ ಇಸ್ ನಾಟ್ ಪಾಸಿಬಲ್. ಡಿಫರೆಂಟ್ ಆಗತ್ತಾ? Anyway.
If it is confined only to this nature of sentence and offense, my lord, all are common.
We'll see. It's better I pass different orders. The petitioner is accused number 3 in special CC 53 of 2014. Petitioner appellant.
Appellant.
The appellant calls in question an order of judgment of conviction and sentence in the aforesaid special case. In terms of the order, in terms of the judgment impugned, the appellant is directed to undergo an imprisonment of 7 years.
Sentence, my lord, by order dated 26.
26?
26/10, my lord. Date of sentence is different.
1 minute. In terms of the impugned judgment and sentence, is convicted for the offense punishable under section 420.
120B
420, 379 IPC.
120B, 420 and 379 of the IPC and is sentenced to undergo
Imprisonment for 5 years, 7 years, and
imprisonment
3 years.
for
5 years, 3 years, 7 years, 3 years.
1 minute, 5 years for offense, separate offenses ಹೇಳಿದಾರಾ?
120B, my lord, page 410, your lordship.
Is directed to undergo imprisonment for offense punishable, imprisonment of 5 years for offense punishable under section 120B of the IPC. ಆಮೇಲೆ
And a fine of rupees 20,000.
and a fine of rupees 20,000. Next one,
Offense
hanging
under 420.
paramedi. For offense punishable under section 420 of the IPC.
Yes, 7 years RI.
The petition, the appellant is directed to undergo imprisonment for a period of 7 years with a fine of 9 crore 25 lakhs
Jointly.
and severally. For the,
For offense under
corruption act
379.
ನಿಮಗೆ ಬರಲ್ಲ ಬಿಡಿ. For offense punishable under section 379 of the IPC, the appellant is directed to undergo
3 years.
imprisonment for a period of 3 years with fine of 20,000. Joint, with fine of 20,000. ಇದು joint and several, yeah?
Illa, these
yes.
all individual.
20,000 individual, yes. The learned senior counsel Hasmat Pasha appearing for the petitioner would contend that admission of the appeal and suspension of sentence in terms of section 389 of the CRPC is a matter of right. The respondents need not even be heard in the matter. The issue now would be with regard to the aftermath of the suspension of sentence in the event this court would accede to the appeals and suspend the sentence imposed upon each of the accused. The apex, it would be apposite to refer to the judgment of the apex court in the case of Satyendra Kumar Mehra versus State of Jharkhand, 2018-15 SCC 139, paragraph 36. The apex court holds that the appellate court, while exercising power under section 389, can suspend the sentence of imprisonment as well as fine without any condition or with conditions. There are no fetters on the power of the appellate court while exercising jurisdiction under section 389 of the CRPC. The appellate court could suspend the sentence or fine or both, or direct for deposit of the fine or a part of the fine. In the light of the you are also on anticipatory bail. In the light of the accused, in the accused number 3 in the case at hand being granted anticipatory bail and has and there is no indication from the respondents that he has violated any conditions of the bail, nor in the order, I deem it appropriate to suspend the sentence. So suspend the sentence in special case 53 of 2014, que accused number 4, accused number 4 and accused number 3, que accused number 3 and direct his he be released on grant of bail on the Israeli condition idalla.
Illa condition.
In condition.
No condition.
Grant of bail. However, the petitioner shall, the appellant shall deposit the fine amount within 6 weeks from, subject to the condition that the petitioner or the appellant would deposit fine amount within 6 weeks from today.
Yes. Here.
Deposit tane.
Fine of 120B and 379, my lord, we are ready to deposit.
40,000 ಯಾರು ಬೇಕಾದ್ರೆ ಕೊಡ್ತಾರೆ.
That, my lord, how to quantify, my lord? My lord, in respect of joint and several, my lord, it is.
All of you put together and deposit.
But it is, your lordship has.
Or we will direct deposit of part of the fine amount to each of them.
My lord, reasonable sum. What the Supreme Court has said, my lord, that it should be a payable one or recoverable.
Jointly and severally.
That is the reason, my lord.
Lots with A2 and A4 companies, lots it's written in the order, A2 and A5 companies, because they are entities then, therefore they are asked to split it up equally.
But in respect of A2, my lord, the firm, my lord, partnership firm, the same fine is imposed. The other 4 accused also same.
Without deposit of fine, I'm not going to suspend any sentence.
My lord, reasonable
That is for
sum.
sure.
Your Lordship may kindly, that is the reason, my lord, in the facts and circumstances of the case, whether fine can be imposed equal.
That is that I'm
My lord,
asking for deposit, sir, not to be
what the trial
dispersed,
court,
not
my
be
lord,
not to be dispersed
what
to the
the
state.
trial court calculated, my lord, this 9 crore is 9
ಈಗ total deposit ಎಷ್ಟು ಹೇಳಿದ್ದಾರೆ?
9 crore.
All put
20
together, what is the deposit?
9 crore 65, my lord.
9 crore 65 lakhs?
Yes.
How many accused are there?
My lord, 6 accused, your lordship.
Divided to
Five accused, my lord. 5 accused.
5 accused, divide it and deposit.
My lord, 9 crore 65, my lord, your lordship.
9 crore deposit, sir.
It comes, my lord, 2 crores, your lordship.
Well, it's deposit. I'm not saying give it off to someone.
My
In
lord,
case,
deposit means, my lord, they have to.
yeah, that's why
There,
6
that is
weeks
the
or 8
reason-
weeks, whatever.
Your lordship, one submission here. My lord, the main accused who has taken away from the court, my lord, is different. My lord, they are the only sellers. Our accused, my lord, they only sold, my lord, and the amount of sale, my lord, is still due from accused number 4.
Or anyway, all of you are convicted of the offences.
That is how, my lord, it cannot be quantified. The trial court has
So that's
committed
why
error, my
it
lord,
is,
that-
we will split it up. You deposit.
The work, the iron ore material sold, my lord, is not that much it is. That is how it is. And your lordship may kindly see, accused number 2 and 3, they have not removed. They have not committed theft of. Only with the aid of 120B, my lord, they have been found guilty. This 9
ಈಗ
crore
ಎಷ್ಟು
25
6 people ಅಲ್ವಾ? 1.5.
5 people.
5 people, my lord. One
5
is public,
people,
sir.
my lord, 9 crore 65 lakhs, my lord, it comes around 1 crore 85 lakhs it is. My lord, that much iron ore material, they have not even touched, your lordship. Here, my lord, the role of accused number 2 firm and of this accused, my lord, they conspired, my lord, to sell the iron ore material, not to
On the
remove it.
merits of the
This
matter,
case,
my
my lord, this case, my lord, is pertains to removal of iron ore, which is accused number 4. Accused number 4 had exported it. That company is ready to pay.
Without directing deposit, I am not going to suspend.
Your lordship may kindly reasonable, my lord, that at least your lordship may kindly
May-
25% of the fine amount, your lordship.
Lord, may I make one submission?
Well, not
Each case, Lord, the quantity alleged is totally different. But without reference to any quantity, the fine is imposed. In my case,
That's on the merit of the matter, sir, we will see.
no, my lord, the deposit, if it is impossible condition, my lord, we will not be able to comply. My lord, that is what, my lord,
Your
Supreme
lordship
Court.
may kindly separately here with regard to imposition of fine or deposit of fine is concerned, but substantive sentence may be suspended, my lord, with a subject to condition of furnishing surety. My lord, then, my lord, the fine amount, my lord, we are bound to deposit if your lordship imposes. The fact, my lord, that this requires hearing because in the facts and circumstances of the case, the role of each accused differs. My lord, as on the date of seizure, our product was not there at all.
That's on the merit of the matter, we'll see.
ಇಲ್ಲ, merits andre, they have been found guilty only with 120B, my lord, not with the substantive offense. Section itself, your lordship may kindly see, they have not looted, my lord, anything it is. They are under loss. My lord, their amount is still due for them.
My lord,
Fine, I'm not going to.
my lord, fine,
Lord,
it is compensation which is granted under 350.
I am not asking you to disburse, sir. Deposit in this
Lord,
court.
deposit, it is
Mata?
impossible
Deposit means
condition to comply, my lord.
My lord, for deposit also money is required. It is not.
The money is required, definitely required.
My lord, even while suspending, my lord.
No, you are arguing as though it is going to be distributed to the state.
No, not.
Or
Your
to
lordship may
the-
kindly
to anybody
reason
else.
about 20%, my lord, each, my lord, in respect of this accused, my lord, accused number 2 and 3, 20%, your lordship may kindly of the total amount. 9 crore 65 lakhs, your lordship may kindly, my lord, out of 5, my lord, it comes, my lord, a huge amount it is. My lord, 1 crore 85 lakhs, my lord, it comes. For
Without anything, nothing, sir.
My lord, out of total, my lord, 20%, my lord, your
The
lordship.
court has definitely erred in not directing imposition of fine on each of the quantify ಮಾಡಬೇಕು ತಾನೆ.
That's the reason.
What reason?
The reason Leonard Court has passed this.
In fact, at this stage
Split
of
it equally. That is why Leonard Judge
Divide
has
it
used the
equally.
jointly and severally.
There is no basis for the fine.
That we'll see.
Order of sentence arguments were heard, my lord.
9 crore, my lord, 9 crore for all 5 accused. My lord, if it is divided, my lord, it will come, my lord, that 1 crore 85 lakhs. My lord, out of this, my lord, 1 crore 85 lakhs, 25% you will deposit.
No, what 25%? Nothing.
My lord, then it cannot be, your lordship, that much fine amount again, my lord, that. Otherwise, your lordship may kindly hear with regard to imposition of fine.
Oh, no,
deposit
sir.
of fine, my lord.
That we'll hear the matter finally.
Lord,
Without fine being deposited, I will not
now,
accept it.
your lordship has to impose a condition deposit of fine. How much it is, how your lordship has to calculate out of this fine.
That
my
is
lord,
what calculation ne.
my lord, calculation.
965 divided by 5. That is calculation.
My lord, not that much. Out of that, my lord, your lordship may kindly 25 or 20%. My lord.
No, sir.
Lord,
Normally, my lord, 50%.
how it has to be considered on the judgment. Your Lordship may kindly have a look at this Dhankar's judgment. One nimsham, madam, idkodi. When the compensation is awarded under 357, it should not be unreasonable.
This is
by
not a question
considering
of 357, my lord. It's a question
No,
of
fine is
389.
granted under 357.
That
Compensation is
the
granted
problem.
under
No, no,
357.
He quotes 357 to
357
impose fine.
Last
My lord,
suffered by
say
state.
para 72, your Lord.
We'll hear all this. Deposit 50%.
Well, reasonable amount, otherwise nobody will come out.
50%.
No, I might have to secure it.
Now itself, your
You
lordship.
need not be heard on
50%
that, sir.
25%.
No,
my
no,
lord,
no.
It is payable. Your lordship.
Nothing.
My lord, 50% under how it is distributed.
Divided by five companies, sir, 5 accused.
But in my case, company is liquidated. The liability is on the
Accused
company
I know,
also.
sir.
My lord, this is, my lord, your lordship may kindly reduce to 25, my lord.
No. 50% of the fine amount.
50% of fine amount divided.
Fine amount, 5 will divided by 5. It will come to a crore each.
In
will
appeal
come-
number 2035, there are 6 accused. And there are separate appeals with separate number of accused.
Anyway,
Six
all of you
accused
put together,
divided among them.
deposit
yes.
it.
But my lord,
Joint
25
seven.
Idರಲ್ಲಿ one anomaly I will point out. In one case, the alleged export is 24,000 metric
No,
ton.
that's in the merits, sir.
ಅಲ್ಲ ಒಂದು ನಿಮಿಷ ಹೇಳ್ಬಿಡ್ತೀನಿ. ನನ್ನ ಕೇಸಲ್ಲಿ ಇಟ್ ಈಸ್ 29,000. ಆ ಕೇಸಲ್ಲಿ ಫೈನ್ 54 ಲಕ್ಷ, ನಂಗೆ 9.5 ಕೋಟಿ. There is no basis.
That is why all of you put together deposit 50%, 9 crore 65 lakhs alva. Deposit 5 crores. We will, all of you put together do it. I'll grant you 8 weeks.
My lord, if that condition is imposed, my lord, nobody will be able to comply. My lord, the Honorable Supreme Court, your Lordship is very well aware. The condition for bail, we should meet it.
2010 matter, my lord, 15 years, my lord, they have suffered litigation. They are under loss. They are not able to arrange also. My lord, imposing such kind of harsh condition, my lord, then, my lord, again they have to surrender, my lord, this kind of, my lord, it cannot be.
That's
My
may
lord,
say.
kindly, my lord, that it may be reduced to 20.
You should have told that court, sir. ನೀವು ಇಲ್ಲಿ ಹೇಳೋದಲ್ಲ ಅಲ್ಲಿ ಹೇಳ್ಬೇಕಾಗಿತ್ತು. What is this? Quantify ಅಂತ ಹೇಳ್ಬೇಕಾಗಿತ್ತು ಅಲ್ಲಿ.
My lord, the role of,
Leave the headache to the High Court.
role of the
Appellate
accused-
court will do it.
role of the accused differs, my lord. Here, accused number 4 is
Should
the
it not be
expert.
quantified by the accused and its role
Yes.
or the
The
offense?
trial court should have done it this, my lord, because the
The
trial.
blanket
was
saying that joint and several they will pay, and how are they going to pay? And there are officers also under 13.
Yes, yes. my lord,
How is he going to pay?
He has not even filed the appeal.
Then
He is not even
Not in
having
the
money to
position, my
pay,
lord,
file the appeal. He is
Look,
seeking.
the officer is not asked to pay, my lord. It's only
No, officer is also asked. It is
A2
joint.
company. Jointly and severally to
Sir,
pay to A2.
see the order of conviction.
Yes.
An accused is convicted for offense under the Prevention of Corruption Act.
Yes.
9 ಕೋಟಿ fine. Should not the court quantify ಈ offense ಗಿದು, ಈ accused ಗಿದು ಅಂತ? It's easy to say joint and several. How do you admit the appeal now?
But even under section 16 of PCI, while imposing penalty, court has to quantify that. Section itself is
Sir,
clear.
That is rudimentary. That court has to quantify and then do it where the offense is.
My lord, one submission, your lordship. My lord, here, my lord, after
Sir,
seizure.
without deposit of some fine, I am not going to suspend the sentence.
It is to be deposited, but it should be reasonable sum, not, my lord, 9 crore. The imposition of 9 crore itself is exorbitant. It is, it has no ratio at all.
Lord, your Lordship may impose reasonable fine. Lord, definitely your Lordship has power to take a reasonable, impose reasonable fine. Lord, a reasonable fine on each
You have
person.
told that court. Why you did not tell that court?
Opportunity, my lord, no opportunity to say regarding this, because the quantum of amount, what it was said only in the order. At the stage of hearing, well, we were not doing this 9 crore will be imposed.
Lord, there is a fundamental error. Because the original allegation in FOC 17 registered by the Forest Department is only for violation of Forest Act. There is no allegation that it is a material belonging to the government. Now the compensation is awarded as if the material belonging to government. That is the fundamental error in the judgment.
But, in all the 6 cases, my lord, exporter is accused number 4. SMSPL, my lord, it is not by his accused also and our accused also. That is.
ಮುಂದೆ ಬಿಡಿ.
Yes, he has to, my lord, explain this. Exported, mainly exported by whom? That
No,
is the question.
that's on the merit of the matter. Now, without deposit of any fine, we will not suspend the sentence. What is it is a very, the order does not speak what is to be done at all. It's the operative portion of the order is totally vague.
Undoubtedly go by your lordship's directions, that is number one.
Yes.
But for the purpose of imposition of certain directions, we are appealing to your lordship to be more reasonable.
No, that is there.
Practical, that is be more practical. My lord, we feel for ourselves, my lord, till the time your lordship hears us and dispose of the matter, we have a good case, extremely good case.
No, that's all right.
To the matter itself. And as my learned friend, Mr. Azmat Pasha has put it, before imposing the fine amount, in addition to the sentence of imprisonment, the judge did not hear us at all.
No, should there be a hearing on the fine amount?
Quite right. That is exactly we are before your lordship, my lord, that we are urging that also. See, because your lordship posed a question to us, you ought to have urged these things before the trial court.
That is true.
We did not get the opportunity of making our submissions on the quantum of the fine that is to be imposed. But for a moment, we are not saying that we are not going to deposit any amount by way of fine. We only appeal to your lordship to see some reasonableness.
That's what I said, 50%.
Probably subject to what my lord would ultimately, probably my lord,
5 crores, whatever.
subject to what my lord would ultimately say. 25% would be reasonable.
25, my lord,
25 would be reasonable amount.
25% will be about 2.5 crores.
That would be reasonable.
That you will say even 50 lakhs is exorbitant.
May I make one submission? Let them give security for the fine amount. For the entire fine amount.
No, it will be deposit. Which security? And security anybody can give.
Fine amount security.
Surety for the fine amount plus deposit. Surety you give. Surety will be given, no problem at all.
Surety, there is no problem for getting us enlarged on bail. We are bound to, and we are
surety you will get
no problem. Appearance before the court to receive the leftover sentence, if any. That is the purpose of we furnishing the surety.
Yes.
Separately, my lord. Or you lordship, may I suggest one thing?
And joint and several.
May I suggest
joint and several? Some semblance in the order that is passed.
25%. 25%. Reasonable.
No, that's not, thousands of crores, 25% is.
Or any amount which
no,
could suggest between 25 and 30%.
We'll quantify the amount. You deposit 3 crores and
please.
In joint and several and
please.
Deposit 3 crores. I'll post the matter for.
May I say this, my lord? For a matter involving thousands of crores, my lord, 3 crores.
ಯಾಕೆ ಮತ್ತೆ 9 ಕೋಟಿ ಹಾಕಿದ್ದಾರೆ 90 ಕೋಟಿ ಹಾಕ್ಬೇಕಾಗಿತ್ತು
let them deposit the fine.
Thousands of crores ಅಂದ್ರೆ
Learned judge has passed an order for 9 crores. 9 crores is not something unreasonable.
Discretion of the court. Yes. 3 crores. Appeal is admitted to be heard.
5 crores, 5 crores.
Admitted to be
50%. 50% reasonable. Barrage
50% was reasonable.
3 crores divided by different activities.
ಅದು ಗೊತ್ತಿಲ್ಲ. That is your headache.
How court will decide?
Joint and several. As the court has said, I will not sit and rob. This accused will pay this much. This accused will pay this much. No.
That is exactly the problem.
By the accused. That's the job of that court. Final hearing al ನೋಡೋಣ ಆಮೇಲೆ.
ಅದು ತಾವು ಜಾಯಿಂಟ್ ಅಂಡ್ ಸೆವರಲ್ ಎಂದು ತಪ್ಪಾಗುತ್ತೇನೋ ಅನ್ಸುತ್ತೆ ಅಪೀಲ್ ಅಲ್ಲಿ. Because otherwise trial court will not be able to get the bond.
That's why I said I'll pass the order tomorrow. Somebody's marriage urgent ಆಗಿ ಇವತ್ತು ಬೇಕು ಅಂತ ಏನು ಮಾಡಕ್ಕೆ?
3 crores.
We'll see then. I'll pass the order.
3 crores or 25%, it comes same, my lord. Your lordship may kindly
we'll see.
it.
I'll pass the order tomorrow.
In percentage, if your lordship imposes, my lord, it will be more clear. Each accused can deposit.
Percentage, we don't know.
Percentage, your lordship, it will come 25%, my lord, it comes to that one. My lord,
Anyway.
2 crore 50 lakhs, my lord, 25% it
When
is.
tomorrow at 10:30 I will pass. Yes.
And ultimately, when your lordship pass the order, my lord, this may be clear, that's what it is.
Some clarity, there's some, if you
Yes,
give me
my
some
lord,
time,
that-
some clarity will emerge.
But
Otherwise, where is the problem?
30% comes, my lord, it is about around. My lord,
These courts passing order, joint and several, leave
around 3
everything to
crore
the High Court.
Unheard of, my lord.
It's not correct.
A criminal case, it is.
Fine should be quay the accused, quay the offense.
Each individual accused
Yes.
has to impose the fine. Ella ಒಟ್ಟಿಗೆ ಸೇರ್ಕೊಂಡು
Giant cell motor vehicle case ಇದು.
ಕೊಡಕ್ಕಾಗತ್ತಾ fine amount?
Not a motor vehicle case.
It is meaningless, man. I would rather say.
We'll see.
Will undertake, my lord, otherwise, my lord, equivalent surety amount, my lord.
Surety amount you will give, sir. That's a different thing. To stay the sentence, the condition is you should deposit the amount.
25%.
Deposit the amount of 3 crores or whatever it is. That is okay, we'll pass. Otherwise, then I'll
If
pass
it
it
is
tomorrow.
last, my lord,
So many advocates are waiting.
250, your lordship, 2.5.
What bargain is this? Then
But
I'll stop it at 50%. Yes.
Lordship, in 2035, that was the one where I sought for early. Your
That
Lordship-
is why this problem,
No,
because
Your
of your
Lordship,
hurry.
Lordship, you are saying that it should be deposited. Let it cover all the accused in that matter, in special CC 54 of 2000.
No, every case, this will be the order. But it is not a common order.
No, no, no.
Ah.
In my appeal arises out of special CC 54 of 2004.
What is the fine imposed there?
They are 90 lakhs, madam.
Only 90 lakhs.
Only 90.
Then
But if it is jointly and severally, it will cover all the accused in that case. That would be the position, Your Lordship.
No, no,
Otherwise,
no.
it will be that all the 6 will
Separate
have
conviction order in your case is too.
90, all total together 90, for all 6 together.
Oh, then if joint and several under separate,
If I pay, then it will be covering everybody else.
what sort of an order?
And even if I pay 50%, I'll be covering all the 6.
ಅದರಲ್ಲಿ 24,000 metric ton, ನಂದು 27,000 metric ton. 3,000 difference, but I have to pay 9 crores.
And his is 90 lakhs.
He is 90 lakhs. That is what I said.
For 24,000 metric ton.
But
Lord, in
I jointly-
percentage, your lordship may kindly, my lord, out of the fine amount, this much percentage each accused has to deposit.
How?
My lord, that court will calculate.
How?
Well, it
How,
can
tell
be
me?
calculated, your
Now
lordship.
his conviction is based on 90 lakhs.
Tax, my
90
lord.
No, his conviction is 90 lakhs.
90
Why
lakhs.
will he pay more?
My lord, he can pay, my lord, 25% calculation, my lord, it is easy to deposit amount.
No,
Each-
jointly and severally ಅಂತಂದ್ರೆ
Jointly and
ಹೋಯ್ತು ಅಷ್ಟೇ.
severally
ಅಲ್ಲ,
means if one
individually-
pays, it pays for all.
25%, my lord.
These courts ಸುಮ್ನೆ yes.
Keeping that in mind, Your Lordship may then say that each accused in each of the criminal trial is directed to deposit 10 or 15.
Then 27,000 metric tons, 9 crores is imposed on him. Out of 9 crores, 25% he will have to pay.
Please, that will have to be, there's some method in the madness will have
that
to
is
be
the
followed.
reason. A quantum, your lordship may direct and
No,
I'll
that
put
is
each
there.
case.
Start regarding
Each
quantum
case.
Deciphering everything, sir, that can't happen. 25% of the fine amount in each of the cases.
plus,
By each of the accused.
50%. Problem is, my lord,
ನೀವು collect ಮಾಡ್ತಾ ಇದ್ದೀರಾ sir?
deposit.
I will have to stay it without any fine the way the order is written.
Plus,
Without fine, I'll have to stay the matter. That is the way the order is written. What are you talking of? Should not the court quantify ಯಾರ fine, ಯಾರ accused ಗೆ, ಯಾವ offense ಗೆ ಅಂತ? And you are saying 50% should be imposed now? Where is the clarity in the order? Fine imposed ಮಾಡಕ್ now he says 27,000 metric ton is the allegation against him. 9 crores is imposed. 24,000,
Metric ton,
one
they said
minute,
is-
24,000 metric ton is the offense against him. 90 lakhs is imposed. Why 10 times more?
Plus, Milots, with respect to the quantum, Milots, this 10,000 metric ton is only exported in that case. The others are lying in the port, whereas in this case, 27,000
None-
has been
If
exported.
that is the argument in
Right,
my
take
case,
it.
entire quantity is in the port itself. I will show from the charge sheet itself.
Milots, on the respect of
ನಾನು
quantum.
ಏನು
aspect,
ಓದೋದು
they
ಬೇಡ,
can take it
ಚಾರ್ಜ್
to the
ಶೀಟ್ ನಲ್ಲೇ
merits of the
ತೋರಿಸ್ತೀನಿ
matter.
ನಾನು. ನಾಟ್ ಇವನ್ ಎವಿಡೆನ್ಸ್ ಇಸ್ ರಿಕ್ವೈರ್ಡ್. ಅವ್ರು ಹೇಳ್ತಾರೆ 40,000 ಮೆಟ್ರಿಕ್ ಟನ್ ಮೇನಲ್ಲಿ ತಂದು ಹಾಕಿದೀರ ಅಂತ. ಸೀಸ್ ಆಗಿರೋದು ಮಾರ್ಚ್ ಅಲ್ಲಿ. I can show it. Now
Even
itself,
if
in
entire
the objection
27,000 metric
itself,
ton
I
is
can show
taken,
it.
10 times more, 3,000 metric ton is the difference. Where is the,
In our case, 17,500 metric ton, 9 lakh, 6 lakh, 9 crore, 6 lakh, fine has been
ಅದು ಕರೆಕ್ಟ್ ಆಗಿದೆ ಸುಮ್ಮನೆ ನಿಮ್ದೇನ್ ತೊಂದ್ರೆ
17,500.
ಪರವಾಗಿಲ್ಲ ಲ್ಯಾಕ್
Lakh ಅಲ್ಲ, 9 crore, 9 crore, 6 lakhs.
It's all right. Now, each case will pass that order. Shall pay, then let it be 50% of the fines imposed in each of the cases.
25%.
Each of the accused, your
ಅದೇ
lordship.
ಹೆವಿ ಆಗ್ಬಿಡುತ್ತೆ.
Then that 90 lakhs can, they ಆಗಲ್ಲ. No use of that fine at all.
ಅಷ್ಟೇ 90.
You deposit the entire 90 lakhs.
Only
But
in
that
this
would
case.
cover
my
then
lord.
all the 6, your lordship.
No, it will not cover all the
And the
6.
jointly and severally is the order, your lordship would go.
All the 6 accused.
All the 6 accused.
Jointly and severally, that for the present, the deposit will cover all the 6.
Yes.
ಅದೊಂದು ಅದ ತಗೊಳ್ಳಿ ಅಪೀಲ್ ತಗೊಳ್ಳಿ ಒಂದು ನಿಮಿಷ.
2035.
First order dictated, my lord. Another appeal, my lord.
ಒಂದು ನಿಮಿಷ ಸರ್. This court has created lot of obfuscation in this order. ಆಯ್ತು ತಗೊಳ್ಳಿ ಮೇಡಮ್. ಈಗ ಕ್ರಿಮಿನಲ್ ಅಪೀಲ್ 20 ಶಂಕರ್ ಯಾವ್ದು ಇದೆನಾ 2035 of 2024. The petitioners, ಇಲ್ಲಿ accused number 3 ಮಾತ್ರ ಇದೆ ಇಲ್ಲಿ.
Please, I have alone I have.
You said there are 5 accused.
Just in the judgment itself refers to all of them. And
Where
that
are the
your
other,
lordship
where
will
are the
find-
other accused? They have not appealed?
ಇಲ್ಲ ಅದ್ರಲ್ಲಿ A1 ಹಾಕಿಲ್ಲ ಇಲ್ಲಿ.
One, Mr.
If they have not appealed, you pay all the 90 lakhs. Yes. The petitioner is, appellant is accused number 3. Is convicted of the offense punishable under, ಏನ್ ನಿಮ್ದು offense?
120B.
Where do I get the order?
Your lordship will get
Page.
it on page 5.
Page
5
5.
of my appeal paper. I have extracted it for ready reference. Bottom up.
Is convicted of the offense. ಹಿಂಗ್ ಮಾಡಿ. The appellant by the judgment dated 24/10/2024 and order on sentence dated 26/10/2024 is convicted and sentenced to imprisonment in the following terms. Page 5 11. Page 5 and 6. The appeal, since the offense is punishable, since the conviction is for a maximum period of 7 years in the case at hand, I deem it appropriate to admit the appeal. The appeal is admitted for hearing and the sentence stands suspended, subject to the condition that the petitioner would deposit the fine amount that covers the accused in these cases. Covers the accused in CC, in
54 of
special CC 54 of 2024 in the
2014.
2014 in the next 6 weeks. Idu one next
The entire 90. Entire 90.
90, yes.
1995, my lord. Appeal.
Quantum prakara we will do it. Yes. Wherever it is 9 crores, we'll reduce it.
Yes.
Yeno?
And ನಾಳೆ ಮತ್ತೆ.
Yes.
1995, my lord.
Now 1995, yes, sir.
9 crore 65 lakhs, my lord, it comes.
Same order, subject to the condition of 25%.
That's, may I, your lordship had posed a question regarding to the quantum. The
Shoot,
reason
my
there is a,
Yeah, what
the
company?
reason there is a difference in sentence, my lord's imposition is based on the loss cost to the exchequer. That is the reason the learned judge has quantified.
Where is Prasanna Kumar?
Lord's
He was here, why did he leave?
before division bench, my lord, that he was unable to.
Yes.
But based on the loss.
Where is the loss? Where is the quantification of loss in this?
Quantification of loss, my lord's- my point.
Where is the quantification of loss in this case?
Security has not been.
Adella, regular terms will be there, apart from that, yes.
And by it will be deposited in the High Court or registrar.
This generally what is done here.
Before the trial court.
Before the trial
Before
court.
the trial.
Before the trial court, yes.
Registrar.
6 weeks time, my lord.
6 weeks time.
If it is forfeited, the trial court will have to do that. That's the.
ಅಲ್ಲಿ ತಾನೇ deposit.
Generally, ಅಲ್ಲೇ deposit.
ಈ appeals first time ಬರ್ತಾ ಇರೋದು ನಮ್ಮದು ಅದಕ್ಕೆ ಗೊತ್ತಾಗ. Yes.
In respect of firm, my lord, no such.
Yes, sir. Where is the quantification?
Certain.
Quantification is coming?
No, charge sheet is produced from the charge sheet. That is.
Before making statement, you should be ready to answer the question. Then I will suspend it without any fine, without any
Apologies,
stay
my
of
lord.
fine.
May I get my senior?
Yes. 20, ಎಷ್ಟು fine ಇದರಲ್ಲಿ?
My lord, 965 it comes.
9 crore 65 lakhs.
65 lakhs.
3 crores, yes. Deposit, subject deposit of 3 crores. Bear in other conditions.
You lordship may kindly, in respect of each of the accused, my lord, divided by
ಅದು
3
ನಿಮಗೆ
crores divided by 5, your lordship may kindly.
ಇದು ಸ್ಪೆಷಲ್ CC ಏನು?
53/2014.
To be deposited by all the accused in 53/2014.
All the accused, my lord, 3 crores, my lord.
That is what I
You may
said.
kindly specify, my lord, it will be divided among them. At least your lordship has to write in.
No.
My lord, trial court did not write. Your
Sir,
lordship
one
at least specify.
Wait, sir. ಏನ್ ಹೇಳಿದೆ ಮೇಡಮ್? To be deposited by all the accused. What else you want?
All the accused ಅಂದ್ರೆ
All the accused in special CC.
divide, my lord, among them, my lord, lordship may kindly 25% dictate, your lordship, that is understandable it is.
I said 3 crores to be divided by all.
25%.
25% ಅಂದ್ರೆ ಏನು? 3 crores
Each
ಅಂದ್ರೆ ಏನು?
accused can deposit 25%, my lord, they will deposit without hesitation,
ಅಲ್ಲಿ
my lord, without any confusion in the trial court also.
ನಾಳೆ
Otherwise, 3 crores, one will deposit, another will not deposit. My lord,
forfeiture ತೊಂದ್ರೆ
not
ಅದಕ್ಕೆ
by-
ಬೇಲ್ ಆರ್ಡರ್ ಅಲ್ಲಿ ಈಗ
25%.
50 lakhs each ಅಂತ ಮಾಡಿದ್ರೆ at least
25% by all the accused.
Yes. 6 weeks, my lord, time.
6 weeks.
This firstly, second matter also same order, my lord, which is a firm, my lord, no imprisonment. My lord, only to deposit fine, my lord, order is separate, my lord.
Anyway, we'll take those cases. ಕೊಡಿ, first list ಕೊಡಿ madam.
Arising out the same case, my lord, that's all.
The court should not create this vacuum and send it here. The courts are meant to deliver judgments with clarity. ಇದರಲ್ಲಿ ಏನು ವಿಜೇತ ನಾಯಕ್?
Page number 420.
9 ಕೋಟಿನಾ?
9 ಕೋಟಿ 6 ಲಕ್ಷ.
Sorry, 25% of that. Same order, 25% by all the accused. Yes, in the next 6 weeks.
Next matter, my lord, serial number 2.
But no,
This is a firm, my lord, only fine is imposed. To sentence.
ಸರಿ, ಅದ್ರಲ್ಲಿ ಬೇರೆ ಏನು ಬೇಡ.
25%.
Sentence ಏನಿಲ್ವಲ್ಲ?
25% to be deposited.
ಅದರಲ್ಲಿ so and so appeal is admitted to
No
be heard.
surety, nothing, my lord.
Appeal is admitted to be heard. The sentence is suspended, subject to the condition.
The fine is.
Sentence of fine is stands suspended, subject to the condition of deposit of 25% of the fine amount.
6 weeks or 8 weeks. my lord.
6 weeks, ಎಲ್ಲ 6 weeks standard, yes.
Kindly, my lord, do the operation.
ಯಾವ್ದು ಹ್ಯಾಂಡ್ ಡೆಲಿವರಿ ಎಲ್ಲ ಇರುತ್ತೆ ಸರ್, ಕೊಡ್ತೀವಿ. They are in custody.
You, my lord, tomorrow morning.
Tomorrow morning you will get, yes.
We'll leave this, my lord. Memo, your lord.
ಕೊಡಿ. Tomorrow morning.
number 3.
Apply.
Serial number 3, 20,000 rupees is the final.
ಎಷ್ಟು?
20,000.
In all?
ನಮ್ಗೆ ಇರೋದೇ 2 ಚಾರ್ಜ್. 420 20,000, 379 20,000.
Entire amount. ಇದರಲ್ಲಿ 25%. Subject to deposit of the fine of entire amount, no 25%. Same appeal admitted. ಕೊಡ್ತೀನಿ ಸರ್, ಎಲ್ಲ ನಾಳೆ ಕೊಡಿ.
Four.
992. 4 992.
9 crore 92 lakhs, 25%. ಎಲ್ಲ ತಗೊಳ್ಳಿ, ಏನ್ ಮಾಡ, ಎಲ್ಲ ಕಸ್ಟಡಿ ಇದೆ.
Bill number 5.
ಮಾರ್ನಿಂಗ್.
My lord, serial number 52, 10 minutes, 25%. 9 crores under.
ಎಲ್ಲ 9 crores.
ಎಲ್ಲದರಲ್ಲೂ 9 crores.
ಎಲ್ಲದರಲ್ಲೂ ಸೇಮ್ ಆರ್ಡರ್, 25%. Within 6 weeks.
They might stand on a different footing. They are exporters as.
Huh?
No, they are the exporters, they are the main conspirators. Therefore, my lord, at least for them, my lord, 50% may be permitted.
Yes, ಅದೆಲ್ಲ ವಿಲ್ ಡಿಸೈಡ್ ಇಟ್ ಇನ್ ಅಪೀಲ್. ಈಗ ಒಬ್ರಿಗೆ ಇಂಪೋಸ್ ಮಾಡಿ ಇನ್ನೊಬ್ರಿಗೆ 9 crores ಇನ್ನೊಬ್ರಿಗೆ ಅಷ್ಟೇ ತಾನೆ.
ಅಲ್ಲ ಇವ್ರಿಗೆಲ್ಲ 9 crores ಇದೆ.
ಅಲ್ಲ ಕರೆಕ್ಟ್, ಇನ್ನೊಬ್ರಿಗೆ 9 crores ಅಲ್ಲಿ 25% ಹೇಳಿದಿನ ದಟ್ ನಾಗೇಂದ್ರ ನಾಯಕ್ಸ್ ಕ್ಲೈಂಟ್.
They were all only
ಅಲ್ಲ
sellers.
ಅವ್ರಿಗೂ 9 crores ತಾನೆ. If the imposition itself is erroneous, then where is it doing here?
9 to 10.
9 to ಎಲ್ಲ 25% ಮಾಡಿ.
Please.
Yes. 25% all these cases. Appeals admitted for language ಎಲ್ಲ ಹೇಳ್ತೀನಿ. ಇದರಲ್ಲಿ ಬೇಡ, ಅಡ್ಮಿಟ್ ಅಂತ ಮಾಡಿ ತಗೊಳ್ಳಿ. ಇದೇ ಲ್ಯಾಂಗ್ವೇಜ್ ಡಿಪ್ಲಾಯ್ ಮಾಡಿ. ಯಾರ್ಯಾರು ಇದೆ ಎಲ್ಲ ನೇಮ್ಸ್ ಹಾಕಿ. ಸೀನಿಯರ್ ಕೌನ್ಸಿಲ್ಸ್ ಮೇಡಮ್ ಇದು ತಗೊಳ್ಳಿ. ಯಾವುದು ನಿಮಗೆ ಎಸ್ ಲಿಸ್ಟ್ ಕೊಡಿ, ಕಂಟಿನ್ಯೂ ಮಾಡಿ.
Lord, I'll file my objections in this. I'll put it on record.
File it on record. The learned DSGI seeks 10 days time to file statement of objections. List the matter on
I'll file my objection.
3rd December.
Grateful.
Objections, if any, by then.
Lord, can I get an interim orders that he may be allowed to come,
Interim order of what, sir?
that he may be allowed to come to India? He is blacklisted, which is.
No,
as I
that will be
told,
that.
those are
By
all
interim
rights.
order, we can't do that, yes. List on 3rd December in the fresh
Please,
matters list.
please.
Yes.
My lord, in fact, I filed my instruction. My learned friend insisted that he wants to see the objections on an affidavit. So I'll file an affidavit.
All right, no problem.
Please.
File it, file it.
Well, at least notices can be sent to all the other respondents so that the truth can come out.
Which
especially,
other respondents are there?
He's from.
Who is he?
Respondent number 1.
Go back.
2, 3 and 4. 2, 3 and 4 and 5.
My lord, let him delete the name of the first respondent, my lord.
Who is
By
it?
name, he is made the Commissioner of Bureau of Immigration. By name. Let it be
Have you attributed malefites?
My
Are you attributing malefites against the respondent?
Accused number 6 has stolen my gold worth 34 lakhs. And he has said that he has stolen it because you have shown the CCTV footage. And knowing all this, nothing is being done to them.
Objections, if any, emergent notice to the respondents. First respondent name ಮಾಡಿದ್ರೆ ಮಾಡ್ಲಿ ಬಿಡಿ.
You delete the name of first respondent. By designation, you can let it be there.
My lord, then why is he not
Leave it. Emergent notice to the respondent. Put objections, if any, in the next 2 weeks. Put up the matter after receipt of notice by the respondents.
My lord, then
In
their
admission.
reply that they have written that I am an NGO. At least a notice can be sent to that NGO, and he has agreed that I am not a any part of it.
I have issued emergent notice to others.
Yeah, but in this reply, they have written about 2 people. One is the
That
Chennai,
we will decide.
FRRO
We
Chennai.
will decide it after they come. Yes. Yes.
Great.
This case, my lord, take notice, my lord. 40 and 40,
offense ಏನಾಗಿದೆ?
Sir, they have been already been caused by this honorable court.
40 and 41, my lord, I will take,
Predicate offense ಹೋದ್ಮೇಲೆ ನಿಮ್ದೇನು ಉಳಿಯುತ್ತೆ?
I will, because first time I am appearing, my lord, I will.
First time. The learned counsel Jaikar, Madhukar Deshpande ilva?
ಇಲ್ಲ,
ನಿಮಗೆ ಕೊಟ್ಟಿದ್ದಾರೆ. Learned counsel Jaikar Shetty submits that he has been interested with the matter. Registry to delete the name of Madhukar Deshpande and print the name of Jaikar Shetty as appearing for the enforcement directorate in both these cases. Objections, if any, by the next date of hearing, list the matter on 4th December in the fresh matters list.
next case is same.
Same, yes.
42. The petitioner wills. I am challenging Annexure B FIR. It's a family matter. Dispute was there between husband and wife and the matter was settled. So I have filed this present application, present petition for quashing of the FIR Annexure B.
In the meantime. Stay application idea ilva? WP, yes, next.
Orders 43.
The year was not put up. Here, Mera, it is allegation, Mera, in the police compound.
I filed my
The
statement of
petitioners
objections,
alleged to
my
have
lord.
assaulted them. At page 32, Mera, of the charge sheet.
ಯಾಕೆ ಆರ್ಡರ್ಸ್ ಎಲ್ಲ ಯಾಕೆ ಬಂದಿದೆ?
32, Mera.
Office objections raised by.
Of the objection.
ನಾನು ಅಬ್ಜೆಕ್ಷನ್ ಹಾಕಿದ್ದೀನಿ ಸ್ವಾಮಿ, ಅದೇನೋ ಸಮ್ ಮಿಸ್ಟೇಕ್ ಇದೆ ಅಂತಿದ್ದಾರೆ. ಐ ವಿಲ್ ಕ್ಲಾರಿಫೈ.
I'll grant stay now.
ಅಲ್ಲ, ಫೈಲ್ ಮಾಡಿ ಅವ್ರ ಕಾಪಿ ಕೊಟ್ಟಿದ್ದೀನಿ.
ಹಾ.
ಅದೇನು ಅಂತ ಗೊತ್ತಿಲ್ಲ. ಅಂಡ್ ಮಚ್ ಮೋರ್ 2 ಕೇಸು ಪೆಂಡಿಂಗ್ ಇದೆ ಸ್ವಾಮಿ, ಇದನ್ನು ಅದ್ರ ಜೊತೆ ಟ್ಯಾಗ್ ಮಾಡಿ.
ಯಾಕೆ ಅದಕ್ಕೆ ಇದಕ್ಕೆ ಏನ್ ಸಂಬಂಧ?
ಅದಕ್ಕೂ ಇದಕ್ಕಿಂತ ಅಲ್ಲಿರ್ತಕ್ಕಂಥ ಅಣ್ಣ ತಮ್ಮಂದ್ರು, ಇಲ್ಲಿದ್ದವರು ಅಣ್ಣ ತಮ್ಮಂದ್ರು.
The matter, Mera. There was a complaint last.
Tag this petition along with so and so.
ಮೇಡಮ್,
List them all.
2 ಮ್ಯಾಟರ್ಸ್ ಇದೆ.
List them all on 27th in the fresh.
ಪ್ಲೀಸ್ ಮೇಡಮ್.
For admission, yes, next. In terms of the memo, 44.
45.
For petition. The interim order is partially complied, my lord. Another 5 lakhs has to be deposited by today. DD is ready, my lord. I may be permitted.
Kodi. Which matter, madam? 20 lakhs. How much have you paid?
Till now, 15 lakhs is deposited, my lord. On 27/9, 10 lakhs is deposited, 14/10, 5
ಈಗ
lakhs is deposited.
when are you going to deposit the remaining?
Now I'll file it in registry.
The learned counsel for the petitioner submits that 5 lakhs will be deposited today. Deposited in the next 24 hours. In that light, the interim order subsisting shall continue till the next date of hearing. Next.
Pleasure.
46.
Petitioner.
Non-compliance.
I'll do that. Overrule ಮಾಡಿದ್ರೆ ಸ್ವಲ್ಪ first time ಅಲ್ಲಿ.
ಕೊಡಿ.
On 3/9 it was overruled if I'm not wrong.
3/9 ಗೆ 6 weeks time ಅಂತ ಇರೋದು overall.
I'll do that.
Office.
That
Interim order ಕೊಟ್ಟಿದ್ದೀನಿ ಆಗ್ಲೇ.
interim order is granted.
Of list the matter after 4 weeks, interim order subsisting will continue to the next date of hearing. Office objections be complied with by the next date. Next.
Much of that.
47.
At last occasion, your lordship was pleased to heard, after filing this petition, my lord, the complainant filed a suit for recovery, my lord, OS number 1425 of 2024. My lord, both of them are the petitioners, are the parties to this, so. My lord, there is an interim order in the connected matter, my lord. In my matter, my lord, there is no interim order. My lord, it is purely, my lord, the real estate, my lord.
Which is your matter, sir?
My lord, my matter.
47, my lord. He's an habitual offender, my lords.
Who?
Pratap Sima, my lords. Accused number.
9376 of 2000.
Yeah, 47.
47.1 is.
Yes, sir. No, it has come up for what purpose, sir?
My lord, for
My lords,
consideration of.
there is an office
Not
objection.
consideration of interim prior at all.
My lord, there is a suit, my lord, filed against
all
me
right,
for
yes.
recovery of the amount in respect of
Just
the same
might not-
transaction.
46 ಅಲ್ವಾ ಇದು? 47.
47, my lords.
47.
47.1, I am appearing. my lords.
You are the bona fide purchaser.
I am the bona fide purchaser as well as
A2,
attesting
my lord,
witnesses are also present.
Is
Are also
A2,
petitioners before your lordships.
is
This
A2.
A1 is the petitioner in 47.
47.
Yes.
1 minute, please.
We'll dismiss that.
My lord, 22 acres of land has been, my lord, registered in their name. Now, my lord, they filed the voluminous of document. I will verify. My lord, now those said there is a suit for recovery against me and also against them. Now, my lord, I have to recover 24 crores from the A4. My lord, I am going to settle. Now, my lord, there are certain anti-social elements are involving. Therefore, my lord, I am requesting your lordship, when the suit is filed for recovery, my lord, cancellation of sale deed also permissible. If there is, my lord, a prima facie, my lord.
All right, we'll post it for admission. We'll hear it.
My lord, the interim order. my lord,
No,
Police, my lord,
not
your
in your
lordship-
case, sir.
my lord, in the last vacation, your lordship, my lord, pass an order not to harass the police, my lord.
Correct, ಅಷ್ಟೇ, that is all that is for you ಅಷ್ಟೇ.
ಅಲ್ಲಲ್ಲ ಇಂಟರ್ ಮಾಡಿ ಇನ್ನೊಂದು ಕೇಸಲ್ಲಿ ಫಿಕ್ಸ್ ಮಾಡ್ತೀವಿ ಅಂತ ಹೇಳ್ತಾ ಇದಾರೆ. That is-
ಮಾಡ್ಲಿ, ಮಾಡ್ದಾಗ ಬನ್ನಿ. Yes. List the matter for admission after 2 weeks.
Entitled for, my lord.
Insofar as my matters.
Both, sir. Interim orders.
Interim order.
Interim order, in any of these cases, subsisting shall continue till the next date of hearing. Next.
Grateful.
Grateful.
But if a date could be fixed, my lord.
No, yes, next.
That order, my lord,
Great.
granted by your lordship may be extended. Not to
Whatever,
harass-
ಎಲ್ಲ
not to harass.
ಏನಿದೆ ಅದು, whatever is there will get extended.
Please.
Next.
Grateful.
Was directed to serve on the trial court counsel, and I have filed a memo for compliance also.
List after 4 weeks, interim order granted earlier stands extended to the next date of hearing.
Office objection.
Office objections comply.
ಮಾಡಿದ-
Furnishing of PF, madam, objections ಅಲ್ಲ. Learned counsel submits needful has been done, office to verify. ಆಮೇಲೆ 4 weeks, next, yes.
Direction was to serve on the trial court advocate.
Whatever, yes, next.
Petitioner. PF pay ಮಾಡಿ.
Pay ಮಾಡಿಲ್ವಾ?
Morning.
Interim order vacate ಮಾಡ್ತಿದ್ದಾರೆ. ಇಲ್ವಾ?
Next week.
2 weeks to do the needful, next.
50.
Office objections,
Order sheet furnish ಮಾಡಿ ಅಂತಿದೆ, order sheet put up ಆಗಿಲ್ಲ.
put up ಆಗಿಲ್ವಾ?
Put up ಆಗಿಲ್ಲ.
ನಿನ್ನೆ.
And for respond number 2, my lords.
Only one objection has been raised.
List after 2 weeks, objections if any
Interim
by
order
then,
kindly be extended.
office objections be complied with by the next date, interim order subsisting shall continue to the next date of hearing. Next.
51.
I represent the.
Respondent number 2, my lord.
The petitioner is accused.
Post immediately after service of notice upon the second respondent.
For respondent number 2, my lord.
Learned
I'll
counsel
file my
so and so submits that he has entered appearance for the respondent. Registry to print the name of so and so is appearing for the respondent. Interim order ಇದೆಯಾ?
Interim ಮಾಡಿಲ್ಲ ಈಗ ಕೊಡ್ಬೇಕು. Notice
ಈಗ
ಹೋಗಿ ಬರ್ಲಿ
ಕೊಡ್ಬೇಕಾ?
ಅಂತಂದ್ರೆ.
ಬರ್ಲಿ, yes.
Notice ಹೋಗಿ ಬರ್ಲಿ.
List on 20th in the fresh matters list, yes.
Please, my lords.
20th.
Next.
Interim application
20th.
for consideration.
ಅಂಥದ್ದೇನಿಲ್ಲ, ಸ್ಟೇ ಅಪ್ಲಿಕೇಶನ್ ಇದೆ ಅಲ್ವಾ? ಇರುತ್ತೆ. Fresh matters.
Fresh matters ಅಂತ ಬಂದು.
ಅದೇ ಹೇಳಿದ್ದೀನಿ.
Oblige.
Respondent number 2, your lord.
Learned
Today only
coun-
filed wakalat, my lord.
Learned counsel so and so undertakes to enter appearance for the respondent. Registry to print the name of so and so is appearing for the respondent.
There is stay against accused number 3, my lord.
The interim order subsisting against any of the accused shall continue till the next
Swami.
date of hearing.
ಇದ್ರಲ್ಲಿ ಸ್ಟೇ ಮಾತ್ರ ಕೊಡಬಾರ್ದು, ಅದಕ್ಕೆ ಒಂದು ಆರ್ಗ್ಯುಮೆಂಟ್ ಬೇಕಾದ್ರೆ ಮಾಡ್ಬಿಡ್ತೀನಿ ಸರ್.
ಒಬ್ರು ಕೊಟ್ಟಿದ್ದೀನಿ ಸರ್.
ಸ್ವಾಮಿ.
ಅಕ್ಯೂಸ್ ನಂಬರ್ 3 ಮಾತ್ರ ಕೊಟ್ಟಿದ್ದೀನಿ, ಬೇರೆಯವರು ಕೊಟ್ಟಿಲ್ಲ. ಅಲ್ಲ,
ಇದ್ರಲ್ಲಿ ತುಂಬಾ ವಿಷಯ ಇದೆ ಸ್ವಾಮಿ ಇದ್ರಲ್ಲಿ.
ಗೊತ್ತಾಯ್ತು. ಅಕ್ಯೂಸ್ ನಂಬರ್ 3 ಮೇಲೆ ಏನಾರು ಇದೆಯಾ? ಯಾರು ಅಕ್ಯೂಸ್ ನಂಬರ್ 3 ಅಂತ ಗೊತ್ತಾ?
ಗೊತ್ತು.
ಅವ್ರ ಮೇಲೆ ಇದೆಯಾ?
ಅವ್ರ ಮೇಲೆ ಇದೆ, ಅವರೇ ಮಾಸ್ಟರ್ ಮೈಂಡ್ ಈ ಕೇಸಲ್ಲಿ.
ಮೈಂಡ್ ಬಿಡಿ,
ಅಲ್ಲಲ್ಲ
ಓವರ್ ಆಕ್ಟ್ ಯಾರ್ದು ಅಂತ. ಮೈಂಡ್ ಎಲ್ಲಾರ್ದು ಇರುತ್ತೆ.
ಅಲ್ಲ, ಇದನ್ನ ಮಾಡಿಸ್ತಿರೋರು ಅವರು ಸ್ವಾಮಿ, ದಯಮಾಡಿ.
ದಟ್ ವಿಲ್ ಸಿ. A1 and A2 ಕೊಟ್ಟಿಲ್ಲ, A3 ಮಾತ್ರ ಕೊಟ್ಟಿದ್ದೀನಿ. A1 A2 ಕೊಟ್ಟಿಲ್ಲ ಏನು. ನೆಕ್ಸ್ಟ್ ಟೈಮ್ ಮಾಡಿ. ಎಸ್.
ಅಲ್ಲ, ಒಟ್ಟು 5 ಜನ ಇದಾರೆ ಸ್ವಾಮಿ ಇದರಲ್ಲಿ.
A3 ಒಬ್ರಿಗೆ ಕೊಟ್ಟಿರೋದು, ಒಬ್ರಿಗೆ ತಾನೆ. ವೈ?
Because he is an advocate. my lord.
ಅಡ್ವೊಕೇಟ್ ಮಾಡಿಸ್ತಿರೋದು.
They have concealed the fact that accused number 3 is advocate and have registered this crime.
ಅದೊಂದಕ್ಕೇನೆ ಅಡ್ವೊಕೇಟ್ ಅಂತೇಳಿ ಅವ್ರ ಬೆನಿಫಿಟ್ ತಗೋತಾ ಇದೆ. ಇದೊಂದ್ರಲ್ಲಿ ಆಗಿಲ್ಲ ಸ್ವಾಮಿ, ಇನ್ನ 2 ಕೇಸ್ ಇದೆ.
ಆಯ್ತು, ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಹಾಕಿ. ಬೇರೆ ಯಾರಿಗೂ
Objection
ಕೊಟ್ಟಿಲ್ಲ ಅಷ್ಟೇ. Yes.
They are pressurizing us to withdraw the civil suits, my lord.
ಅದೇನಾರು
by filing-
ಹಾಕ್ಲಿ ಅವ್ರು. ಎಸ್.
Please, my lord.
ಫೈಲ್ ಅಬ್ಜೆಕ್ಷನ್. ಎಸ್. ನೆಕ್ಸ್ಟ್.
53.
Right, please. So the second respondent. Lords, on the last occasion, your lordships have granted an interim order based on the decision of this honorable court in Ravi Kumar. My submission is that decision in fact comes to my aid. If my lords kindly see Ravi Kumar, if I may just pass on a copy, Ravi Kumar says that even after a B report is filed, the magistrate can order further investigation if he is not satisfied that B report. So if your lordships kindly see, the magistrate very clearly notes that the bank accounts of the accused where large sums of money have been deposited have not been verified by the police and has directed further investigation. That's all the magistrate did. And there's nothing wrong with that.
The order is, my lord, it's neither rejected nor accepted. On that basis, my lord has granted an interim order.
We'll send it back.
When further investigation, it need not be rejected. In fact, 173(8), if your lordships kindly see,
That I
CRPC
know, yes.
very clearly says that further report has to be filed.
B report is not rejected.
It's
Not
neither
rejected.
accepted nor rejected.
No.
It need not be rejected when ordering further investigation.
We'll see.
Only if it is, if cognizance is to
That
be
I know.
taken, B report has to be rejected.
That I'm aware.
My lord,
List day after tomorrow in the fresh matters list.
Request.
can it be on 20th, day after tomorrow? I'm in Dharwad.
All right, 20th in the
20th.
in the fresh matters list.
Grateful, grateful.
54.
What are these IA 1 of 24 and
There are two IAs, one for defreezing and one for stay of proceedings. My lords, what has happened in this matter is A1 and A2 are from Sikkim, my lords. A1 was into real estate. He was looking at potential.
Yes, comment.
My lords,
defreezing?
Please, my lord.
You're ready?
No, my lord.
Till there I will direct defreezement now. If you are not ready, I'm going to direct defreezement.
in fact, my lords, is an FIR which has to go in all, my lords. What has happened is, my lords, A1, A2 in Sikkim, A1 real estate, he looks for potential investors, my lords. A company from Hyderabad would invest 5 crores. Then the project did not go through, 2.8 crores returned back, there's certain due. Then, my lords, instead of in Hyderabad initiating the complaint, the present FIR comes to be initiated at the basis of a person who claims to be a consultant, my lords. Now, on that basis, my lords, there has been freezement of certain accounts. No territorial jurisdiction, entire cause of action.
List on 22nd in the fresh matters list. Yes. We will dispose the matter itself.
Please.
Yes. Avat ready illandre I'm going to dispose it, Harish. Please. Yes.
55.
What direction?
There's already direction passed, my lords, on the previous date.
This court on 22/10/2024 has already considered the application seeking direction and has passed the order. Therefore, the order, the registry to, therefore, IA 1 of 2024 stands disposed of.
Investigation records were called for, my lords, for today.
One Tandira.
Illa, sir. I'll check it in the next.
376/420.
Oh, this is that continuously harassing the employer.
Not the employment. This is, please, that was IA where we had sought for some directions.
Communication of mails, that's all I have not said. Secure investigation papers.
Please, Ben.
Where?
I'll secure.
I have already said so.
Stay is only as regards petitioner 2 and 3. 1, there is no stay.
Let's
I'll secure in the
matter
next.
2 weeks between date coding. 5th December. 5th December.
Please.
Yes. Interim order subsisting will continue to the next date of hearing. Next.
56.
My lords, I appear for the petitioner. The arguing counsel in this matter
That's
is
all
on
right.
her
What are
legs
these?
currently, my lords.
What production of original dispensation? Madam. for
It
the
may be had after
reasons
2 weeks' time,
indicated
my
so and
lords.
So,
Interim orders.
the dispensation allowed, yes, sir.
Could be allowed, madam. The matter requires, it has to be remanded back, madam, because in the order, in the impugned order, there is no discussion made by the appellate courts.
Contrary to Jambu Banda.
Yes, it has to be remanded and it
May
has
be
to
had- It may be had in 2 weeks' time, my lords. My
the
senior
appellate
is on
court
her
may be
legs. at the
directed to decide the application again.
List the matter on 3rd December in the fresh matters list. Yes, next.
Much obliged, my lord.
No time would be granted, madam. On 3rd. On 3rd, no time would be granted.
Please.
Yes. Second is November.
Number 2, fresh matters.
One submission with regard to CL number 57.
Wait, in urgency, no, wait. I'll take that list and come back.
Being spoken to, still number 1.
My lords, appeal for the petitioners in the instant matter, my lords. The lordship, wide order dated 23/4/2024 had stayed the execution proceedings pending before the district consumer forum. However, my lord, it's the execution case number that your lordship, it's not inserted, it's not included in the order sheet. As such, the consumer forum is refusing to stay the proceedings, my lord.
Which date? Order dated
23/4/2024, my lord.
23?
23rd April 2024, my lords. In all of these three connected matters.
1 minute. Yeah, what do you want now?
My lords, the execution case number is missing, my lords, in the interim order. As such, the trial court is refusing to stay the proceedings.
As prayed for ಅಂದ್ರೆ ಏನರ್ಥ?
My lords, we gave the copy of that, even the petition, my lords, but they've actually said, go and get the order modified, my lords. So we filed an IA for modification, seeking insertion of the execution case number in the.
The matter is moved for being spoken to on the ground that the consumer forum has generated some unnecessary obfuscation about the order, which the order does not brood. The order is that there shall be an interim order of stay as prayed for till the next date of hearing. Prayer execution number ilva?
There is, my lords.
The prayer is as follows. If what is stayed is the prayer and the prayer being shown to the consumer forum is not accepted to be a stay, it is ununderstandable what other clarity can be granted. However, in the interest of the litigant, I deem it appropriate to direct, I deem it appropriate that the execution proceedings in number so and so
Yes, my lord. I'll pass
shall
it on.
remain stayed.
My lords, and also, my lords, one more submission, my lords, there's also typographical error, my lords. There was CIRP instituted against the petitioner, corporate insolvency resolution process. However, in the order sheet, it's written as CRP, criminal revision petition.
CRRP. ಅದು ಒಂದು correct ಮಾಡಿ.
There's another correction, my lord. Third matter ಅಲ್ಲಿ, it's mentioned no application filed by bringing in of LRs ಅಂತ ಇದೆ. Should be in the second matter, my lord. WP 2207/8 of 23. In 2207 of 23, respondent is.
Do it one by one.
Please.
ಈಗ ಫಸ್ಟ್ ಮ್ಯಾಟರ್ ಗೊತ್ತಾಯ್ತಾ ಮೇಡಮ್? ಕ್ರಿಮಿನಲ್ ರಿವಿಷನ್ ಪೆಟಿಷನ್ ತೆಗೆದುಬಿಟ್ಟು CRRP.
That's in all of the three matters, my lords.
You have said that in the memo?
I've found three different memos for all of these three respective matters. my
ನೋಡ್ಬಿಟ್ಟು
lords.
ಏನಿದೆ ಮಾಡಿ. ಈಗ ನಾನು ಏನ್ ಹೇಳಿದೆ ಆರ್ಡರ್ ಬರೆದ್ಬಿಟ್ಟು ಆಮೇಲೆ ಅದು ಮಾಡಿ. ನಿಮ್ದು ಮೆಮೊ ಏನು?
ಇದರಲ್ಲಿ 2207/8.
ನೀವು memo
I'll file a
ಹಾಕಿದ್ದೀರಾ?
memo in the counter.
ನೀವು ಹಾಕಿದ್ದೀರಾ?
ಇಲ್ಲ ಹಾಕಿಲ್ಲ.
ಹಾಕಿ ಮತ್ತೆ.
I'll ಹಾಕ್ತೀನಿ.
Yes.
My lord, a date may be fixed.
ಮೆಮೊ ಇದ್ದೇ ಪ್ರಾಬ್ಲಮ್ ಆಗುತ್ತೆ, ಇಲ್ಲದೆ ಪ್ರಾಬ್ಲಮ್ ಆಗೇ ಆಗುತ್ತೆ. Yes.
I'll seek for a date, my lord.
No date,
File my
yes.
statement of objections.
My lords,
Files.
if the interim order may be extended till the next date of hearing.
Interim
my
order
lords.
subsisting will continue to the next date.
Grateful, my lords.
Next.
The only submission is that, my lord, the district consumer court's order has been challenged by your writ petition. It is not maintainable. I'll file my statement of objections.
File it, will dismiss it.
I'll have,
File
just a
it
date
under
may be
220.
fixed.
List the matter on 5th December.
Grateful.
Grateful, my lords.
What is challenge is consumer court's order.
Consumer court's order. On the ground that there were meritorious proceedings and the consumer court could not have passed an order. But the thing is, my lord, you know,
282 ಅಲ್ಲಿ how have you come?
That's why we invoked 227, my lords, because there was moratorium imposed operating
What?
as against the
227?
petitioner, my
File
lords.
ಕೊಡಿ.
it's an appealable order, my lord.
Give the file. Let's tomorrow in the fresh matters list.
Grateful, my lords.
ಎಲ್ಲ ಇದೆ ಮಾಡೋದು. Where is 482 here? What is the crime pending?
No, it's not 482, my lords. We've invoked 227, my lords.
GMI.
27 what's GMI ಇದು?
GM out.
My order is passed in GM, is it?
Please.
GM, yes, my lords.
Sorry. Then barely 5th December, yes.
Grateful.
Date may be fixed, my lords.
5th December.
Grateful, my lords.
Grateful.
Number 2, adjourn till number 3.
No representation, list after 4 weeks.
Number
Next.
4.
Petitioner, my lord. Serial number 4, I am for the petitioner, my lord.
Post immediately after service of notice upon.
The notice has been served, my lord. Yesterday they are intending to on behalf
Wakalat
of
ಹಾಕಿದಾರ
second.
Yes, post immediately after service of notice upon the respondent. Next.
Number 5.
Private complaint has been filed against the wife's relatives, my lord. But the petition number 1 is wife's grandfather's brother's son. And petition number 2 is wife's father's sister.
What is the offense, sir?
Offense, my lord, 143, 448, 323, 352, 504, 506, and 149, my lord. Private
Where is the
complaint.
respondent?
And, I have served the copy to the council before the honorable trial court, my lord.
Maybe. No, ವಕಾಲತ್ತು ಹಾಕಿದ್ದಾರೆ.
ಹಾಕಿದ್ದಾರೆ, record ಇದೆ.
There is no representation behalf the. Sorry. Behalf the respondent, list this matter day after tomorrow in the fresh matters list. In the event the respondent would not be present, this court would be constrained to grant an interim order of stay. Please, next.
Number 6.
The 498A matter, my lords, covered by Achin Gupta is what I was submitting. And my lords was to hear the matter.
Husband.
My lords,
And the family.
it all seven accused. My lords,
I have not stayed again,
no, not yet, because my lords was to hear the matter, my lords.
stayed against any of the accused.
No,
Because there is an allegation of 354 also as
my
against
lords,
the
this is
father-in-law
a
and the other
case, I'm
accused.
sorry, my lords, this is a case, wife says she wants to join the husband. Finally, this is what she has asked in her prayer. So in fact, we wanted to say,
Kindly, they themselves have obtained an injunction order against me from entering the marital home. Kindly see, they have
Not
produced the
set-
injunction order also.
No settlement, is it?
settlement, in fact, my lords,
Allah,
my lords,
354 allegation ಇದೆ, how can there be settlement? 354 against the father-in-law. Kindly
Could
see
I-
the governments which.
Father-in-law.
my lords,
Allah, father-in-law and other
can I
family
make
members.
one request, my lords? The matter may be taken up next week. So far as 2 to 7, let there be a stay.
No.
Husband is A1.
It's all right.
Husband
If
is
there is
A1.
allegation of 354 against the father-in-law, I will not.
No. Against A6, and that too without any force. According to their allegation, he came, he threatened, but did not use force. 354.
ಇಲ್ಲ, threatened ಇಲ್ಲ.
Where is the
Allegation
Kindly,
hai
page number 46.
My lord's page,
One
Page,
minute.
page 46, second
46
paragraph.
second paragraph. Kindly notice whether there is any force in that, my
ಅಲ್ಲ,
lords.
force ಅಲ್ಲ, language ಓದಿ.
Language, alike.
ನನ್ನೊಂದಿಗೆ ಅನುಚಿತವಾಗಿ
Force is a necessary ingredient for 3.
ಪ್ರಯತ್ನಿಸಿ.
No, kindly see, my lord, he is in the.
ನನ್ನ ಗಂಡನ ತಿಳಿಸಾದಾಗ ಅವನು ಅದೇ
ಅಲ್ಲ, ಅಸಭ್ಯವಾಗಿ ವರ್ತನೆ ಮಾಡಿದ್ ನಾವು can there be
ಅದು
any more
three-
detail in that?
ಆಮೇಲೆ
Aste, that's it. That's it, my lords. So if they want to bring
charge sheet
this under,
ಹಾಕಿದಾರಾ?
The charge sheet, why they could not
Charge
find
sheet
this?
ಹಾಕಿದಾರಾ?
No, because there was an order against me from entering the marital home. They, that injunction order also they have produced.
My lord,
Kindly see
kind-
page number
Charge
105.
sheet ಹಾಕಿದಾರಾ?
They have not, because the police were to take me and enter the home. Now that injunction has been vacated.
Ah.
30th, my lord, I am told, my lord,
Sanction is vacated?
that injunction has been vacated. 105.
Vacated, ah?
That 105 order wherein I was barred from entering the marital home
Ah.
has been vacated. That is the urgency why, my lord, now the police were filed charge sheet. That is why they are moving before this.
my
honorable
lords,
court.
could I just,
On 4 occasions, my lord, the matter had come up before this court. There was no stay order granted. I filed my
my
objection.
lords, no stay granted because the matter was to be heard. We said it's covered by Achin Gupta. My lord said 7 dates, we'll see it on the next date anta adjourn madid. My lords, can I point the 7 dates, my lords? Please notice how this gets covered under Achin Gupta.
You mean to say I have to stay against the husband also?
My lords, even if it is not going to be stayed against the husband, 2 to 7, my lords may stay for now. Hear the matter. In fact, my lords, Achin Gupta's case where it is quashed for the husband, I'll be able to demonstrate this stands on the same footing. Alla, illiye. My lord says, my lords, 2 matters my lords has quashed against the husband. Out of the 4 citations we are relying on, my lords, 2 my lords has quashed against the husband.
Sir,
Achin Gupta is third.
Those are on the facts of those
The
cases.
facts, I will be able, my lords, 2014 is a marriage.
You're referring to one where the party in person appeared.
My lords, Vivekananda, the 2 judgments, Vivekananda Darpan, the 2 judgments of my lords were for A1, it's quashed.
Vivekananda, I think it is in Dharwad.
Howd.
Ah.
Then my lords came Achin Gupta, Supreme Court. After Achin Gupta, my lords, in
Vivekananda-
Manja Naik.
Vivekananda, I followed Abhishek and quashed.
Howd, correct. Yes, my lords. Post that came Achin Gupta, where quashment for the husband also. Supreme Courts. Then my lord's judgment in Manja Naik, where other than the husband, my lords quashed for all. These are the 4 judgments, my lords.
That I day in and day out quashed for. But
So,
each
my lords,
each case is different.
my lords, if for the purpose of hearing the matter, if my lords is
No.
have,
We'll hear the matter.
my lords, 2A5 is not even in the country. A2 to A7, it may be stayed for the present. my
ಇರೋದು
lords.
father-in-law.
Father-in-law and accused number 6.
Who is A6?
My lords,
My lord is the,
could I give the allegations, my lords?
No, no. Who is out of the country? Who is
I
out
have
of the,
specified the allegations against each of them.
who
Please
is out of
notice
the
this.
country?
Out of the country is A5, my lords. A5 is out of the country.
ಆಮೇಲೆ
A6 is a person, a student, my lords, who they just pointed out case of
That's all right.
300 and
that will see.
then, my lords,
A7
A7 is a family friend.
ಆಮೇಲೆ
A5 is sister of,
A4, yes, Shivaprasad.
But A4, my lord, is in the country. I'm sorry,
No, no.
A5 is in the country, my lord. A5,
A4 ಯಾರು?
my lords, A4 is sister of the first petitioner, of the husband.
Please don't tell the relation. I'm telling allegation.
My lords, kindly notice, my lords, I've just segregated the
So far as
allegations.
A4
Please
is the-
notice the
See,
allegations.
1 minute, sir. Accused number 1, husband,
Husband,
leave it. Accused number 2,
father-in-law,
father-in-law.
father-in-law ಮೇಲೆ ಏನಿದೆ ಅದೇನಾ?
Apart from that, there are multiple other allegations. also.
my lord,
Father-in-law.
Yes.
ಆಯ್ತು. Next, mother-in-law.
Mother-in-law also, my lord, 498A. There are specific statements made by me saying that,
ಆಮೇಲೆ?
yes.
Yes.
My lord-
Charge sheet ಹಾಕಿಲ್ಲ, complaint ಅಲ್ಲಿ ಯಾವಾಗ್ಲೂ glorify
ಅಲ್ಲ,
ಮಾಡ್ತಾರೆ.
charge sheet ಯಾಕೆ ಹಾಕಿಲ್ಲ ಅಂದ್ರೆ because they were
ಅದಾಯ್ತು, complaint ಇರೋದೆಲ್ಲ ನಾವು we can't take it as truth, we'll see. Yes.
A4,
A4,
sister of A1,
A4 ಮೇಲೆ ಏನಿದೆ?
4 ಅಂತ ಏನಿದೆ.
ಏನೂ ಇಲ್ಲ. Yes. A4.
Barring that one statement saying that, apart from that, this.
A5 sister
Yes,
who's
A5
residing at
498
US.
A5 also 498 is there for this reason. She's staying with the family.
She's in US, my lords. She's in United States.
Kindly see, my lord, for the moment.
She's in US and then how are you saying
No, no.
stay with the
No,
family?
she's here, my lord. Complaint government also is very clear.
Complaint governments, but how do you show that she's outside?
My lord, she's in United States, my
Eh.
lords.
She's in fact staying
I'll give the
opposite to the
document,
house.
my lord, to show she's in United.
Is glorified complaints? No, sir, wait. US ಅಲ್ಲಿ ಇರೋದ್ನು ಜೊತೆಗೆ ಇದಾರೆ ಅಂದ್ರೆ ಹೆಂಗ್ ಸಾಧ್ಯ ಇದೆ? Let him show.
ಅಲ್ಲ,
I'll produce
US
the
ಅಲ್ಲಿ
visa
passport.
copy itself.
Well, let them show, my lord. Let them show when they have resided in, they may hold.
Marriage 2014, ಅಲ್ಲಿಂದ ಈ complaint ಕೊಟ್ಟು just omnibus statements.
ಯಾಕೆ complaint ಅಂತ
That 498A,
Because, my lord,
because an FIR is registered against them comes this complaint. That's why I said 7 dates, my lords, of importance.
We'll hear it, we'll hear it. Now,
The counter blast to mine.
now this
No.
fifth.
in
Yes,
my
Nit-
objections.
Nitya is not
My
in
lords,
the,
page 116, the visa itself, my lords.
Nitya is not in the country.
She's not in the
The
country.
visa does not
My lords,
necessarily mean that
A6
they are staying.
My lords, A6
Let
is,
them show on what dates they have been there.
ಇದು.
All right.
Visa
yes.
ತೋರಿಸ್ಕೊಂಡು ಬರ್ರಿ ಮಾಡೋದು.
ಆಮೇಲೆ next.
My lords, A6 is son of petitioner number 4, a student, which now they're alleging
Against him.
354.
Yes.
That is what they're alleging.
ಆಮೇಲೆ 7 is family.
7 is family friend.
So 4,
No
5,
allegation at all.
4, 5 and 7 will stay. Others will hear.
6, my lords,
But 7.
No, sir.
student,
No, sir.
354.
Correct. Sir.
Ingredient LL.
No problem.
No force.
No worries.
My lords.
No worries. No problem.
Well, accused number 7, insofar as accused number 7 is, he has said that because after the birth of second daughter, this problem has started. The accused number 7 says he has a
My-
daughter,
I'm
He is a
sorry.
family friend, right? He's-
Family friend.
family friend, he is the.
Sir, ನೀವು ಎಲ್ಲ all complainant, whatever she feels, she cannot tell. It should meet the ingredients of 498A. This 4, 5 and 7, I will.
In fact,
say.
even 2 and 3, same, my lords. Nothing. Omnibus statements
That
against
will-
father-in-law,
that-
mother-in-law.
That we'll see. We'll hear it. Heard the learned senior
Vaidranta.
counsel. Heard the learned senior counsel, Sandesh Chowta appearing for the petitioner and the learned counsel Shiva Prasad Shantan Gowda representing the respondent. A perusal at the complaint would not indicate sprinkling offences even against accused number 4, accused number 4, 5 and 7. The accused number 4 is in sister-in-law, na?
Sister.
Howdu, howdu. So the
Sister-in-law.
complainant.
Accused number 4 and 5 are said to be sisters-in-law. And accused number 5, according to the learned counsel for the petitioner, is residing at the United States of America, which is disputed by the counsel for the petitioner. Therefore, the matter would dispute by the counsel for the petitioner, be that dispute as it is. The accused number 7 is said to be a family friend who has some interest in the separation of the accused number 1 and the complainant. Prima facie, those would not meet the ingredients of what the Apex Code describes to be necessary in an offence punishable under 498A, inter-alia. Therefore, there shall be an interim order of stay of the further investigation to accused number 4, 5 and 7. The investigation shall continue till the next date of hearing. List the matter on
So the trial court, my lord, date has been given on 30th. It may be posted after that.
30th.
Matrimonial case where the injunction order was operating against me.
That
How does that
that
matter
has nothing
with
to
this?
do with this. List the matter on 6th December in the
Please.
fresh matters list. But for admission, sir,
Please.
family problem, ಬೆಳಗ್ಗೆ ತಗೊಂಡು
Please.
ಕಷ್ಟ.
Please.
Yes.
Number 7.
Counsel is appearing online.
Jayant V. Who is Jayant V?
I am Jayant. There's an arguing counsel who's appearing online. I believe he's not muted. He's still muted.
ಏನ್ ಅಷ್ಟೊಂದಿದೆ papers?
The Chinese app.
Your Lordship, I am on the line. Am I audible? Your Lordship, may I start the submissions if I am audible?
ಹೇಳಿ sir.
My lord,
ಹೇಳಿ sir.
There seems to be
my
some.
lord, counsel is.
ಅದೇನ್ ಕೇಳಿಸ್ತಾ ಇಲ್ಲ ಹೇಳಿ sir.
My lord, I am a chartered accountant.
Ah.
I incorporate 2 companies.
Ah.
Now, that is where my professional services as chartered accountant comes to an end.
Oh, this is registration of Chinese companies.
Yes.
You're accused number 47.
I'm accused number 47.
Page 153.
Yes, my lord.
Yes.
My lord, thereafter, these 2 companies go give out loans at exorbitant interest, for which now I am sought to be dragged into the case. My professional service comes to an end the moment I have rendered my service.
ಇಲ್ಲ ಇವ್ರದ್ದು ಅದಾದ್ಮೇಲೆ ಏನಿದೆ?
No, but the issue, my lord, that as a chartered accountant, while registering the company, the person has obligation to see whether such company exists and functioning with such in such places. The places in which.
So negligence is the allegation
Yes.
against you.
No,
Negligence.
No, not negligence, my lord. The fact that.
ಅಲ್ಲ, is he involved in the crimes?
No, company itself is not exist in the address.
I'm neither an employee nor a consultant. I only incorporate
If
the
it is
company.
negligence, my lord, we could have understood something else.
May I make some?
Negligence, my lord, then I go, one day I go, it's there, not there. But the fact that in the given address, no company exists.
How did you register the company without verifications?
My lord, I have produced, kindly see paragraph, volume number 4, my lords. Where the
Volume?
volume number 4 that I have furnished.
Volume 4.
Eventually, it was furnished, my lord.
Your Lordship,
Sir, ಅವ್ರಿಗೆ ಇಲ್ಲಿ ಕೇಳಿಸಲ್ಲ ಅಂತ ಹೇಳಿ.
Certainly.
am I audible?
No, sir, you are not audible.
My lord, kindly see the allegations in the charge sheet itself, 154. The primary allegation is that I have not met anyone.
You have not
That-
met anyone.
I have not met the directors, I have not perused the documents, and I have not, and the statement is incorrect. My lord, if that is the case, I should be prosecuted for dereliction of my, as the duty as a chartered accountant.
420 ಹೆಂಗ್ ಬರುತ್ತೆ ಇವ್ರಿಗೆ?
Let I have come, my activities completely stopped after incorporation.
What is the allegation against 420, right?
My lord, 420 and
What is the
certain,
specific allegation against you?
my lord, that is the only allegation against me, that I have not verified the documents, I have not met them individually. Which means I have not conducted my duties as a
Ah.
chartered accountant, for which I am liable for prosecution
Let me
under the.
417, 419, 420, 384 ಇದು ಯಾವ್ದು ಬರಲ್ಲ. 120B, maybe.
120.
Maybe. ಅದು direction of duty.
Please do I want
120, my lord, the
If
causal link is
if the
to.
petitioner has not done this registration, the company could not have been existed. Now, this is, my lord, one of the cause where multiple people have been forced into, cheated into, and all those things have done. The source is this.
Let's see. Yes. We'll hear the matter.
Yes, very well. As on today, there is no stake way accused.
No, stay, no. Sir. Yes. List the matter on 5th December. Yes.
Thank you.
Number 8.
Appearing for petitioner. Page 14 is the complaint against the.
Yes, sir.
Against the director of the cooperative bank. My lord, one Sudhir Subbanna, my lord, has taken a loan and mortgaged his property.
And my lord, he has sold the property to the petitioner's mother's sister. And he himself has drafted the sale deed without verifying, my lord, the uh, original documents.
You're accused number 1 now.
Yes.
Ah.
Absolutely nothing, my lord. If you read the complaint as it is, my lord, there is no case is made out.
Yes, sir.
My lord, if I may be
Tell me, sir.
permitted, my lord. Yes, my lord. My lord, this demands investigation for simple most.
Not according to you, tell
Yes,
me
my lord.
according to law.
Yes, my lord.
Ah.
Page number 49, my lord.
Ah.
EC. It clearly states the said.
This man is 84 years old. What has he done?
Yes, my lord.
Ah.
The man has established a bank and he's been the founding president of the bank and
Who?
uses the bank.
petitioner?
Jai Prashad Shetty, yes.
Ah.
Uses the bank to reroute the funds, and it's been proven in multiple FIRs, my lord. There is not only this matter, other than this, there are other 2 FIRs in which Butts Act.
Filed your objections?
Yes, my lord.
Yes, my lord. He
Yes,
has
my lord.
filed.
In the statement of objections, my lord, if I may draw to page number 8 of the statement of objections, para number 4, my lord. Anand H, complainant in FIR number 221/2023, FIR number of the same Chandra Layout Police Station against the petitioner, has established that there was a connivance between Sudhir Subbanna, who is the real estate conniver. The bank is established by this petitioner, Jai Prashad Shetty, my lord.
All right.
He has the same real estate holding called as Prasad Nesara,
All right.
for which he uses this bank to bring innocent people, give them loans, and they evergreen loans. And after evergreening of loans, this Sudhir Subbanna and he basically share it. Now this Sudhir Subbanna, my lord, he is not in country. He has fled the country. The police is after him, not only in one FIR, but multiple FIRs, my lord.
Right.
So my humble submission to the court is, let the investigation carry on.
I have not stayed investigation.
Yes, my lord. Yes, my lord. But please, time-bound investigation, my lord. That they are very powerful people, my lord, and it's a case of misappropriation of public
What investigation have you done till now?
I'll have to secure records.
No, my lord, may I kindly,
Completed.
kindly, my lord, permit me to read the complaint.
Yes, sir.
Kindly see, my lord, para 2.
Complaint sometimes is not an encyclopedia. Let the investigation.
No, my lord, see, what is the case made out, my lord, against me? They have lent money to somebody and they have not recovered. My lord, he has purchased the property. My lord, without verifying my lord, bank has already taken the steps, my lord, to under the Cooperative Societies Act to recover the money.
I am ready.
Without, my lord, without verifying any of the document.
Let the investigation papers come, sir. Yes, the learned HCGP to secure the investigation. ಯಾವ crime register ಆಗಿರೋದು ಯಾವಾಗ?
ಇದು 2024
January, my lord.
January.
Investigation ಮುಗ್ದಿರ್ಬೇಕು ಎಷ್ಟೊತ್ತು. Learned HCGP to secure the investigation papers and place it before the court on the next date of hearing, 6th December in the fresh.
Grateful, man.
Yes.
My lord, may I request, my lord, for the stay of further proceedings? My lord, absolutely nothing has been done by him.
We'll see. Sir. Let the investigation come. Yes, next.
9.
My lord, humble submission, my lord. Submission.
9 ಅಲ್ಲ.
9 ಅಲ್ಲ, sir. 90, serial number 97, specific time has been given by your lordship. 4 PM matters ಅಂತ ಕೊಟ್ಟಿದ್ದಾರೆ. Senior counsel Prashant Bhushan is waiting. Serial number 97.
First list.
First list.
First list.
Electoral bond case.
Further hearing at 4 PM. ಯಾವ್ದು ಎರಡಿದೆ?
See that the allegation in the complaint, my lord, is one of extortion. Electoral bonds that.
Okay, yes, yes. Because yesterday's absence has created.
I know, my lord, I understand,
chaos.
I understand. My lord.
We'll see, we'll hear that then. We'll finish. Time ಕೊಟ್ಟಿರೋದ್ರಿಂದ we'll take that. ಬೇರೆ time, ನಿಮ್ದು ಯಾವ್ದು madam?
Lordship, second list, the
Which is
ninth
yours?
matter that was called out.
Serial number 9. No, no, no. He's mentioned it out of turn.
Oh, she mentioned it.
No, no, this colleague, he's
Oh,
mentioned.
you mentioned. it. Oh, you are mentioned.
But may not be over now.
Available, my lord, whenever your lordships are.
Yes, madam. Prashant Bhushan, sir.
You are on mute, sir.
Yes,
Yes, my lord. I'm here. We have filed our counter affidavit.
Yes, sir. So should
And,
we hear it, should we hear it now because it's already 4:40? Or take it day after tomorrow?
If you're, no, day after tomorrow,
Or
maybe
on 20th?
20th is Wednesday.
Wednesday.
20th should be all right. 20th.
All right. 20th, I'll post it at 2:30. Please remind at 2:30 itself.
All right, okay.
Yes, because it's already 4:40 and the list is still long.
All right, all right, all right.
That's all right, sir. 20th?
20th is fine with me.
Yes, sir.
Very.
Due to paucity of time, the matter could not be taken up. I heard so and so Madi, Prashant Bhushan sir, yes. Matter could not be taken up. List this matter on 20th at 2:30 p.m. Please remind at 2:30 itself on that day. Yes.
I am obliged.
Yes.
And of course, my lord, interim order.
That will go.
Take it.
Yes.
Serial number 9. Lordship, page 10. Lordship,
Serial number 9, page 10.
Page 10, please. Civil dispute with respect to return of amount. And your lordship here,
Yeah, last time like it.
your lordship, this had come out initially, come up on the first hearing. After the 2 hearings, your lordship, for paucity of time, it was kept today.
Paucity of time.
Your lordship, entire pleadings in page 10.
1 minute. ಎಷ್ಟು amount?
Your lordship, she claims that about 8 lakhs is due.
Yeah,
With respect,
ವಾಪಸ್ಸು.
please, your lordship, with respect to,
Give it back.
with respect to the petitioner, who's the wife, your lordship may kindly see at line 5 and 6, at page 10 itself. Line 5 and 6 is with respect to the petitioner.
All right. Accused number 2 now. All right, yes.
Your lordship, might I
But
pass?
that would inure to the.
Might I pass this on, your lordship? What has happened is, in the police station itself, this amount was returned, 1 lakh check, 1 lakh cash, in the presence of the IO, and the check is credited, the cash was also accepted. That is with respect to the petitioner here.
The remaining money?
The remaining money, your lordship may kindly go to the last but 4th line in para 10. This is with respect to the husband.
All right.
Now, she claims that this property that was to be registered in her favor, right now, some Somashekar has also been given some right in it, which is not true. As of tomorrow itself, he is willing to register it in their favor. Conveniently, they do not want to proceed with registration. They are worried about a specific performance filed by this husband. Now, they don't want to go and register this, and
Heard the
they're
learned senior counsel Lakshmi Engar appearing for the petition. The crux of the complaint lies in its last 4 lines. It reads as follows. It is registered for recovery of money. Setting criminal law into motion for recovery of money cannot be permitted in the light of the judgment of the apex court in the case of Lalit Chaturvedi source 179, 171, 24. The learned senior counsel would also place on record that that certain amount has already been returned to the complainant insofar as the transaction between the husband and the complainant. Husband of the
insofar
petitioner and
as
the
the
complainant.
petitioner, the wife and the complainant.
Wife and the complainant.
And the second document is the sale agreement.
Wife and the complainant, that would be between the petitioner, accused number 2 and the complainant. Therefore, there shall be an interim order of stay of further proceedings with the petitioner in the next date of hearing.
Your lordship, difficulty here is, your lordship, the petitioner, she's been a constable for the last 12 years, and her promotion as head constable is due this month in the list, your lordship.
Retrospective effect will get everything. It will be kept in sealed cover.
Might I request?
If you are in the zone of consideration, it will be in the sealed cover. After this order is passed, sealed cover will be opened and retrospective promotion with all benefits will be
She's
given.
not even given 50% of her salary with a 3-year,
That is
she has to
suspension.
manage, your lordship.
Suspension.
Please, your lord, as of this case, your lordship, there's nothing else,
That's
no
a different
history.
cause of action.
I understand your lordship. Might I only request that,
Subsistence allowance 50% should be given.
lordship, if it may be.
I have
quashed, then
stayed.
I understand your
Yes.
lordship. Any early date,
That we'll see. Yes, 12th,
please,
Yes.
obliged,
12th December.
obliged.
Next,
Number 10.
post immediately after service of notice upon the second respondent. Intermodal idea, idre continue. Next, please.
7.
11, I represent the petitioner, my lord. But on the last date of occasion, my lord, learned SPP made a submission that final report is ready.
Yes, additional SPP to secure investigation.
Ready.
And it was stated that
Final report
except
is
accused
ready to
number
be
one,
filed,
my
ಏನು?
except accused number one, my lord, rest of the
In the
petitioners
investigation
ಮೇಲೆ
stage.
B report ಆಗ್ತೀವಿ ಅಂತ ಏನೋ submission was made.
ಇನ್ಮೇಲೆ ನೇಮ್ ಬರೆಯಕ್ ಸ್ಟಾರ್ಟ್ ಮಾಡ್ಬಿಡ್ತೀನಿ. ನೀವು ಎವ್ರಿ ಡೇ ರೊಟೇಟ್ ಮಾಡ್ತೀರಾ?
After record, I have told my lord that it appears to be case against only against accused number one, not against.
That last time you told us.
That's exactly. I get it.
I list the matter on 29th. Yes, next.
12.
Lord, the offense is under 427 and 47, my lord. Under BNS, my lord, 424, 5, 493, 329 and 3, my lords. Earlier, my lords, the relative of the petitioners has filed one case and it has been stayed by this honorable court just 2 months back, my lord. Afterwards, another person came in possession. Tell that it is in his
Yes.
possession.
The findings in the suit for cancellation of an agreement under issue number 1 was challenged in the RFA, and the RFA has been admitted and stayed by this honorable court.
Now then we will
Now
stay
what
this.
has happened is, as far as this complaint is concerned, he has started writing on the wall and saying, thinking that there is a finding in his favor and issue is in his favor. Now, though compromise has taken place already in 2008 itself, he has given up his rights in this property, my lord. Despite that, my lord, he wants to now make use of that finding on a cancellation, a suit for cancellation of a sale agreement. He wants to make use of that and trespass into the property.
Yes, sir.
My lord, their allegation is, sir, we are trespassing to the property survey number 104/1. That is aerodrome property. My lord, 2 months back, just 2 months back, another person comes to, that is my relative, and so it is in their possession. The sign are not requirement.
Now
that
there
it
is
has
an
to be
RFA
possession.
pending.
Yes, my lord.
RFA is something else, my lord.
RFA same property, same
All right,
finding.
file your objections.
Yes, ma'am.
In the meantime, my lord, because,
In the meantime, I have not granted earlier. Yes.
my lord, sir, in the first time,
Learned senior counsel representing the respondent so and so seeks 2 weeks time to file statement of objections. Objections, if any, by the next date. List on 12th December.
maybe tagged along with the 5415 of 2020.
Tag the petition. Adral stay idea.
No,
It
ನಮ್ಗೆ
is there, my lord. Same property.
No,
It cannot
no.
be two person cannot be in possession
No,
at the same time.
we are not parties to
2
that.
months back.
We are
In
not
that
given
stays there.
notice.
There stays there.
We are not.
How is that connected to this?
Same property. Same property.
Tag this petition along with so and so.
Let him give a
The
copy
learned
of the.
counsel submits that there is an same complainant.
Same,
Illa.
no, another complainant.
That's
says
what
that
I'm
it is
saying.
their
We are not.
possession. 2 months back, another person came.
He
said
gets
that
it
is in his
filed
possession.
probably and got a stay order.
The
It's all set up.
learned counsel for the, but that's a different complaint, right?
Yes.
No, my lord, different property. There cannot be two person in
That's all
possession.
right. List on 12th December, tag the petition along with so and so.
In the
Yes.
meantime, stay may be granted by lord.
On
Because
that
my
day,
lords,
on that day, yes.
it will be, my lords, a civil proceedings taken to criminal.
On
my
that
lords.
day, sir. Yes,
Yes.
next.
Maybe in the fresh matters, list, my lord.
Fresh matters. Next. ಬಂದಿದ್ಯಾ? ಅಲ್ಲ ಬೇಡ ಇದು ಮುಗಿಸ್ಬೇಕು. ಇದು ಎಲ್ಲಿದೆ? We'll finish this. Fresh matters ತಾನೇ ಇರೋದು.
13, 16 and 17 are connected, my lord.
We'll hear it another day, no time now.
And my lords, the entire charge sheet may have to be produced. They've sought for quashment of the charge sheet, but the charge sheet is not produced.
Produce it.
Case
I
of
produce the materials also. I produce the head of.
entire charge sheet we need, my lords. There's certain
produce.
materials.
Then counsel for the petitioner is directed to place on record the entire charge sheet on the, on the next date of hearing. Take it on 22nd. Yes, based on 22nd. Next.
14.
Case and counter case. my lords.
Charge sheet is ready to be filed, your lordship.
Challenge ಮಾಡಿ. Yes,
Liberty to file for press.
yes, sir. Next.
15.
Bona fide purchaser agreement holder has filed the case against the agreement.
Why do you get your client here? Why do you bring your client to the court? Settlement?
No settlement.
And then
See, agreement holder.
Why do you get the client? Is he your client? Why do you get him? Why do you get him?
No, no, because he
Then-
was carrying my file because I was in the. other
Carrying your file, ತುಂಬಾ ತೂಕ ಆಯ್ತಾ? Yes, ಆಮೇಲೆ
So
ಹೇಳಿ.
I entered into agreement and as he failed to perform his part of, I also filed suit for specific purpose. In the meanwhile, complaint says that he entered into agreement with the owner earlier and he has filed suit. And according to owner has filed.
ಇಬ್ರು ಸೂಟ್ ಹಾಕಿದ್ದೀರಾ ಈಗ?
My vendor executed sale agreement
One
as a power of
HCP
attorney.
to emergent notice in the meantime, next. Stayed, yes.
18.
Now you can give that heavy file to your client. Yes.
18.
Petitioner.
The same as 13. 18.
Same as?
18.
Same as what?
That incident not at all been happened because one of the deposition.
ಜೋರಾಗಿ ಮಾತಾಡಿ,
Actually-
ಇಟ್ಕೊಳ್ಳಿ. Speak on the mic, sir.
My lord, that incident not at all been happened. The complainant only been deposited one of the copy. That I have got only Xerox. I'll submit the certificate
ಏನ್
copy, my
ಹೇಳ್ತಾ
lord.
ಇದ್ದೀರಿ? Time ಬೇಕಾ?
Yes, my lord.
Your lordship may recall, this is the case where partly disabled child was subjected to sexual assault. His submission was PW1 and PW2 were turned hostile.
And also they are not supporting that prosecution, my lord.
No, they are not.
Together with
Your lordship
that,
may see the deposition which is there.
They have not turned hostile.
No, they are not turned hostile.
that Xerox is there. I'll submit. Kindly pass over, my lord. This copy I'll submit a certificate copy, my lord. I think it's 1 week time.
No,
In fact, I think they is given a certified copy
But
of
they
the
only-
deposition, my lord, your lordship may have.
My lord, page number, kindly may see that page number 72,
ಇದರಲ್ಲಿ
my
ಯಾವ್ದು
lord.
ಕೊಡಿ?
Last paragraph.
That one stray suggestion which was made to her, based on that, they say the PW1 and 2 not supported.
ಓ, ಇದು ಬೇಲ್ ಕೊಟ್ಟಿದಾರಲ್ಲ ಆ ಕೇಸ್.
Yes, my lord, yes. Kindly see page number 72, my lord, the last paragraph. May I read, my lord?
72.
72, yes, my lord.
Ah.
That memo of copies.
Ah.
ನನಗೆ ನೆನಪಿನ ಶಕ್ತಿ ಇದೆ. ಕಿಟ್ಟಪ್ಪ ನಮ್ಮ ಊರಿನವರಾಗಿರುವುದರಿಂದ ನನಗೆ ಆತ ಗೊತ್ತು. ನಾನು ಮತ್ತು ನನ್ನ ಅಕ್ಕ ನಿನ್ನೆ ಮೊನ್ನೆ ಆಟ ಸಾಮಾನಿನಲ್ಲಿ ಆಟವಾಡುತ್ತಿರುತ್ತೇವೆ. ನಾನು ಮತ್ತು ನನ್ನ ಅಕ್ಕ ನಮ್ಮ ಮನೆಯ ಹತ್ತಿರವೇ ಆಟವಾಡುತ್ತೇವೆ. ಬೇರೆ ಎಲ್ಲಿಗೂ ಹೋಗಿರುವುದಿಲ್ಲ. ಕಿಟ್ಟಪ್ಪ ತುಂಬಾ ಒಳ್ಳೆಯವನು. ಅವನು ನನಗೆ ಏನೂ ಮಾಡಿರುವುದಿಲ್ಲ. ಕಿಟ್ಟಪ್ಪ ನನ್ನನ್ನು ಮನೆಗೆ ಕರೆದುಕೊಂಡು ಹೋಗಿರುವುದಿಲ್ಲ. ಕಿಟ್ಟಪ್ಪ ನನಗೆ ಯಾವುದೇ ತೊಂದರೆ ಕೊಟ್ಟಿರುವುದಿಲ್ಲ. ಕಿಟ್ಟಪ್ಪನನ್ನು ಆತನ ಮನೆಗೆ ಕರೆದುಕೊಂಡು ಹೋಗಿರುವುದಿಲ್ಲ. My lord clearly says that. Together with that, the complaint itself says that the contradictory statement means indistinguishable statement, page number 2 and page number 9, my lord. In the complaint, they said that one of the statement. In the 164 statement, they said that one of the statement. This is very indistinguishable. The reason is why they've been complained with the things that ಅವ್ರಿಗೆ ಹೊಲದ ಹತ್ರ ಏನೋ ಇವ್ರ ಹೊಲದಿಂದ ಅವ್ರ ಹೊಲಕ್ಕೆ ಹೋಗ್ಬೇಕು ಅಂತ ಹಳೆ ಏನೋ ದ್ವೇಷ ಇಟ್ಕೊಂಡು ನಿನ್ಗೆ ಜೈಲಿಗೆ ಕಳಿಸ್ತೀನಿ ಅನ್ನೋ ಒಂದೇ ಒಂದು ಉದ್ದೇಶ ಇಟ್ಕೊಂಡು ಇದ್ ಮಾಡಿದ್ದಾರೆ my lord. After that, once they came to know that they've been even this, for that reason we been.
ಎಲ್ಲಿದೆ?
Statement, of course, the one suggestion she said, she has not nodded anything. Otherwise, she says that he's taken me to the bathroom, ಕರ್ಕೊಂಡು ಹೋಗಿದ್ದಾನೆ, ಬಟ್ಟೆ ಬಿಚ್ಚಿದ್ದಾನೆ.
ಎಲ್ಲಿದೆ ಅದೆಲ್ಲ?
In the deposition only she says. In fact, this, because she's disabled, 164 statement should be treated as evidence. And subsequent to that, my lord, that statement has been, of course.
A statement given by the complaint, my
Again,
lord.
caution
After they
ಕೇಳಿದ್ರಾ?
came- Yes, my lord.
Caution
Completely. The incident not at all been happened, my lord, because intentionally they did, because of that reason. And FSL report, entire things been denied. Not at all been detected, even single article.
No, this is the case that
Of course.
it is a 13-year-old child
Yes,
who is
ma'am.
disabled and you
Yes,
have
but
48
even-
years indulging in sexual assault on the child.
My lord, ಅಕ್ಕಪಕ್ಕದ ಮನೆಯವರಾಗಿರೋದ್ರಿಂದ.
Mentally retarded child ಮೇಲೆ ಮಾಡಿದ್ದೀರಾ ಅಂತಲ್ವಾ?
Yes.
My lord, mentally retarded child ಮನೆಗೂ ಹೋಗಿಲ್ಲ, ಅದು ಹಾಗೆ ಇನ್ಸಿಡೆಂಟ್ ಆಗಿಲ್ಲ my lord. Incident ಆಗಿಲ್ಲ my lord. If it is happened like that, so I am ready to agree with that things, but incident not at all been happened. However, they have been complained. That statement only shows that clearly.
164, my lord, that 164 statement should be treated as evidence in where mental disability is there.
ಅದೆಲ್ಲ ಮ್ಯಾಟರ್ ಆಫ್ ಎವಿಡೆನ್ಸ್. 482 ಕಾಸ್ಟ್ ಮಾಡಕ್ಕಾಗತ್ತೆ.
My lord, mentally disability ಅಂತ ಹೇಳ್ತಾರೆ my lord. Deposition ಅಲ್ಲಿ ಎಲ್ಲ ಗೊತ್ತು ಅಂತಾನೆ ಹೇಳ್ತಾರೆ my lord. Read that deposition. Clean ನನಗೆ ಗೊತ್ತು ಅಂತಾನೆ ಹೇಳ್ತಾರೆ. But of course, even if you consider that also, the complaint statement itself, it is indistinguishable. Complaint ಅಲ್ಲಿ ಒಂದ್ ರೀತಿ ಹೇಳ್ತಾರೆ, 164 statement ಅಲ್ಲಿ ಒಂದ್ ರೀತಿ ಹೇಳ್ತಾರೆ.
ಅದೆಲ್ಲ ಎವಿಡೆನ್ಸ್. 482 ಪಾಸ್ ಮಾಡಕ್ಕಾಗತ್ತೆ. ಇಲ್ಲ ತಾನೆ?
No, my lord. They only, they said, I'll put the deposition, my lord. I'll read this, my lord.
Anyway, you ಅಲ್ಲೇ ಮಾಡ್ಕೋಬೇಕಲ್ಲ, dismissed.
Kindly consider these points on the trial court.
482 allegation is a 48-year-old man had sexual assault on a 13-year-old mentally retarded child.
My lord,
You must be a pervert.
incident itself not at all been happened, my lord.
That
At
is the
least-
that was the allegation. That is the allegation.
My lord,
482 ಪಾಸ್ ಮಾಡಕ್ಕಾಗುತ್ತಾ ಸರ್ ಈ allegation? You will be acquitted if there is nothing. Leave it.
kindly consider all these points like that.
Yes, dismissed. We'll see. We'll consider
Dispose
all
with
that.
considering
Dismissed
all
sir.
this within
ಏನು
limited time ಆಗ್ಲಿ ಸೊಮ್ಮೆ within the time ಆಗ್ಲಿ ಇದು consideration. ಈ ಪಾಯಿಂಟ್ಸ್ ಏನಿದೆ
ಡಿಸ್ಮಿಸ್ ಮಾಡಿದ್ದೀನಿ ಅಷ್ಟೇ.
ಅಲ್ಲ some
No sir, I am not going to entertain. Yes.
19.
But petitioner is arraigned as accused number 5.
ಏನಿದೆ?
13(1)D, my lords. My lords, this is a case where petitioner is a member of one cooperative society, my lords. He made an application for allotment of a
Latif.
site. There's a suit which was filed, suit is compromised.
Dole, all these matters on 27th we have posted. Please post it on 27th. If it doesn't come that day, we'll grant.
Please,
ಎರಡು
19 and 21.
19 and 21 both. Yes. 20,
Number 20.
Surendra.
We'll argue in detail.
ಏನು?
The date may be fixed, my lords. I'll argue in detail.
ಸ್ಟೇ ಇದೆ ಇಲ್ಲಲ್ಲ?
ಇಲ್ಲ.
28 fresh matters. Next.
22.
All the witnesses were hostile, my lord. The accused persons are already waiting.
Split up.
Split. 114, page 114, para 9.
23rd fresh matters. ಅವತ್ತೆಲ್ಲ ಸ್ಪ್ಲಿಟ್ ಎಲ್ಲ ಅವತ್ತು ಹಾಕೊಂಡಿದ್ದೀನಿ. Yes.
23.
For the petitioner, your lordship, petitioner is arraigned as accused number 9 in crime number 48 of Mangalore North Police Station, lordship. The crux of the matter, your lordship, is that the accused number 1 proposed a business proposal to the petitioner about a business in precious metal.
Yes, madam.
Impersonated as military officers.
Get the investigation papers. 20th fresh matters. Investigation papers be secured by them.
Till then, investigation against accused number 9 may be.
Let the investigation papers come. Yes. These are all leftover cases where I have not granted stay.
No,
That's
this
why
is
they've
a
come up
different
here.
case wherein I have only procured loan, your lordship.
We'll see, yes.
24.
B report is ready, your lordship. It's set to be filed.
The report is ready to be filed.
Please,
Heard the learned
it
senior.
requests.
Heard the learned senior counsel PP Hegde appearing for the petitioner. ನಿಮ್ ಭಯಕ್ಕೆ ನೋಡಿ B report Yes.
No,
ಅದನ್ನ
no,
ರೆಕಾರ್ಡ್ ಮಾಡಲ್ಲ.
No,
They'll
because
be in
it's
a
purely
fixed
civil
summary.
dispute. Then now the police understood the tenor of the orders of the small court, man. Now it's resulting, giving result.
List on 21st.
Please.
21st. 21st in the fresh matters list. We'll close. ಅವತ್ತು ಗೊತ್ತಾಗುತ್ತಾ madam? B report. ಅವತ್ತಲ್ಲಿ ಹಾಕಿಲ್ಲ ಅಂದ್ರೆ we'll close it on that ground.
Please. Grateful.
25.
To appear for the petitioner in this. Black Magic Act, my lord.
Promise to marry Black Magic Act and
Ah.
Star car.
Yes, sir.
Lord, the entire charge sheet, my lord, at 3 to 4 places, my lord, the police.
I've heard you on the last occasion.
This was moved at 2:30, my lord, sir. Lordship posted it today for fresh matters. Yesterday it was posted, my lord. So today
Yesterday I
it is
was not fitting. Yes.
Not the allegation is for rape, extortion as far as black magic. my lord. So the first
And,
is that, my lord,
ಅದೇ ಪೂಜಾರಿ
Pooja, that,
ತಾಯ್ತಾ ಥಾರ್ ರೌಂಡ್ ಅದೇ ಅಲ್ವಾ?
Lord, the charge sheet, my lord, at 3 places clearly the investigating officer states that.
She is an
there's no-
employee of the Infosys.
Yes,
Ah,
there is no material that is available in the, for evidence for the charge sheet, my lord. Now, your lordship judgment is also there, my lord, as regards black magic.
Black magic is all right.
Alala, the allegation is that I've given one lemon and one stone, my lord.
Ah.
So the schedule to the black magic, my lord, I'm not in performance or I'm not beating or I'm not exorcising.
Black magic ಬಿಡಿ ಪರವಾಗಿಲ್ಲ ಬೇರೆ ಇದೆ.
Alala, the whole allegation is that she's virtually if the entire complaint is read, my lord, it is that because of the black magic, she is consented for sex with me. So this is the kind of black magic if I am able to dislodge, my lord. The rest of the case is easy for me. In the entire charge sheet, my lord, no material, no recoveries. Nothing is forthcoming in the charge sheet. my lord.
All right, we'll hear you.
Tomorrow, my lord.
Tomorrow not possible.
Interim bail is expiring on 24th. There was some urgency. That is why I requested this.
Oh, interim bail 24th,
24th. Any day before that.
20th ತಗೊಂತೆ.
I create fresh matters.
List on 20th in the fresh matters list.
Great.
Interim bail, oh, this cancel.
Cancellation.
You had some problem. Yes, yes. All right.
No material, sir.
ಅದು ಪ್ರಾಬ್ಲಮ್ ನೋ ಮೆಟೀರಿಯಲ್
ಅಲ್ಲ ಅದಕ್ಕಿದೆ ಸರ್ ಇದರಲ್ಲಿ ಏನಿಲ್ಲ
ಅದಕ್ಕಿಲ್ಲ ಸರಿ
ಮಚ್ ಆಫ್
proceedings under PC Act, my lord. Motivated proceedings, my lord. If you look at page 22.
13(1)(b), 13(2).
ಹೌದು.
ಚಾರ್ಜ್ ಶೀಟ್ ಹಾಕಿದಾರಾ?
ಹಾಕಿಲ್ಲ.
ಸರಿ. ಅದು ಯಾವತ್ತು ಹಾಕಿದೆ ಮೇಡಮ್? List on 27th, the respondents are restrained from filing the charge sheet if not already filed.
Not filed.
Learned counsel BP Patil is directed to accept notice for the respondent petitioner to serve set of papers upon the aforesaid counsel. The ಎಲ್ಲದರಲ್ಲೂ common order. Yes, next.
27.
Husband.
Husband ಇದಾರೆ 2 to 5 my lords are in-laws. The last occasion, my lords, 2 to 5, it was stayed. Thereafter, my lords, they filed charge sheet. That is why I withdrew and my lords.
Oh, ಅದ ಈಗ husband ಇದಾರೆ ಇದರಲ್ಲಿ?
Husband ಇದಾರೆ.
Except husband in the meantime 2621. Yes.
2 to 5.
2 to 5 ಮಾತ್ರ. Individual. Husband ಅಲ್ಲ. Yes, next.
8.
Yes, madam. Complaint petition, my lord. The complaint lodged against the owner as well as the supervisor of the swimming pool, my lord, they are not maintained. The son was drowned in this.
Why do you get the client here? Settlement case ಆಯ್ತು.
ಇಲ್ಲ ಸುಮ್ಮನೆ.
ಮತ್ತೆ?
ಅಲ್ಲ ಬಂದಿದ್ರು ಬೆಳಿಗ್ಗೆ.
ಇಲ್ಲ ಬಂದಿದ್ರೆ ನೀವು ಆರ್ಗ್ಯೂ ಮಾಡ್ಬೇಕಾದ್ರೆ you want to support is it?
ಅಲ್ಲ ನಾನು ಇದು ಮಾಡ್ಲಿಲ್ಲ ಅಂತ ನಡೆಸ್ತಾ ಇಲ್ಲ ಅಂತ ಅವ್ರು ಬಂದಿದ್ದಾರೆ.
ಅದಕ್ಕೆ ನಡೆಸ್ತಾ ಇದೀನಿ ನೋಡಿ ಹಿಂದೆ ನಿಂತ್ಕೊಂಡು.
ಅಲ್ಲ ಇಲ್ಲ ಅವ್ರು ಬಂದಿದ್ದಾರೆ ಆಕೆ ಎಷ್ಟು ದಿವಸ ಆಯ್ತು ಸ್ವಾಮಿ ಹಾಗೆ ಅಂದ್ರು.
ಹಾ ಅದಕ್ಕೆ ನೀವೇ ಬಂದು ನೋಡಿ ನಾನು ಹಿಂದೆ
ಇಲ್ಲ
ನಿಂತ್ಕೊಂಡು. Yes.
They are not followed the rules and regulations of this.
304A sir.
304 ಮಾಡಿಲ್ಲ ಸ್ವಾಮಿ.
304 ಮಾಡಿದಾರಾ?
ಮಾಡಬೇಕು ಅಂತ
ಮಾಡಬೇಕು.
ಕಂಪ್ಲೇಂಟ್.
Why 304 ಮಾಡಿ ಮೆನ್ಸರಿ ಎಲ್ಲಿತ್ತಲ್ಲಿ?
ನೀವು
ಕಂಪ್ಲೇಂಟ್.
ಹೌದು. Even the
ಏನಾಯ್ತು ಹೇಳಿ?
even they are not intimated to the police, my lord, regarding the unnatural death in the swimming pool, my lord.
Who died? Your son?
Yes, 17 years, my lord. You must kindly.
Yes sir. Why is not done?
Annexure F, my lord.
304A ಮಾಡಿದೀರಾ? Who was 304 ಅಂತಾನೆ ಇದೆ ಇಲ್ಲಿ? FIR was registered for 304.
304. 2 eyewitnesses.
No. For 304, you need mens rea. And he should have the knowledge that this is going to cause death. 304 language note.
Therefore, my lord, you must kindly see that they are not arranged the safety measures.
So you should know that he is going to die out
Yes,
of that.
you must kindly bear with me. Annexure F, my lord, swimming pool safety plan, my lord, annexure F, page number 90. Safety plan 91. So, safety plan content procedure to be followed in the event of serious injury, emergency, or incident. Pool operators are expected to develop procedure to be followed in the event of
ಈಗ ಯಾರು
serious.
who was pool operating the pool?
A1 is the owner of that pool, my lord. A1 is the supervisor. A2 is the proprietors. ಅಲ್ಲಿ ಬಿಟ್ರೆ ಆಪರೇಟರ್ಸ್ ಇಲ್ಲ, they are not followed any rules.
ಏನಾದ್ರು ಸ್ಟೇ ಮಾಡಿದೀನಾ ನಾನು ಬೇರೆ?
ಇಲ್ಲ, ಈ ಸ್ಟೇ ಕೊಟ್ಟಿಲ್ಲ ಸ್ವಾಮಿ.
ಏನಾಗಿಲ್ವಾ?
My humble submission is, my lord,
ಇದು ಶ್ರೀನಿವಾಸ್ ರೆಡ್ಡಿ ಅವರೇ, will it not amount to 304A only? 304 ಹೆಂಗಾಗ?
you must kindly see.
ಓದಿ sir.
Knowledge, you must kindly see.
ಓದಿ.
Ingredients. My lords, you must kindly see the.
It is
Three
were they present in that in the spot and they performed this act knowing that they are going to die?
You must kindly, if they are unable to provide any
That is
safety measures.
negligence,
things, my
sir.
lord, you must
That is
kindly-
negligence.
You must
Thing has
kindly
to
see.
be-
Knowledge.
304 is
you must kindly-
culpable homicide
Page
not
number-
amounting
I
to
will
murder.
note it. I will inserted, my lord.
You
Page number
ಓದಿ.
7 of my.
304 ಓದಿ sir.
304. punishment for culpable homicide not
Not
amounting
amounting
murder.
to murder.
ಮತ್ತೆ ಲಾಸ್ಟ್ ಓದ್ಬಿಡ್ತೀವಿ. If the act is done with the knowledge that
Our-
is
yes,
likely to cause
yes.
death, but without
Right,
any intention to
right.
cause death or to cause such bodily injury as is likely to cause death.
All right.
In this case, my lord, they are not made out any safety measures, they are not provided any safety measures, they are not appointed the supervisors regarding the.
That's all right. That is
That's all.
negligence.
Under such circumstances, my lord,
Negligence.
it clearly.
ಒಂದ್ ನಿಮಿಷ 304 ಆಗ್ಬೇಕಾದ್ರೆ 301 ಅಲ್ಲಿರೋ ಇಂಗ್ರೀಡಿಯೆಂಟ್ಸ್ ಇರ್ಬೇಕು. 301
You kindly see the.
301 ಇಂಗ್ರೀಡಿಯೆಂಟ್ಸ್ ಇದ್ರೆ 304 ಬರುತ್ತೆ. Go to 301.
You kindly see the complaint, my lord.
ಸರ್ 301 ಓದಿ. 304 ಓದಿದ ತಕ್ಷಣ ಅದ್ ಮಾಡಿ.
ಹಾ,
301 ಅಲ್ಲಿ ಏನಿದೆ ಓದಿ ಅಲ್ಲಿ.
301.
ಎಸ್. ತಾನೇ ಜಗದೀಶ್?
Yes, please.
ಸುಮ್ನೆ 304 ಕನ್ವರ್ಟ್ ಮಾಡಿ ಅಂದ್ರೆ ಆಗಲ್ಲ.
On the basis of the.
Because it is culpable homicide is blamable homicide not amounting to murder. ಇಲ್ಲಿ ಸ್ವಿಮ್ಮಿಂಗ್ ಪೂಲ್ ಅಲ್ಲಿ ಸೇಫ್ಟಿ ಮೆಜರ್ಸ್ ಇಟ್ಟಿಲ್ಲ ಅಂತಂದ್ರೆ ಇಟ್ ವಿಲ್ ನಾಟ್ ಅಮೌಂಟ್ ಟು 304. 304 ಏನೇ ಕರೆಕ್ಟ್ ಆಗಿ ಮಾಡಿದ್ದಾರೆ.
Death by a person other than person whose death was intended. In this case, my lord, the supervisor as well as the owners, they have got some knowledge regarding the.
ಆಯ್ತು ಸರ್.
If they are not
See,
maintaining the swimming
safety
pool.
measures were not kept.
Yes.
All right.
Yes.
The swimming pool did not have lifeguard or whatever it is. They are all negligent acts. 304 ಬರಲ್ಲ. 304 ಅಂದ್ರೆ ಅಕ್ವಿಟ್ ಆಗ್ಬಿಡ್ತಾರೆ. ಸುಮ್ನೆ ಇರಿ. 304A is the offense. ಸುಮ್ನೆ don't kill the cause also.
So my lord, so my humble submission is direct the trial court, my lord, as per 323, if they finds out any material regarding so in knowledge regarding those aspects on the evidence, my lord, that may be 320.
That is always open, sir. Why should I direct?
Some observations of that set are 323, my lord, kindly see. The 323 is very clear, my lord.
CRPC.
House. Procedure when after commencement of inquiry or trial, magistrate find case should be committed if in any inquiry into an offence or trial before a magistrate, it appears to him at any stage of the proceeding before signing the judgment that the case is one which ought to be tried by the court of session, shall commit to that court under the provisions here and before.
304 ಇದ್ರೆ committal 4 ಏಕ್ ಬರಲ್ಲ. You are asking the contradictory.
The charge sheet papers
Sir,
under the
304 A ಕಮಿಟ್ ಮಾಡಿ ಅಂತಂದ್ರೆ what is this?
Witness statement.
304A is a matter that is to be tried by the magistrate.
If
He
the
will try
permits,
it.
my lord.
304 ಆದ್ರೆ it will go committal order ಆಮೇಲೆ 304 ಆಗಿಲ್ವಲ್ಲ ಇಲ್ಲಿ.
The evidence will come on record.
That the court will take, sir. 304 ಬರಲ್ಲ.
That is my humble submission, my lord. Kindly give the directions for alternate.
No direction. Yes, sir.
Different amount, my lord.
304 magistrate ತಾನೆ.
ಹೌದು magistrate.
If the permits, my lord, regarding the evidence available and record, my lord, at that
Sir,
time.
it cannot amount to 304. It is 304A only.
The safety, they have got knowledge regarding if they are not done
That is-
anything
that-
regarding
that
the
can't-
appointment
you
of
can't do that.
supervisors and.
There should be mens rea for 304. It's a blamable, sir, culpable homicide, it's a blamable homicide. Culpable ಅಂದ್ರೆ blamable.
Knowledge
not-
ಇದೆ ಅಂತ that is my contention. Papers.
That is death by negligence, 304A. Dismissed. Next.
17 years, so I, my lord.
Sir, all sympathy is definitely a precious life is lost. ಅದಕ್ಕೆ 304A. We are not quashing the crime. 304A 7 years.
One observation.
Murder ಆಗಲ್ಲ.
If the evidence is come on record, my lord,
That is always
they are
open,
not
sir.
collected the footages and CCTV.
That is always,
footages and
sir,
other things,
ಏನೇ
my
ಆದ್ರೂ
lord.
304 ಗೆ ಬರಲ್ಲ. Yes. Next.
29.
Much of.
Tape ಜಾಸ್ತಿ ಆಗುತ್ತೆ. ಇಷ್ಟೊಂದು
Thinking of bank account. The financial transactions that happened between family members.
Based on 6th December. Next.
30.
The petition of judicial custody ಮೇಲೆ ಇದು ಸ್ಟಾಟ್ಯೂಟರಿ ಬೇಲ್
ಸ್ಟ್ಯಾಚ್ಯೂಟರಿ ಬೇಲ್
ಹೌದು
ರಿಜೆಕ್ಟ್ ಮಾಡಿದಾರ?
ಹೌದು
ಎಸ್ ಜಗದೀಶ್.
ಚಾಲೆಂಜಿಂಗ್ annexure A.
Why statutory bail is rejected? Poxo na?
Contention is
Coca.
Coca has been invoked. Extension of time. He was not heard is the contention.
He has to be heard.
No, madam.
Why?
You need to be informed.
No, no. You need to be informed or need to be heard also.
No, the lawyers only need to be informed.
No, sir.
That's,
I'll produce it. I have some doubt about it.
yes.
Because you're denying his bail, which is statutorily available. You want to extend it by invoking something else. I think you have to hear him.
No, it's the,
No, that you provision ಓದ್ಬೇಡಿ.
even judgment.
Interpretation by the Supreme Court.
Yes, madam. 2024.
24 then some
Yes.
doubt about it. Day after tomorrow. List day after tomorrow in the fresh matters list. Yes.
31.
Only prayer is, my lord, a poor woman in whose favor orders of maintenance is passed, my lords. The husband is employed in the central services, the military service, my lord. Warrant could not be executed. Nothing could be recovered since more than 4 years, my lords. Only
What is the prayer?
prayer is to execute the warrant.
Your lordship, warrant, they stated that he's in military service. ನ್ಯಾಯಾಲಯಕ್ಕೆ ಬರಲು ಫೆಬ್ರವರಿಲಿ ಬರ್ತೀನಿ ಅಂತ, that is what is.
My lords, the one thing is, my lord, the learned magistrate would insist the wife to furnish the address. Wife is unable to get the address. And when my lords warrants are issued to them, my lord, they should take necessary steps because she has to live.
ಈಗ no maintenance is
Nothing
paid.
is paid. Nothing is paid all these years. Since
We'll get him
he has to
for
pay.
payment. In courtiಗೆ I will come in February ಅಂದ್ರೆ
ಅಲ್ಲ, ರಜಾ ಇಲ್ಲ, ಕಾಶ್ಮೀರದಲ್ಲಿ ಕರ್ತವ್ಯ
Only payment since
ಏನು what is he working there as?
ಈತನು ಭಾರತೀಯ ಮಿಲಿಟರಿ ಸೇವೆಯಲ್ಲಿ ಜಮ್ಮು
ಮಿಲಿಟರಿ
ಕಾಶ್ಮೀರ
ಸೇವೆಯಲ್ಲಿ ತುಂಬಾ ವಿಂಗ್ಸ್ ಇದೆ, ಏನಿದೆ ಅಲ್ಲಿ?
ಡೀಟೇಲ್ಸ್.
He may be a cook also.
Since the
That
year
details are not mentioned.
2020, nothing is paid.
ಇಲ್ಲಿ there is an order of maintenance staring at him. How is he walking free there? The learned HCGP to secure instructions as to and intimate to the concerned authorities as to how a communication is sent to this court that he would come only in the month of February. Any exigencies at any defense exigencies, the instruction shall include the instructions to be secured from the by the HCGP from the hands of the appropriate authority shall include the defense exigencies, comma, if any, that are if any that is causing an impediment for the petitioner, for the husband to appear before the court. List the matter on 22nd. Please, Ramana, wait. Yes.
32.
Appearing for petitioner, my lord.
In this matter, my lord, on the last occasion, lordship has directed me to secure the statements which are recorded by the police.
Victims.
ಎಲ್ಲ
Record ಮಾಡಿದಾರಾ?
ಇಲ್ಲ, ಒಂದರಲ್ಲೂ ಏನು ಹೇಳಿಲ್ಲ.
ಏನು ಹೇಳಿಲ್ಲ. Learned HCGP places the statements of the alleged victims on record. The same is taken on record. List the matter on 12th December. Next.
Much obliged.
33.
For the petition in this case, my lords, the case where, my lords, after 5 years, my lords, a complaint is filed. My lord, commercial suits are pending.
Connected.
Other connected matters, my lords, the other companies, my lords, are involved, my lord. The first respondent company, my lord, availed the premises belongs to the petitioner. But earlier, my lords,
We'll take it 20th, 21st in the fresh matters list. Yes, next.
34.
34 is also connected, my lord.
Same, yes, 34.
35.
Appear for petitioner's counsel. But a 72 years aged doctor, my lord, the gynecologist, has been, my lord, arraigned as accused in a case.
So ಆಗ್ಬಾರ್ದು ಅಂತಿದ್ಯಾ?
No, my lord, the
Gynecologist ಆಗ್ಬಾರ್ದಾ? 72 years ಆಗ್ಬಾರ್ದಾ?
allegation is that, my lord, he has not reported the case of the Lord, termination of pregnancy is the allegation.
Section 21 of POCSO.
21 of,
Ah.
Lord, he was not aware. Before the patient goes to this hospital, Lord, it is admittedly that the victim has gone to a government hospital and she has treated there. That has come in the 164
For
statement.
further treatment ನಿಮ್ಮ ಹತ್ರ ಬಂದಿದ್ದ?
ನಮ್ಮ ಹತ್ರ ಬಂದಿದ್ದ with the excess bleeding report. And therefore, my lord,
Why did not the government hospital report it, sir?
that is exactly the case.
Why did not the government hospital report?
According to her, my lord, she went only to Bhadra Nursing Home. 164, my lord, page 108.
ಎಲ್ಲಿದೆ? Where do you get she went to government
Page
hospital?
51, my lord.
Page
Page 51.
51.
51, my lord.
One
164 statement, my lord. My lord, at page 51, your lordship may read, my lord, after 4 lines.
ಬಲವಂತವಾಗಿ ನನ್ನ ದೈಹಿಕ ಸಂಪರ್ಕ ಮಾಡುತ್ತಾರೆ. ಅದು ಎಲ್ಲಿದೆ? ನಾನು ನನ್ನ
ಇರುವ
ತಾಯಿ-
ಕಾರಣ ನಾನು ಮತ್ತು ನನ್ನ ತಾಯಿ ಅರೆಬೆಳತಿ ಕ್ಯಾಂಪ್ ನಲ್ಲಿ ಇರುವ ಸರ್ಕಾರಿ ಆಸ್ಪತ್ರೆಗೆ ಹೋಗಿದ್ದು. ಅವರು ಪರೀಕ್ಷಿಸಿ ನನ್ನನ್ನು ಗರ್ಭಿಣಿ ಎಂದು
ಎಲ್ಲಿದೆ? ಸರ್ಕಾರಿ
ತಿಳಿಸಿರುತ್ತಾರೆ.
ಆಸ್ಪತ್ರೆ ಎಲ್ಲಿದೆ?
Lord,
ಎಲ್ಲಿ ಓದಿದ್ರಿ?
ಸರ್ಕಾರಿ ಆಸ್ಪತ್ರೆಗೆ ಹೋಗಿದ್ದು
ಎಲ್ಲಿ?
ಅವರು ಪರೀಕ್ಷಿಸಿ ನನ್ನನ್ನು ಗರ್ಭಿಣಿ ಎಂದು ತಿಳಿಸಿರುತ್ತಾರೆ.
ಇರುವ ಕಾರಣ ನಾನು ಮತ್ತು ನನ್ನ ತಾಯಿ ಕ್ಯಾಂಪ್ ನಲ್ಲಿರುವ ಸರ್ಕಾರಿ ಆಸ್ಪತ್ರೆಗೆ ಹೋಗಿದ್ದು ಅವರು ಪರೀಕ್ಷಿಸಿ ನನ್ನ ಗರ್ಭಿಣಿ ತಿಳಿಸಿರುತ್ತಾರೆ. ಆಮೇಲೆ ನಂತರ ನನ್ನ ತಾಯಿ ಸೋನ್ಸು ಮನೆಗೆ ಹೋದ್ರ ಆಮೇಲೆ
ಹೌದು, ನನ್ನ ತಾಯಿ ಅಲ್ಲ, ನಂತರ ಮನೆಗೆ ಹೋಗಿದ್ದಾರೆ ಅಂತ ಕೇಸು. ಕಂಪ್ಲೇಂಟ್ in her complaint she says
Why did
they
not the
went to
government doctor
home.
report it, sir?
That depends a lot. We don't know what page. Your lordship has come to page 108, ma'am.
No, why first ಇರುವ ಕಾರಣ ನಾನು ಮತ್ತು ನನ್ನ ತಾಯಿ ಸೋ ಕ್ಯಾಂಪ್ ನಲ್ಲಿರುವ ಸರ್ಕಾರಿ ಆಸ್ಪತ್ರೆಗೆ ಹೋಗಿದ್ದು ಅಲ್ಲಿ ಪರೀಕ್ಷಿಸಿ ನನ್ನ ಗರ್ಭಿಣಿ ಎಂದು ತಿಳಿಸಿರುತ್ತಾರೆ.
She doesn't say she was minor at that time.
What do you mean, sir? Is he a doctor or what?
Alla,
Won't he know? The
Doctor's
moment he
statement
tests
is
it,
there.
You
They
last
say
may
they
come
have
to page
prescribed
108.
medicine, my lord. The same doctors have been examined as
for
witness.
defending a government doctor, sir.
Yes,
Who is
exactly.
also equally responsible for section
That's
21.
correct, my lord. He is
You
responsible.
can't.
No, your lordship may come
The
to
doctor's
page number
statement is
108.
also there. Doctor says he has given treatment to this girl.
Where is the statement?
108, my lord, page 108.
One nimsha, I'll get back to you, sir.
197, my lord. Sorry, 97. Dr. Jagadish,
Sorry,
Arabilachi Government Hospital, doctor.
Dr. Jagdish.
97.
Dr. Jagadish.
ಗೊತ್ತಾಯ್ತು ಅದೇನ್? Why are you repeating it?
Dr. Jagadish.
ಎಷ್ಟನೇ page?
Yes.
Lord, ಪ್ರಾಥಮಿಕ ಆರೋಗ್ಯ ಕೇಂದ್ರ ಆಸ್ಪತ್ರೆಯಲ್ಲಿ ವೈದ್ಯಕೀಯವಾಗಿ ಕರ್ತವ್ಯ ನಿರ್ವಹಿಸುತ್ತೇನೆ. ದಿನಾಂಕ 27/7/2021 9 ಗಂಟೆಗೆ ನಾನು ಎಂದಿನಂತೆ ಕರ್ತವ್ಯಕ್ಕೆ ನಿರ್ವಹಿಸುತ್ತಿರುವಾಗ ಆ ಸಮಯದಲ್ಲಿ ಅರಬಿಳಚಿ ಕ್ಯಾಂಪ್ನ ನಿವಾಸಿ
ನೀವು ಸ್ಟೋರಿ ಓದ್ಬೇಡಿ ಸರ್, ಆ ಲೈನ್ ತೋರಿಸಿ ಸಾಕು.
ಹೊಟ್ಟೆ ನೋವು, ಎದೆ ಉರಿ ಎಂದು ತಿಳಿಸಿದ್ದು ನಾನು ಅವರಿಗೆ ಕೊಟ್ಟು ಹೊರರೋಗಿ ಚೀಟಿ ಮೇಲೆ ಹೊಟ್ಟೆ ನೋವಿನ, ಎದೆ ಉರಿ ಇಂಜೆಕ್ಷನ್, ಡೈಕ್ಲೋಬಿನ್ ಟ್ಯಾಬ್ಲೆಟ್, ಪ್ಯಾರಾಸಿಟಮೋಲ್ ಟ್ಯಾಬ್ಲೆಟ್, CPM, ಯಾರ್ನಿಡಿಮ್ ಟ್ಯಾಬ್ಲೆಟ್ ಬರೆದು ಕೊಟ್ಟು ಸ್ಟಾಫ್ ನರ್ಸ್
ಸೂಚಿಸಿ ತಿಳಿಸಿದ ನಂತರದಲ್ಲಿ
ಇಂಜೆಕ್ಷನ್ ಕೊಡಿಸಲು
ಗರ್ಭಿಣಿ ಅಂತ ಹೇಳಿದ್ರಂತ ಎಲ್ಲಿದೆ ಇಲ್ಲಿ?
they don't say that.
Your 164 statement is that ಗರ್ಭಿಣಿ ಎಂದು ತಿಳಿಸಿರುತ್ತಾರೆ.
ಅದು 160 victim says. This the very same doctor reported that she is pregnant anta.
Where is that? Doctor statement
In his statement he don't say. My lord, the victim says doctor has diagnosed and said anta.
Yes, sir.
And it has been, my lord, in her statement.
Doctor had a duty to do it.
That's correct.
Yes.
Alla, we may have to.
If a private doctor has a duty to do it, government doctor also has a duty to do
Yes.
it.
Now,
If you want to haul him up for 21, you better haul him up for 21
that's
as
correct,
well.
my lord. But your lord may request your lordship to page 108.
The age of the victim is also disputed. Kindly see page 132.
ಅದೇ ನೀವು ಕೇಳಿದ್ರಾ? ನೀವು
ಅಲ್ಲ,
ಕೇಳೇ
ನಮ್ಗೆ
ಇಲ್ಲ.
ಅವಾಗ ಗೊತ್ತಿಲ್ಲ, ಬಟ್ ಈಗ
ಈಗ ಸರಿ,
major when
ನೋಡೋಣ.
she was therefore 21 does not attract.
That will see.
Page 108. 164 statement of victim. Extra E. It starts from 106, my lord, at page number 108. Your lordship may see second para. ನಂತರ ನನ್ನ ತಾಯಿ ನನ್ನನ್ನು ಅಭಾಷಣ ಮಾಡಿಸಲು ಭದ್ರಾ ನರ್ಸಿಂಗ್ ಹೋಮ್ ಕರೆದುಕೊಂಡು ಹೋಗಿರುತ್ತಾರೆ. Maybe page numbers are different, madam.
ನಂತರ
ನನ್ನ ತಾಯಿ ನನ್ನನ್ನು,
ಎಲ್ಲ ಓದ್ತಾ ಇದ್ದೀರಾ ಸರ್?
page numbers may be different, my lord. In my paper it's 108.
ಕೊಡಿ ಅದು, ಅದೇ ಕೊಡಿ. ನಂತರ ನನ್ನ ತಾಯಿ ನನ್ನನ್ನು ಅಭಾಷಣ ಮಾಡಿಸಲು ಭದ್ರಾ ನರ್ಸಿಂಗ್ ಹೋಮ್ ಕರೆದುಕೊಂಡು ಹೋಗಿರುತ್ತಾರೆ. ಅಲ್ಲಿ ನನಗೆ ಅಭಾಷಣ ಮಾಡಿರುತ್ತಾರೆ. ನಂತರ ಮನೆಗೆ ಬಂದಿದ್ದು ಸೋನ್ಸ್. So you aborted the child?
No, my lord.
Then
the very discharge summary I have produced along with the petition, my lord. There I have conducted the pregnancy test, which is, my lord, negative. Then, my lord, she came with the sign of, my lord, bleeding. That itself is an indication that, my lord, the pregnancy is not there. My lord, therefore, my lord, so far as excess bleeding, I have treated. Discharge summary also I have produced. But whereas in her complaint, she says some other hospital she has went. Kindly see page 37 of the complaint. 36 is the
So the
complaint.
government doctor yaru nodi. Get the government doctor also.
But kindly see, my lord, page 37. She says Nirmala Aspatrige ಕರೆದುಕೊಂಡು ಹೋಗಿದ್ದು. But on, my lord, kindly see on 1/7.
MTP ಮಾಡಿದ್ದು ಯಾರು?
That we don't know, my lord.
According to 164
My
statement,
discharge summary is also there, my lord. I have, my lord, the only.
No, if you have conducted MTP on a minor, definitely then.
Kindly see, my lord, page 37. There, my lord, the complaint says she has went to a Nirmala hospital. That is a different hospital in Bhadravati.
Right, let's see. You, which is that government doctor, get information. We'll take it on 20th in the fresh matters. Again, problem ಏನಾಗಿದೆ?
My lord, he has been, my lord, subjected to appearance and, my lord, harassment. Some ill
When is the
treatment
next?
has been done, my lord, at the hands of police.
What?
My lord, ill treatment has been done to the doctor. Therefore, my lord, some protection.
We'll see. List the matter on 20th in the fresh matters list. The petitioner shall cooperate with the investigation, but in the garb of.
Investigation is over. In the
Charge sheet ಆಗಿದೆ. ಮತ್ತೆ ಯಾರು
charge sheet ಅಲ್ಲಿ implicate ಮಾಡಿರೋದು.
ಅಲ್ಲ,
I was not there in the.
All right, ಯಾರು harass ಮಾಡ್ತಾ ಇದ್ದಾರೆ ಮತ್ತೆ?
Not the police as well as.
ಇನ್ಯಾವ precipitation? Yes.
Not likely to.
Investigation, no precipitative action.
But at least maybe exempted from appearance.
That okay, it's fine. The petitioner is exempted from appearance before the concerned court in future proceedings. List the matter on 20th in the fresh matters list.
And framing of charge may be deferred.
ಏನು ಇಷ್ಟು ಜಲ್ದಿ ಆಗಲ್ಲ.
My lord, kindly see the certificate also.
ಪರವಾಗಿಲ್ಲ.
She is a major.
ಆಗಿದ್ರು ಏನು ತೊಂದರೆ
matter of fact.
Yes, 20th.
In order to
But
save
the government doctor
doctors,
also
my
you should
lord,
hold, sir. Otherwise, I'm going to let him off.
no, in order to save the government doctors, my lord, he has been roped in. The discharge summary is there, my lord. The test I have conducted and I have treated only for this, my lord, excess.
We'll see. Yes. Next.
36.
Public.
A6, your lordship, is a
ಏನಿದು?
sub-register.
Six, my lord, IAPM. That's the petitioner is a sub-registrar, my lord. That's in this, your lordship, my lord, heard this matter, day before, the connected matter.
Allege of what?
My lord, the allegation is, my lord,
Yes.
that the agreement of sale that is entered into, the seller did not have the power, my lords, to enter into the agreement of sale. That the
19th fresh matters. Yes.
the co-accused, my lord, has been,
All right.
may I just place it on record?
ಕೊಡಿ. Yes. 230 mood matters.
30 more matters.
ಇಷ್ಟಿದೆಯಾ? ಇಷ್ಟೊಂದಿದೆ.
30
Shankar.
more matters.
Police filed my charge sheet against the.
Mic use ಮಾಡಿ.
Lord?
Mic use ಮಾಡಿ.
Please. My lord, respond police, my lord, the complaint, my lord. They have, my lord, filed charge sheet against the petitioner. Petitioners are, my lord, brother and sister. The allegation, my lord, they have shouted.
ಕಾಪಿ ಕೊಟ್ಟಿದ್ದೀರಾ?
ಕೊಟ್ಟಿದ್ದೀನಿ, ತೋರ್ಸಿ. They have shouted.
ಎಲ್ಲಿದೆ ಕಾಪಿ?
ಅಲ್ಲ, I have.
ಶಂಕರ್, ನೀವು ಈ ಕಡೆ ಇದ್ರಿ.
Please, my lord, I have.
ಕಾಪಿ ಎಲ್ಲಿ ಯಾರಿಗೆ ಕೊಟ್ಟಿದ್ದೀರಾ?
ತೋರ್ಸಿ.
he asked me to read the paper and I read.
Please, ಸ್ವಲ್ಪ ಅದು ಬೇರೆ matter. Please. My lord, only allegation, my lord, they have shouted in the police station and.
353.
Please, my lord.
The petitioners are before this court calling in question registration of a crime in crime number so and so for offense punishable under section 353 inter-alia. A perusal at the complaint would nowhere indicate the ingredients of section 353 as is described by the apex court in the case of H. Dhananjay versus cabinet secretary so and so, where the apex court observes that there should be assault and usage of criminal force. There is neither in the case at hand. Therefore, there shall be an interim order of stay of further proceeding, further investigation by these petitioners till the disposal of the petition. Further proceedings by these petitioners till the disposal of the petition.
Please, the police official, my lord, respond 1 and 2.
The additional SPP accepts notice for both the respondents. ಮೇಲೆ ಬರ್ದ್ಬಿಡಿ ಅದು ಆಮೇಲೆ ಅದು perusal at the complaint but a summary of the charge sheet. Yes, next.
Date maybe.
Interim order ಕೊಡಲ್ಲ, date verify, date maybe.
Sir, my lords, 406 and 420, my lords. The complaint came to be lodged on 17/10/2024, alleging that in the month of December 2017, he had given money to his partner
Heard the
of
learned-
85 lakhs.
Heard the
my lords.
learned counsel Avinash appearing for the petitioner. The copy ಕೊಟ್ಟಿದ್ದಾರಾ?
ಕೊಟ್ಟಿದ್ದಾರೆ.
ಹಾ.
Quotations.
Copy for the petitioner. The complaint is for the following purpose. Page 15. If the complaint is for the following purpose, setting criminal law into motion or permitting further investigation in the
lords.
case at hand, would
May-
run foul
may-
of the judgment of the apex court in the
May I
case of-
draw my lord's attention to page 31 annexure E, my lords, whereas 85 lakhs is a amount, they have seized 5 accounts of my family members, my lords. Therefore, my lords, I may be having the liberty to file the application for defreezing the amount,
List after 2 weeks.
my lords.
ಸುಮ್ನೆ ಇದ್ರೆ ಸರ್ ಎಲ್ಲಿ ಸ್ಟಾಪ್ ಮಾಡ್ಬೇಕು ಅಂತಾನೆ ಗೊತ್ತಿಲ್ಲ ರೀ. ಬೆಳಿಗ್ಗೆ ಮೆನ್ಷನ್ ಮಾಡ್ಬೇಕಾದ್ರೂ ಇದೇ ಪ್ರಾಬ್ಲಮ್. ಎಲ್ಲದಕ್ಕೂ ಒಂದೇ ಅರ್ಜೆನ್ಸಿ ಪ್ರೊಜೆಕ್ಟ್ ಮಾಡ್ತೀರಾ. ಏರಿಳಿತಗಳಿರ್ಬೇಕು ಯಾವಾಗ. ಎಸ್, so and so will run follow the judgment of the apex court in the case of Lalit Chaturvedi, 2024 SSC online SC, page 171. The learned counsel for the petitioner submits that several accounts of the petitioners have been frozen on account of the impugned crime being registered. Therefore, petitioner is at liberty to avail of such remedy in the light of the interim order of stay granted by this court. ಪೂರ್ತಿ ಹೇಳೋವರೆಗೂ ಬಿಡಲ್ಲ. Yes.
Number 3. Such.
3, my lords, during an election rally, my lords. They say, my lord, I have made a election rally in the by-elections. I have made a statement.
Why did you make a statement?
Allah, not statement, page 15, very surprising. And there is no statement by me. Statements are by others, Mr. C.T. Ravi and Pratap Singh. I have not made any statement. Kindly see page 15 for one. Page 15, Lord's Secretary.
Page
23. 1-5. Page 23.
ಹೇಳಿ ಸರ್.
1-5 statement. This is the complaint.
ಹಾ.
Lordship may skip first few lines. Sentence commencing.
ಅಲ್ಲ ಅವ್ರು ಹೇಳಿದ್ ಕರೆಕ್ಟ್. ಪೇಜ್ 23 ಇರೋದೆಲ್ಲ.
No, that is second one. The FIR is based on this complaint, page 15. But kindly skip the first few lines, not relevant. It starts from ಮುಂಜಾನೆ 11 ಗಂಟೆಗೆ, Lordships get that straight. ಮುಂಜಾನೆ 11, Lordships get it.
Yes, sir.
Yes. ಮುಂಜಾನೆ 11 ಗಂಟೆಗೆ ರ್ಯಾಲಿಯ
5 ಗಂಟೆ ಆಗಿದೆ. ನೀವು ಹೇಳಿ ಮುಂಜಾನೆ 11 ಗಂಟೆ.
ಅಲ್ಲ, ಪ್ರಾರಂಭವಾಗಿದ್ದು ಸದರಿ ರ್ಯಾಲಿಯಲ್ಲಿ ಮುಖಂಡರಾದ ಕರ್ನಾಟಕ ರಾಜ್ಯದ ಮಾಜಿ ಮುಖ್ಯಮಂತ್ರಿಗಳು ಹಾಗೂ ಕೇಂದ್ರ ಸಚಿವರಾದ ಅವ್ರು ಯಾಕೆ ನನಗೆ ಕೇಂದ್ರ ಸಚಿವರು ಮಾಡಿದ್ರೆ ನನಗೆ ಗೊತ್ತಿಲ್ಲ. I am not a ಕೇಂದ್ರ ಸಚಿವ. The complaint says
you are not a ಕೇಂದ್ರ ಸಚಿವ.
I am not. He says I am a ಕೇಂದ್ರ ಸಚಿವ. Anyway, no, I am happy. ಮಾನ್ಯ ಶ್ರೀ so and so ಮತ್ತು ಮಾಜಿ ಸಚಿವರುಗಳಾದ so and so ಇನ್ನಿತರು ಬಿಜೆಪಿ ಪಕ್ಷದ ಮುಖಂಡರು ಭಾಗವಹಿಸಿದ್ದು ಎಲ್ಲರೂ ಪ್ರತಿಭಟನಾ ಸಾಗುತ್ತಾ ಶಿಗ್ಗಾಂವಿ ಟೆಂಪೋ ಸ್ಟ್ಯಾಂಡ್ ತಲುಪಿದ್ದು ನಂತರ ಮಧ್ಯ 1:30 ಗಂಟೆಗೆ ಮೆರವಣಿಗೆಯಲ್ಲಿ ಬಸವರಾಜ ಬೊಮ್ಮಾಯಿ ಸಾಹೇಬರು ಮಾತಾಡಿ ನಂತರ ಶ್ರೀ ಪ್ರತಾಪ್ ಸಿಂಹರವರಿಗೆ ಅವಕಾಶ ಮಾಡಿಕೊಟ್ಟಿದ್ದು. ಆಗ ಪ್ರತಾಪ್ ಸಿಂಹ ಜನರನ್ನು ಉದ್ದೇಶಿಸಿ ಮಾತಾಡುತ್ತಾ ಅವ್ರೇನೋ ಹೇಳಿದರು. I have not made any statement.
ಏನು 505 ಏನಿದು?
196 under the new code 156.
153.
There is nothing more than so far. I have not made any statement at all.
Last 4 lines. ಅಲ್ಲ ಇವ್ರು ಮಾಡಿ.
Well, they say call.
ಇವ್ರದಲ್ಲ.
ಇವ್ರ ಕಂಪನೀಸ್.
ಎಲ್ಲಿದೆ?
Accomplice. Last 4 lines.
ಅಲ್ಲಿ ಏನ್ ಹೇಳಿದ್ರು?
Last 4 lines.
ಅವರು ಸ್ಟೇಟ್ಮೆಂಟ್ ಮಾಡಿದ್ದಾರೆ.
ಅಲ್ಲ ಅವರಾದ್ರೆ ಏನ್ ಹೇಳಿದ್ರು?
ಅವರು ಕೆಳಗಡೆ ಮಾಡಿದ್ದಾರೆ.
Last 5 lines ಮೇಲೆ ಚಳುವಳಿ 1947 ರಲ್ಲಿ ಎಲ್ಲ ಕೊಟ್ಟಿದೆ.
ಚಳುವಳಿ
page 16 ಅಲ್ಲೇ ಲಾಸ್ಟ್ 4 lines.
ಕ್ರಮಕ್ಕಾಗಿ
It's not a statement made by me.
It's all right.
ಲಾಸ್ಟ್ 4 lines ಮೇಲೆ
ಕಾರಣ ಶಿಗ್ಗಾವಿ ಪಟ್ಟಣದಲ್ಲಿ ಅಲ್ಲಿ ಆ
ಅಲ್ಲ ಚಳುವಳಿ 1947 ರಲ್ಲಿ ಎಲ್ಲ ಕೊಟ್ಟಿದೆ.
1947 ಕಾಣ್ತಾನೆ ಇಲ್ವಲ್ಲ?
You are reading some other.
Where is 1947?
Page 15 ಓದಿ. ಬೇರೆ ಓದ್ತಾ ಇದ್ದಾರೆ.
ಅವರು ಇನ್ನೊಂದು ಪೆಟಿಷನ್ ಓದ್ತಾ ಇರ್ಬೇಕು. ಎರಡಿದೆ ಇವರು.
Page 15 ನೋಡಿ. ಅದರಲ್ಲಿ ಇಲ್ಲ ಯಾವ್ದು ಇನ್ನೊಂದು ಬೇರೆ ಸ್ಟೇಟ್ಮೆಂಟ್ ಮಾಡಿದ್ದಾರೆ.
ಇದ್ರಲ್ಲಿ 1947 ಅಂತ ಏನಿಲ್ವಲ್ಲ?
ಹೌದು.
ಇದೆಯಾ?
ಇದರಲ್ಲಿ ಇಲ್ಲ, ಅದರಲ್ಲಿ
ಇದರಲ್ಲಿ.
ಬೇರೆ ನೆಕ್ಸ್ಟ್ ಅಂತ ಹೇಳ್ತಾರೆ.
ನಂಬರ್ ರೈಟಿಂಗ್ ಗಾಟ್ ಎಕ್ಸ್ಚೇಂಜ್.
ಇದು ಪರವಾಗಿಲ್ಲ.
ಸಾರಿ,
ಫೈಲ್ ಎಕ್ಸ್ಚೇಂಜ್ ಆಗಿದೆ ಅಷ್ಟೇ.
ಅಲ್ಲ ಇರಲಿ.
ಕರೆಕ್ಟ್ ಆಗಿ.
There is no statement by me at all.
There is.
By me, I have not made any statement at all.
Yes, Jagdish. The petitioner is before this court calling in question so and so. Heard the learned senior counsel Prabhuling Navadi along with Shiva Prasad Shantan Gowda appearing for the petitioner. The allegation is offense punishable under section 196, 96 alva.
Old 153A, my lord.
196 1A of the BNS,
Yeah.
which is 153A of the earlier regime, the IPC. The offense alleged is certain statements made by the petitioner in a public rally. A perusal at the complaint would not indicate the statements made by the petitioner, as the narration is that after the petitioner stopped his speech, some others have made the statement. Even otherwise, it cannot amount to an offense under section 153A as 153A as held by the apex court in plethora of judgments, the latest being in the case of Shiva Prasad Sembal versus so and so, reported in 2024. SCC online and 14 minutes. So and so. Therefore, there shall be an interim order of stay of further investigation by the petitioner till the next date of hearing.
Number 4.
And 2024 SSC online is I think 2248.
Once we are before this honorable court for the third time.
Third time?
Yes.
What happened 2 times?
Lords, 2 times there were FIRs registered against us. Lords, I just take a minutes of your lordship's time. Lords, we purchased the property in the year 1996. Some people claim to have purchased the very same property in bits and pieces in 2004. They went before the civil court for an injunction. Their suits were dismissed by recording 3 findings. They were later purchasers. The physical existence of their properties is not reflected and possession is not shown. That decree has become final. Then the Tahsildar passed an order saying that there was an attempt to convert an agriculture to non-agricultural land and directed the Deputy Commissioner to assist him in taking action. The Deputy Commissioner did not assist. We came before this honorable court. This honorable court allowed the writ petition by dismissing the other writ petitions filed by the persons who claimed having interest in the property, saying that the Deputy Commissioner is required to implement the order of the Tehsildar. Notes, then FIRs were registered against us. We came before this honorable court. This honorable court granted a stay of the FIR.
This is third FIR.
Notes, now it's not the third FIR. After your lordships granted the stay of all the FIRs on 2 occasions, in order to circumvent your lordship's order, what he does is, he refers to the very same FIR and says that there is a threat of breach of the public tranquility and passes an order under section 117, which is the present
Deputy
section.
Commissioner.
Yes, the Deputy Commissioner passes an order.
Where
Lords, I have sought for an
are the
inquiry.
orders granted by me?
Lords, your lordships will find it at page number 104, my lords. 104 and 106. And if your lordships were to see, my lords, just the previous page, this honorable court has allowed my writ petition directing the Deputy Commissioner to implement the order. Who is the second respondent in the writ petition? 1 minute. Lord, see, someone wants to cite the land grabbers to ensure that they are given protection. He asks me to give a security, not them.
New petitioner adರಲ್ಲಿ.
Yes, I am the writ petitioner.
Yes.
Page 111.
In what public tranquility is being disturbed, sir?
Page 111. Notice has been issued to him.
To whom, sir?
To the petitioner.
What for?
Asking him to explain, and he has not appeared.
What explanation you want, sir?
ಎದುರುದಾರರಿಗೆ column 132 ಅಡಿಯಲ್ಲಿ notice ಜಾರಿ ಮಾಡಿ
What explanation for what purpose?
about this is to keep peace in the region.
Keep
That's all.
peace. Who has breached the peace?
Intended to breach. This is the preventive orders.
What
have been
preventive measure are you taking here to breach the peace?
It is only to prevent
Misuse of 107 proceedings on the face of it.
He could have explained, my lord. Notice
Why?
has been issued. He could have explained.
Why
Others have
should
explained.
he appear? ಸುಮ್ನೆ ನೋಟಿಸ್ ಕೊಡ್ತಾನೆ ಇರೋದ ಎಲ್ಲ.
ಅಲ್ಲ others have.
So ಇದಾಗಲ್ಲ ಅಂದ್ರೆ ಇದು ಮಾಡೋದು.
ಅಲ್ಲ others have.
Because you know the law, you want to trouble people.
ಅಲ್ಲ others have. We have issued a notice. Others have appeared and given explanation. We dropped against them.
Why that procedure you want to do for the
We wanted to
for
make
the sake of satisfaction of your egos?
We want to make sure that.
What make sure? What has happened till now? What public tranquility is disturbed now? Tell me.
No, because there is
What is the ಇವರಿಬ್ರು ಕೊಟ್ಟಿಲ್ಲ, ಎಲ್ಲರೂ ಬೇರೆಯವರು ಕೊಟ್ಟಿದ್ದಾರೆ. ಈಗ ಈ ನಡುವೆ ಯಾವ ಪಬ್ಲಿಕ್ ಟ್ರಾಂಕ್ವಿಲಿಟಿ ಡಿಸ್ಟರ್ಬ್ ಆಗಿದೆ?
ಅಲ್ಲ ಆಗತ್ತೆ ಅಂತ ಮಾಡ್ರು.
ಯಾವ ಆಗುತ್ತೆ ಅಂತ ಆಗಿದೆಯಾ ಈಗ?
ಅಲ್ಲ ಆಗತ್ತೆ ಅಂತ. It is in preventive of.
That's all right. Just because you have this preventive thing, you start invoking proceedings against everybody.
That's the only way.
And that's the only way you can trouble them.
ಅಲ್ಲ it's only to prevent, my lord.
What prevents, sir? What do you want to prevent?
ಅಲ್ಲ if you had given explanation, my lord.
Why should
probably
they
would
give?
not have-
Tell me. There is an interim order in their favor. There is an order by the coordinate bench to implement the order in the OS. And you want to circumvent all that by troubling them by giving these notices?
They provided all this information, my lord. It would
Why,
not have-
sir? If this information is available, the investigating officer should give it.
My lords, deputy commissioner is a party in the previous
then
petition. He
what,
is fully
sir?
aware of everything.
Yes. Is he feigning ignorance or inflating his ego here?
secure, my lord.
Yes, sir. What you will secure? You will
Lord, there
secure
is-
the deputy commissioner here.
My lords, kindly have a look at page number 8. What is the statement made at paragraph number 4? 4 lines from the bottom. This is what the deputy commissioner actually is doing. Harassing the petitioners of one of the counts, as a matter of fact, in exercising his power only in favor of the land grabbers, threatening the petitioners of registering false cases, opening rowdy sheeter list against the petitioners, fixing in false criminal cases if the petitioners were not to settle, give up their claim in respect of the property, agreeing to the terms of the land grabbers. Second respondent has also threatened that he would influence the jurisdictional Tahsildar to recall his order and to nullify the directions of the Honorable High Court. This is exactly what he has said.
Yes, sir. Keep the deputy commissioner present.
I made him as a party in person, my lords.
Let the notice
Person
go.
ಮಾಡಿದ್ದೀರಾ?
Yes, fourth respondent.
Let the
By
notice-
name?
Yes.
Oh, then fine. He will have to answer. No issues. Heard the learned senior counsel D.R. Ravishankar appearing for the petitioner. 2 crimes are sought to be registered
13
by
FIRs.
Huh?
13 FIRs on 2 occasions.
13 crimes are sought to be registered against these petitioners twice over. All these crimes are stayed by this court or the coordinate bench of this court.
Lords, this honorable court has only stated.
ಅಂದೇನೆ ಅಲ್ಲ?
Yes.
This court in writ petition 1519561 of 24 and 22032 of 24. The interim orders read as follows. The learned senior counsel would take this court through an order passed on 26th September 2024 by which the 2024 by which the coordinate bench of this court had directed by issuance of a writ in the nature of mandamus to implement the order passed by the civil court in OS 665.
By the Tahsildar.
ಅಲ್ಲ, implementation by the
Implementation of the order passed by the Tahsildar, which is
order
at page
passed by the
69.
Tahsildar in OS 66.
In proceedings number LNSY.
ಹೇಳಿದಿರಾ ಅದೆಲ್ಲ?
Lords, it is there, my lords, in the order. Page
Page.
number 102.
ಎಲ್ಲೇನ್ ಅಂತ ಎಲ್ಲಿದೆ ಸರ್?
Lords, that is in WP number 17208. That prayer is extracted, my lords, in the writ petition itself. 17208 at page number.
ಅದು ಯಾವ್ದು ಬರ್ಕೊಡಿ, ಅದು ಯಾವ್ದು?
Lords, I'll write it
So
down.
and so.
Page number 78.
The deputy commissioner is a party respondent to the said order passed by the coordinate bench as respondent number 3. After all this, the allegation by the learned senior counsel is to circumvent these orders. Proceedings under section 107 CRPC is instituted by the petitioner, by the respondent deputy commissioner, calling the petitioner to explain why he should not be prosecuted for likely disturbance of peace and tranquility in the surrounding. Order pass ಮಾಡಿದಾರಾ?
Yes, my lords.
And on the ground that he has not appeared, the impugned order is passed. The respondent, deputy commissioner, is arrayed as a party in person attributing malefides against him. The malefides against the deputy commissioner is found at paragraph 4 in the petition. In the light of the aforesaid, in the light of what is aforesaid, there shall be an interim order of stay of all further proceedings, all further investigation.
But there is no investigation.
Allah, all further proceedings pursuant to the stay of the impugned order and all further proceedings taken thereto. Objections, if any, by the deputy commissioner by the next date of hearing along with others, list the matter on 19th December for further hearing.
Lords, it's great.
Notice has to have to. Since
Emergent
party-
notice to ನೀವು ಯಾರಿಗೆ additional SPP ಯಾರ್ಯಾರಿಗೆ?
One man.
One, ಆಮೇಲೆ 2 ಯಾರು?
I'll take it for 1, my lord, 2 and 3.
One and two, my lords, additional SPP. 3 and 4, I'll have to take emergent notice.
3, 4 emergent notice returnable by the said date. Yes, next.
Please, my lords, great.
What is number 5?
ಇದು ಅದೇನಾ?
Basic for hand delivery in that.
5:30 ಕೂತು ಎಂಟ್ರಿ ಮಾಡಿ ಕೊಟ್ರೆ ಹ್ಯಾಂಡ್ ಡೆಲಿವರಿ ಬೇರೆ 4:00 ಎದ್ದೋಗ್ತೀನಿ. Yes.
This is also like this, in the same election rally, not the same day.
Same order.
Same order. There is slight difference. But the Bharatiya Janata,
1947.
the Bharatiya,
ಇದ್ರಲ್ಲಿ 1947.
ನಾನ್ ಹೇಳಿಲ್ಲ. The Bharatiya Janata, no, I'll just, Bharatiya Janata Party votes had there.
ಸರಿ, ಯಾಕೆ ನೀವು ಇಷ್ಟೊಂದು ಟೆನ್ಷನ್ ಇದ್ದೀರಾ?
Sorry,
Back side.
if I'm given
Yes.
that impression. They had planned a protest,
Ah.
but against this illegal notification of Waqf properties.
Ah.
This
Waqf
only
property ಇದೆ ಇದು.
the statement made by the petitioner is, I had reserved about 1.5 crores for giving lands to Bovi. Now this is also notified as Waqf property. This they say is a hatred speech designed to pick up a fight between two communal trusts. Kindly see the statement, not at page 16.
Sir, if this is this thing, you should also encourage restraint on what you're speaking.
Now, your lordship, if the last 4
What?
lines,
Page number 16 ನೋಡಿ.
page 16, last 4 lines.
Last ಬೇರೆಯವರು ಹೇಳಿದ್ದು ನಾನು ದಯವಿಟ್ಟು please don't
Not for
attribute
you.
it to me.
Not for you.
Please don't, no, I am, petitioner is before your lords.
Don't worry. ಅಷ್ಟೊಂದು ಟೆನ್ಷನ್ ತಗೋಬಿಡಿ. Yes, sir.
Not for this petitioner, but your
Sir,
lordship.
that's
if
all
last-
right.
Last
But
4
if you
lines.
want restraint on the speech of these people, you should have restraint on your side also.
I can't be speaking for,
What you're speaking, sir?
I can't be speaking for.
Every action has equal and opposite
Well,
reaction.
I can't be speaking for on behalf of.
ಸಿ ನಾಗೇಶ್ ಸರ್ ಇದಾರೆ ಇದರಲ್ಲಿ?
ಇಲ್ಲ, next case.
Yes.
No, I'll just point out the statement, my lord, which they say is incriminating, 116 page. 16.
Page?
16 ಅಲ್ಲಿ, the sentence commencing from lords 3:30 ಸುಮಾರು ಸವಣೂರು ನಗರದ ಭರಮದೇವ್ ಸರ್ಕಲ್ ನಲ್ಲಿ ಬಂದೋಬಸ್ತ್ ಕರ್ತವ್ಯದಲ್ಲಿದ್ದಾಗ ಮಾನ್ಯ ಮಾಜಿ ಮುಖ್ಯಮಂತ್ರಿಗಳ ಸೋ ಅಂಡ್ ಸೋ ಅವರ 5 ಜನ ಹೆಸರು ದೇ ರೆಫರ್ ಟು. ಇವರುಗಳಲ್ಲಿ ಒಂದು ವಾಹನದಲ್ಲಿ ಹತ್ತಿ ತಮ್ಮ ಭಾಷಣವನ್ನು ಮಾಡಿದರು. ಮಾನ್ಯ ಮಾಜಿ ಮುಖ್ಯಮಂತ್ರಿಗಳು
How will it amount to 153 years?
Last 4 lines.
What last 4 lines?
I may not be required language, my lord, in last 4 lines is what?
ಉತ್ತೇಜಿಸಿ.
Page 16 ಅಲ್ಲಿ last 4, after 1947.
a learned friend must say, it's not.
ಯಾರು ಮಾಡಿರೋದು ಸ್ಟೇಟ್ಮೆಂಟ್?
ಇಲ್ಲ, I'm not saying that petitioner. I'm not saying petitioner.
ಇವರು
Not-
on mass not
I
simply
did not
registering
say
FIR against all.
But FIR against others also.
Every action has an
That is
equal
the
and
background
opposite
of
reaction.
election, my lord.
Every action has an equal and opposite reaction. So every statement has an equal and opposite statement. ಇದು 153 ಅಂದ್ರೆ ಅದು 153. Yes, in the heard, so in the meantime. I think you should be relaxed now. Why stress? Yes.
Serial number 6?
ಅವ್ರದ್ದು ಬಂದ್ರೆ ಅವ್ರದ್ದು ಮಾಡ್ತೀವಿ. Yes. ಏನ್ ಮತ್ತೆ?
Serial number 6 and 7. Out of the same.
230 ಯಾಕೆ ಮೂವ್ ಮಾಡಿದ್ರಿ ಸರ್ ಇದು? 6 and 7.
Yes.
What has happened again?
My lord, a serious and an important question of law has been raised for being answered by your lordship in this case.
ಹಾ.
The-
ಒಂದ್ ಯಾವ್ದೋ ಡಿಸ್ಮಿಸ್ ಮಾಡಿದ್ವಲ್ಲ ಅದೇನು?
ಅದಲ್ಲ,
Final
ಇದು
ಆಯ್ತಾ?
ಬೇರೆ, ಇದು ಬೇರೆ. My lord, on 13th of March 2023, an application came to be filed by the first accused in the case, invoking the jurisdiction of the court under section 306 of the CRPC to permit
Approver.
him to be treated as an approver in the case
All right.
on 13/3/2023.
ಹಾ.
But on 29th of April 2023, that application came to be rejected by the trial court. Well, may I just request your lordship for a second to have a look at page 146.
No, now what is called, why 230 urgency ಏನು?
ಹೌದು, ಅರ್ಜೆಂಟ್ ನಾಳೆಗೆ ಹಾಕೊಂಡಿದ್ದಾರೆ ಎವಿಡೆನ್ಸ್ಗೆ ಅಂತ, ಅವಂದು ಅಪ್ರೂವರ್ ಎವಿಡೆನ್ಸ್ಗೆ. ಬಟ್ ಇಟ್ ಇಸ್ ಕವರ್ಡ್ ಬೈ ಯುವರ್ ಲಾರ್ಡ್ಶಿಪ್ಸ್ ಜಡ್ಮೆಂಟ್ ಇನ್ ದಿ ಕೇಸ್ ಆಫ್ ದಿಸ್ ಮಲ್ಲಿಕಾರ್ಜುನ ಶಿಪ್ಪಿಂಗ್ ಪ್ರೈವೇಟ್ ಲಿಮಿಟೆಡ್. ಮೊದಲು ಪಾರ್ಡನ್ ಮಾಡಬೇಕು. ಇವರು ಹಾಗಲ್ಲ. ಐ ವಿಲ್ ವೆಯ್ಟ್. ಐ ವಿಲ್ ಡೈರೆಕ್ಟ್ ದಿ ಮ್ಯಾಜಿಸ್ಟ್ರೇಟ್ ಟು ರೆಕಾರ್ಡ್ ಯುವರ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ಅಂಡರ್ 164. I will look into the 164 statement. Then I will consider the issue whether I should give you the pardon or not. That is impermissible under law.
ಅಲ್ಲ, ಯಾರು who has sought pardon now?
A1, first accused in the case. But more than that.
So why are you aggrieved by that?
Not against me.
You are accused number 15.
I am 15. The prosecution wants the first accused to be treated as an approver so that he could give evidence against me.
Not your
ಅಲ್ಲ,
lordship.
ಇನ್ನೊಂದಿದೆ, ಅಲ್ಲ ಒಂದ್ ನಿಮಿಷ, ಒಂದು ಲೀಗಲ್ ಇಶ್ಯೂ ಹೇಳ್ಬಿಡ್ತೀನಿ ನಾನು ಏನು ಅಂತ ಅಂದ್ಬಿಟ್ಟು ಅಂತ. ಅಲ್ಲ, ಟ್ರಯಲ್ ಇಸ್ ಗೋಯಿಂಗ್ ಆನ್, ಎವಿಡೆನ್ಸ್ ಇಸ್ ಬೀಂಗ್ ರೆಕಾರ್ಡೆಡ್. But 164 CRPC comes into play, not subsequent to the commencement of the trial. Have a look, kindly have a look at section 164, which comes on to chapter 12.
Yes.
Only during investigation, my lord,
Correct.
ಅಷ್ಟೇ. ಇವರು ಟ್ರಯಲ್ ಆಗುವಾಗ he assumes the role of an investigator, the judge. No, I want his 160. It is not the prosecution that is
He is
seeking for.
recording the statement of the approver.
My lord?
Is he recording the statement of the approver?
No. No. How can he do it, my lord? My lord, he should be only a presiding judge and not a participating judge. I am sorry to say this. How could he ask the magistrate to record his 164 statement and send it to him? ಆ ಸ್ಟೇಜ್ ಮುಗಿದೋಗಿದೆ. Only during investigation 164 could be recorded. Have a look at the language of section 164, my lord, for a second. Would your lordship permit me to take your lordship to 164? It comes under chapter 12, investigation ನಲ್ಲಿ, commencing from 154.
ನಾಳೆಗೆ ಹಾಕೊಂಡಿದ್ದು ಯಾವತ್ತು?
ನಾಳೆಗಿದೆ.
ಅಲ್ಲ, ಯಾವತ್ತು ಹಾಕೊಂಡಿದ್ರಿ ನಾಳೆಗೆ?
30ನೇ ತಾರೀಕು.
5th.
30ನೇ ತಾರೀಕು. 30th not is order.
ಅರೆ, ಈ ಆರ್ಡರ್ ಮಾಡಿರೋದನ್ನೇ 12ನೇ ತಾರೀಕು, ಅದಂಗ ಅವತ್ತು ಹಾಕೋತಾರೆ.
ಸರ್ 30ನೇ
ತಾರೀಕು ಆರ್ಡರ್ ಮಾಡೋದು.
ಅಕ್ಟೋಬರ್.
ಸಮನ್ಸ್ ಮಾಡೋದು 5ನೇ ತಾರೀಕು. ನಮಗೆ ಕಾಪಿ ಕೊಟ್ಟರೋದು 11ನೇ ತಾರೀಕು. Day before yesterday.
Yes, sir.
Yes, my lord. Any metropolitan magistrate or a judicial magistrate may, whether or not he has jurisdiction in the case, record any confession or statement made to him in the course of an investigation under this chapter. ಎಲ್ಲಿದೆ? ಟ್ರಯಲ್ ನಡೆಯುವಾಗ 164 ಮಾಡಿ ಅಂತ ಅಂದ್ಬಿಟ್ಟು ಅಂತ. That too, not at the instance of the IO. The learned judge says.
Where is the order?
Yes, my lord. May I request your lordship to kindly turn to page 47.
ಅಲ್ಲ, ಈಗ 90 page I am seeing. Where is it?
No, page 47. Kindly go.
47.
7.
ನಾವು ಅಪ್ರೂವರ್ ಆಗಿ ಅಲೋ ಮಾಡಿ ಆಗೋಗಿದೆ 306.
ಈಗ ಅದನ್ನ ಆರ್ಡರ್, that is the one which we have questioned now.
He could not be turned as approver.
Yes, he can't be treated as an approver so that he could give evidence against me.
Now, who is accused number 1? That petition ಯಾವುದು? ಮುಟ್ಟಗಿ.
ಮುತ್ತಗಿ.
ಸರಿ. Because I have dismissed this case as accused number 1. Yes.
Kindly have a look at page 337.
337.
337.
ಅಲ್ಲ, 47 ಅಂತ ಹೇಳಿದ್ರೆ.
ಅಲ್ಲ, ಅದು ಬೇಡ. ಅದಕ್ಕೂ ಮುಂಚೆ ಆರ್ಡರ್, no, I will ask the magistrate to record your statement under 164. If you side with the prosecution, then I will give you the permission for being treated as an approver anta. Are unheard of. Well, it is always the prosecution or the investigator who is indeed entitled to make an application under section 306. An accused can't ask. That is the law laid down by the Supreme Court. But have a look at section 300.
ಅಲ್ಲ, ಈಗ 6 ಗಂಟೆಲಿ ತೀರ್ಮಾನ ಮಾಡಬಲ್ಲ, ನಾಡಿದ್ದು ಮಾಡೋಣ.
ಅವ್ರನ್ನ ಎಕ್ಸಾಮಿನ್ ಮಾಡೋದು ಬೇಡ, ಬೇರೆ ಎಲ್ಲ ಮಾಡಿ. ಓನ್ಲಿ ಅವನದು ಎವಿಡೆನ್ಸ್ ಬೇಡ ಅಂತ ಅಷ್ಟೇ.
ಯಾವುದು ಎವಿಡೆನ್ಸ್ ಆಫ್ ದಟ್ ಮುಟ್ಟಗಿ?
That approval.
ಅದನ್ನ ಆಮೇಲೆ ಮಾಡಿ.
Your lordships have already held, not in 2023, the co-accused not will have no legal right challenge not the order of pardon granted to the another. This is not I just pass.
That is a Yogeshwar case.
No, ಇದರಲ್ಲಿ ಇನ್ನೊಂದು.
ಇದೇ ಯೋಗೇಶ್ವರ್ ಕೇಸ್.
ಮಲ್ಲಿಕಾರ್ಜುನ shipping, not para 10. At page 204.
ಅಲ್ಲ, ಮೊದಲು ಪಾರ್ಡನ್ ಆಗ್ಬೇಕು, ಆಮೇಲೆ ಎವಿಡೆನ್ಸ್. ಇವ್ರು ಎವಿಡೆನ್ಸ್ ಆದ್ಮೇಲೆ ಪಾರ್ಡನ್ ಮಾಡ್ತೀನಿ ಅಂತ.
ನಿಮ್ಗೆ ಅದರ ಚಾಲೆಂಜ್ ಮಾಡೋದಕ್ಕೆ ರೈಟ್ ಇದೆಯಾ ಅಂತ.
ಅದು ಸರಿ.
Apex Court not as was pleased to consider it, not which your lordship not after following the judgment of the Apex Court not at para 10.
All right, we'll 6 o'clock ಆಗಿದೆ, we'll hear it.
Not order is passed not on 30th October.
But summons issue ಕಾಪಿ ಕೊಟ್ಟರದ 11th ನಾವೇನು ಅವಾಯ್ಡ್ ಮಾಡಕ್ಕಾಗಲ್ಲ.
ಈ ಫೈಲ್ ಕೂಡ ಈಚೆ ಬರಲಿಲ್ಲ.
Upload on the same day.
ಅಪ್ಲೋಡ್ ಮಾಡಿಲ್ಲ. ಐ ಆಮ್ ಸಾರಿ, ಇಟ್ ಇಸ್ ಇನ್ಕರೆಕ್ಟ್. 10th ನೈಟ್ ಅಪ್ಲೋಡ್ ಮಾಡಿದ್ದಾರೆ. ಇನ್ನೂ ಒಂದು ಹೇಳ್ತೀನಿ ಬೇಕಾದ್ರೆ ನಾನು ನಿಮ್ಗೆ. ಇದರಲ್ಲಿ ನಾನು I have not come across a case where in the order, my lord, the learned judge writes, I have dictated this order between 1 PM and 2 PM ಅಂತ. ಅವತ್ತು ನಾವುಗಳೆಲ್ಲ ಕೋರ್ಟಲ್ಲಿ ಇದ್ರು ಅವರು 10 ನಿಮಿಷದಲ್ಲಿ ಆರ್ಡರ್ ಮುಗಿದೋಯ್ತು. ಆರ್ಡರ್ ಮೇಲೆ ಬರುತ್ತೆ ಅದು ಬಿಟ್ವೀನ್ 1 PM and ಅದು ಅವಶ್ಯಕತೆ ಏನಿತ್ತು ಹೇಳಿ, ದಯಮಾಡಿ ಹೇಳಿ ಮಿಸ್ಟರ್ ಪ್ರಸನ್ನ
ಅವಶ್ಯಕತೆ
ಕುಮಾರ್.
ಏನಿತ್ತು ಅಂತ ಬಹಳ ಹೇಳ್ಬೇಕಾಗತ್ತೆ, ಬೇಡ.
ಅದ್ರಲ್ಲೇ ಹೇಳೋಣ.
Restrict ourselves.
That's all right, but we'll take it on a particular day, 20th or something.
ಎನಿ ಡೇ ಮೇಲೆ ಅಲ್ಲ, ಈ ಕೇಸ್ ನಲ್ಲಿ ತಾವೇ ಆರ್ಡರ್ ಮಾಡಿದಿರಿ ಇಲ್ಲಿ. ಕೈಂಡ್ಲಿ ಗೋ ಟು ಪೇಜ್ 8 ಮೇಲೆ. ಸೇಮ್ ಕೇಸ್, ಕೈಂಡ್ಲಿ ಗೋ ಟು ಪೇಜ್ 8.
8 of
ಈಗ ಅವ್ರು ಪ್ರಸನ್ನ ಅವ್ರು ಕೊಟ್ಟಿದ್ದು
ಅದರಲ್ಲೇ
ಪೇಜ್ 8 ಪ್ಯಾರ ಇಲ್ಲ ಇಲ್ಲಿ. ಪೇಜ್ 8 ಅಲ್ಲಿ ಸೆಕ್ಷನ್ 306 ಟೆಂಡರ್ ಆಫ್ ಪಾರ್ಡನ್ ಟು ಎನ್ ಅಕಾಂಪ್ಲಿಸ್. My lord gets it, madam? Now kindly go to the next page. Section 306 mandates concerned court to accept an application filed seeking tender of pardon to any accomplice in the crime, subject to the condition that once pardoned, he should make a full and true disclosure of all of the circumstances within his knowledge to the court concerning the issue. Ivar athara alla. He is putting the cart before the horse.
Now pardon is already made.
Madam?
He has already pardoned him.
Yes.
No.
Order is
No.
not passed.
No. After 164
No,
statement.
306 order is not passed.
No order is passed.
No, sir.
Order is passed on the application filed under section 306 after getting his 164 statement recorded.
Now, where is the order under 306 now?
Yes, ma'am. It is
Page 47.
Yes, page
The
47.
operative
That is what
portion note
I
is
said.
at page 91.
Application filed by Muttagi 306 CRPC is hereby allowed and is considered to be an approver. What's wrong?
Evidence ಗೆ ಅವನ್ ಸಮನ್ ಮಾಡಿದಾರಲ್ಲ.
ಅಲ್ಲ, ಈಗ anybody can turn approver.
Anybody can turn approval, my lord.
Huh.
He places reliance on the 164 statement which he would get recorded by the magistrate.
Where is that?
Yes, my lord. He refers to it in the order itself, very order itself.
Where was the direction to the magistrate? To
Yes,
record
that is exactly what I said. 338. Kindly go to 338. Then ನಾನು ಹೇಳಿದೆ, I wanted your lordship to have a look at 337. Unless and until his statement is recorded, he can't.
Now, dehorse this statement. He could have accepted him becoming an approver.
That's it. He could have rejected or accepted it.
He has accepted it.
No, after recording the statement.
It's all right. Now he has recorded the statement and accepted it.
He did not record. He would direct the magistrate to record.
All right. Recorded statement is recorded. and
ಇಲ್ಲಿ
is accepted.
scope ಇಲ್ವಲ್ಲ ರೆಕಾರ್ಡ್ ಮಾಡೋದಕ್ಕೆ ಎಲ್ಲಿದೆ?
Even otherwise, without dehorse this also, he could have passed an order accepting him.
The earlier application came to be rejected on the same ground.
That will consider.
But
Now,
because of the change of guard in the court, the application filed came to be
Now
filed.
what I'm telling is, without this statement or with this statement, the concerned court was empowered to pass an order accepting.
No, not on a bald application. That is what the Supreme Court has
No.
said.
Accepting or rejecting the application under 306.
Under section.
That will be tested on that. Even if this is not in existence, 306 can be agitated.
No, my lord, it is on certain, what the Supreme Court would say is, have a look at the earlier order which came to be passed by the very court at page 124. Kindly go to 142. Kindly go to 142. Kindly permit me to take your lordship. This is earlier application. I have gone through section 306, 307, 308 CRPC. There is no bar, as my lord has pointed out, there is no bar either under section 306, 307 CRPC to tender pardon to an accomplice, and court can tender pardon at any stage of the investigation or inquiry into or trial of the office. Now, in this case, a charge is not yet framed. At this stage, the accused number one has filed an application under section 306 CRPC seeking tender of pardon from this court. In the application filed by the accused number one, he stated that he is ready to give tender, of pardon in support.
Now, you need not dub that as 164 statement. On what basis will he become an approver? He should give some statement that yes.
Yes, my lord, he must at least set out in the application what really happened, what is the role played by him, what is the role played by the other persons, without which how does he tender? That is what the learned judge would write here on the earlier application. Same carbon copy application is filed now. I produced both the applications. Earlier application, kindly go to page 144, para 19.
We'll hear it. Not at this hour, but 20 ತಾರೀಕು 21ಕ್ಕೆ ಹಾಕ್ತೀನಿ.
Not
Let
let
the
me,
court not record his statement.
That's all.
chief,
Then
now
drag
hold on.
on.
We will examine not his chief examination.
No,
It has to differ.
Arre, if this order goes, you can't be a witness.
Recording of this person's statement will be deferred.
Yes.
ಬೇರೆ ಎಲ್ಲ ನಡೀತಾರೆ.
ಮಾಡ್ಲಿ.
Like,
Evidence ಇದೆ.
now,
Evidence ಇದೆ.
now, not, there's already direction by this honorable court. The trial should conclude within not 3.
ಅಂದ್ರೆ ನೀವು ತಪ್ಪು
sir.
ಆರ್ಡರ್ ಮಾಡ್ಬಿಟ್ಟಿದ್ರೆ ನಾವು ಸುಮ್ಮನೆ ಹೋಗ್ಬೇಕು
Thereafter-
ಅಂತನಾ?
First of all, you have no
Well,
right of audience that I have brought your lordship kind notice.
That is
They should show not how they have right of audience. Right of audience, till then, not now they are saying, not that,
ಅಲ್ಲ ಇವ್ರದೇ ಒಂದು 482 dismiss ನಾಗೇಂದ್ರ ನಾಯಕ್ appear.
Please, madam.
Yes. All right. Right of audience ಇಲ್ಲ ಅಂತ 306 they cannot challenge.
That's what
ಇವೆಲ್ಲ
your lordship not have held.
Yes.
Your lordship.
We are the persons who are affected.
ಅಲ್ಲ ನಗೋದೇನಿದೆ ಅದರಲ್ಲಿ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಹೇಳಿದ್ರೆ ತಾವು ಹೇಳಿದೀರಾ?
Who else could challenge it?
It's good challenge it, my lords. Co-accused if they can't challenge.
That's what apex court
Have I
says.
written that it cannot be challenged?
My lords, it only starts like that, my lords. My lords has
Not,
not
ma'am,
given a
not
finding on that.
2013
Paragraph
Supreme
10 will be
Court.
noticed.
2013.
Have I said,
Plainly.
Allah, have I said the accused have no locus to
No,
challenge?
no, my lords.
May I just not,
This is how my lord.
2013 not, may I just,
Paragraph 10.
2013-15 Supreme SEC.
ಅಲ್ಲ ಇರ್ಲಿ ನನ್ನ ಆರ್ಡರ್ ನೋಡ್ಬಿಟ್ಟು.
Within this may not, your lordship not have said.
I've got.
Para 40 of not this
Both
SEC.
It just starts, my lords, whether and no, my lords doesn't give a finding on that. Paragraph 10, the starting point, and then thereafter it may be noticed, my lords.
ಯಾವ ಕೇಸಲ್ಲಿ ಸರ್?
My lords, this was in that Mallikarjun Shipping Private
In the
Limited.
light of the aforesaid judgment parliament statute.
Paragraph
you know,
10.
This kindly come to me not
Pardon
2013,
is
not para
permissible
40.
exercise of power concerned so and so permitted. Judgment relied on.
So many decisions of the Supreme Court. my lords,
Paragraph
it can
40.
Only be the
Accused.
co-accused.
But the
paragraph
crux of this,
This will challenge it, my lords.
Not para 40, not of this 2013 Supreme Court.
And my lords.
that is Ashok Kumar Agarwal.
Please, madam.
Ah.
My
Para
lords, may I
40.
just add one aspect, my lords. Virtually the same application,
Carbon
same
copy.
statement filed by CBI.
ಅಲ್ಲ ನಿಮ್ಗೆ ಗ್ರೀವೆನ್ಸ್ ಇದೆ ಹೇಳ್ತೀನಿ ಒಂದು ನಿಮಿಷ. ಅಲ್ಲ ಅವ್ರೊಂದು ಪ್ರಶ್ನೆ ಹೇಳ್ತಾರೆ ಉತ್ತರ ಹೇಳಕ್ಕಾರ ಬಿಡ್ಬೇಕಲ್ಲ.
ಎಲ್ಲಾರು ಸರಿ 6 ಗಂಟೆಯಲ್ಲಿ ಏನಿದೆ?
Court.
ಅಲ್ಲ ಅವ್ರು ಆರ್ಡರ್ ಆದಾಗ ಮೂವ್ ಮಾಡಬೇಕು.
What's
ನಾಳೆ
the
ಇದರಿಂದ
urgency,
ಹಿಂದಿನ ದಿನ
my lords?
ಬರ್ತಾರೆ.
What's their
2:30
urgency
ಕೇಳ್ತಾರೆ.
for having it when the trial
Why?
is going on? Why is there?
Other
so much
witnesses
of
are there.
urgency? Other witnesses are there.
Summons are.
ಅಲ್ಲ, ನೀವ್ ಹೇಳಿದಾಗ ನಾವು ಟ್ರಯಲ್ ನಡೆಸೋ ಅವಶ್ಯಕತೆ ಇಲ್ಲ. ನೋಡಿ,
Wait tomorrow.
if they are agreed by not, let them come on time. Not when it is listed.
ಆನ್ ಟೈಮ್ ಹತ್ರ 12ನೇ ತಾರೀಕು ಕಾಪಿ ಕೊಟ್ಬಿಟ್ರೆ ಇವತ್ತು 13. ಇನ್ಯಾವ ಬರ್ಬೇಕು ನಾನು? ಅದು ಬೆಳಗ್ಗೆ 10 ಮೂವ್ ಮಾಡಿದ್ದೀನಿ.
Yes.
My lord was so considerate to get this matter listed by issuing a direction to the registry.
Not
At
my
2:30.
submission is,
ಇನ್ಯಾವ
my
ಬರ್ಬೇಕಾಗಿತ್ತು ನಾನು?
submission 2013 Supreme Court. Kindly have a look
ಅದನ್ನ
at
ಮುಂದಕ್ಕೆ ನೋಡು.
paragraph number 40. So far as entertainment of the case at the behest of the respondent by the High Court is concerned, we may state that he may not have a legal right to raise any grievance, particularly in view of the law laid down by this court in so and so. However, the revisional powers under section 397 read with 401 can be exercised by the court suo moto, particularly to examine the correctness and legality or authority of any finding sentence or order.
Your evidence
So regularity
is being laid
of
against
any
me.
proceedings of the inferior.
The revisional court powers can be exercised, but
Inherent
go into
powers.
conflict.
ಅವ್ರಿಗಿಲ್ಲ. This is what apex court has said. They have no right.
So, not by them, so motor revisional powers can be exercised. It's 482 can't be exercised. Yes. Reddy has lot to say.
Please.
Yes. ಯಾವತ್ 20ಕ್ಕೆ ಹಾಕಣ್ವಾ? 20ಕ್ಕೆ ಅದು ಕೊಟ್ಟಿದ್ದೀನಿ 2:30ಗೆ ಮೇಡಮ್ ದಟ್
22nd.
ಎಲೆಕ್ಟ್ರಲ್ ಬಾಂಡ್ಸ್ 28 ಹಾಕಿ 20 ತಾನೇ ಹಾಕಿದ್ರು 21st ಹಾಕಿ
22nd.
22nd.
Second.
ಹಾಕು.
22nd.
Please.
22nd 2:30. Yes, because ಇದು ಅಲ್ಲಲ್ಲೇ ಮುಗಿದೋಗ್ಬೇಕು.
Please.
This can't hold on the trial. Yes. Heard the learned, ನೀವು ಹೇಳ್ತೀರಾ ಕೋರ್ಟ್ಗೆ ನಾಳೆ
ಅಲ್ಲ ಸ್ವಲ್ಪ
ಇದು
ಕಷ್ಟ.
ಅಪ್ಲೋಡ್ ಮಾಡೋದೆಲ್ಲ ಕಷ್ಟ ಆಗುತ್ತೆ.
ಇಲ್ಲಿ ತೊಂದರೆ ಇಲ್ಲ. Your lordship dictate 2 lines order not die.
ಮೇಡಮ್ ಇದು ಅಪ್ಲೋಡ್ ಮಾಡಕ್ ಮಾತ್ರ ಮಾಡಿ ಡೀಟೇಲ್ ಆರ್ಡರ್ ವಿಲ್ ಪಾಸ್. ದಿ ಕನ್ಸರ್ನ್ ಕೋರ್ಟ್ ಶೆಲ್ ಡೆಫರ್ ರೆಕಾರ್ಡಿಂಗ್ ದಿ ಎವಿಡೆನ್ಸ್ either recording the evidence of
The first accused as the approver in the.
the accused number 1 who has now turned approver till further orders at the hands of this court. List the matter on 22nd at 2:30 PM.
Please.
All right?
ಅಲ್ಲ, till further orders ಅಂದ್ರೆ ಮತ್ತೆ ಆಮೇಲೆ
ಅಲ್ಲ,
petition ಮುಗಿದೆ.
till
Till
till the
next
next
date
date of hearing. Further orders is next date. all right. Till the next date of hearing. It's too late now to pass an order.
We will be inhuman, my lord, if we.
All right.
7.
Seven ಏನು?
6 and 7 are
Why
connected.
is seven
Different
ಏನು?
accused.
The other accused who are here, 8 to 14, I find.
We'll consider that. Yes, next. Venkatesh, Aditya.
Yeah, for the petitioner. Petitioner, husband and wife, my lord. They are
Total husband and wife.
please, they are arraigned as accused for offense punishable under
Ah.
1R and 3(1)(s) and of the Atrocities Act, my lord.
Between husband and wife.
No, my lord, they are arraigned as accused, my lord.
Ah.
The petitioner, 1 and 2, they purchased,
Yes.
property belonging to the brother-in-law.
Where did you hurl abuses?
But there's no instance of hurling abuse at all because the complaint and the further statement can be seen, my lord. The further statement of the
Yes.
accused,
Jagdish,
page number
copy
70,
ಕೊಟ್ಟಿಲ್ವಾ?
page number 74, my lord.
Copy ಕೊಟ್ಟಿಲ್ವಾ?
ಕೊಟ್ಟಿದ್ದೀನಿ. Copy ಕೊಟ್ಟಿದೆ. Page 74, my lord. Towards the last paragraph, my lord. ನಮ್ಮ ಮೈದಾನದ ಕೇಶವಮೂರ್ತಿ ಮತ್ತು ಅವರ ಭಾಗಕ್ಕೆ ಬಂದ 3ನೇ ಮಾಡಿಯ ಮನೆ ಮತ್ತು ನೆಲಮಾಡಿಯ ಒಂದು ಅಂಗಡಿ ವೆಂಕಟೇಶ್ ಎಂಬುವವನಿಗೆ, ದಟ್ ಇಸ್ ಪಿಟಿಷನರ್ ನಂಬರ್ 1, my lord, 1 ವರ್ಷದ ಹಿಂದೆ 35 ಲಕ್ಷಕ್ಕೆ ಮಾರಾಟ ಮಾಡಿರುತ್ತಾರೆ. ಮನೆ ಮಾರಾಟದ ವಿಷಯವನ್ನು ನಮ್ಮ ಮೈದಾನದ ನಮಗೆ ತಿಳಿಸಿರುವುದಿಲ್ಲ.
Yes, list the matter on 19th in the fresh matters list. Till such time, the respondents are
Charge sheet has filed, my lord. Warrant has been issued.
ಇದರಲ್ಲಿ
warrant hanging on the head of the petitioner shall remain stayed.
Lord, the
ಮಂಗಳವಾರ ಕೊಡ್ತೀನಿ ಬೇಕಿದ್ರೆ.
ಅಲ್ಲ
fresh matters.
ವಾರಂಟ್ ಸ್ಟೇ ಮಾಡಿದ್ದೀನಿ.
ಅಷ್ಟೇನಲ್ಲ,
ಹಾ.
ನಿನ್ನೆ ಹಿಯರಿಂಗ್ ಇತ್ತು, ಅಪಿಯರ್ ಆಗಿಲ್ಲ, MBW ಆಗಿದೆ ಅಷ್ಟೇ.
My lord,
ಯಾಕೆ ಅಪಿಯರ್ ಆಗಿಲ್ಲ?
my lord, the notice also was not served on me, my lord. Summons ಬಂದಿಲ್ಲ ನನಗೆ.
Anyway,
appear
warrant we'll see next date. Warrant stayed is next.
Quoting settlement, seal number 9, Raghavendra AV.
ಇಲ್ಲ ಅಂದ್ರೆ 2 weeks ಬಿಟ್ಟು ಹಾಕಿ ಮೇಡಮ್. ಯಾವ ಮೂವ್ ಮಾಡಿದ್ದಲ್ವಾ ಇದು? ಎಸ್, ನೆಕ್ಸ್ಟ್ ಕರೀರಿ. ಮೀರನ್ ಸಾಬ್ ಯಾರು ಇಲ್ಲ. 6 ಗಂಟೆಗೆ ಯಾರು ಇರ್ತಾರೆ ಬಿಡಿ. ಎಸ್, ಎನಿಬಡಿ ಪ್ರೆಸೆಂಟ್ ಫಾರ್ ಸೆಟಲ್ಮೆಂಟ್?
Serial number 11, my lords.
Serial number
11, my lords.
ನವೀನ್ ಕುಮಾರ್.
Petition, my lords.
9 withdrawal.
Settlement.
Withdrawal, ಸರಿ. Serial number 11 ಏನು? Offense.
376 and 470. But my lord, they are married and they are having a children.
No problem. Who are married?
My lord,
Same
subsequent-
persons are
Yes,
married.
Yes, my lords. They are-
And that can be
ಮೆರಿಟ್ ಮೇಲೆ
merit ಮೇಲೆ better.
My lord, even otherwise, there is no
No,
material.
why do you get the parties under 376 and 417? I tell you, it can't be settled. Come on, merits will close it. It's better for you.
My lord, subsequent to the complaint, they got married. my
Aitu, that is an added circumstance for me to say, but we will pass orders on merits.
lord.
You are every day in the court. You don't know why do you get the parties, madam? You are aware of the fact that I will not settle 376 and 417. We'll post it on the fresh matters list, close it on that day.
My lord, at least stay, my lord, because he has to come from the Kerala to appear before.
Come from Kerala.
Kerala.
Asha, the Kerala, yes. We'll post it on 22nd and close it.
Please, my lord.
Parties need not be present. Please send them. The petitioner is before this, petitioners are before this court calling in question proceedings in so and so. It transpires that pursuant to the registration of the crime, the petitioner and the complainant have married and are leading a life together today. Therefore, there shall be an interim order of stay of further proceedings in in special case number 1799 of 2022 till the disposal of the petition. List the matter on 4th December in fresh matters list. I will dispose it on that day. Don't get the parties. Let them stay wherever they want.
Serial number 12, my lord.
Number 12.
Really, 307 is the husband and wife.
307 husband and wife.
Husband and wife, my lord, exaggerated complaint. Same day she's been discharged, six. my
All
lord.
right, settlement has.
No, they're present before the court.
ಇವತ್ತಿಲ್ಲೇ ಇರುತ್ತೆ. ಎಲ್ಲಿ ಸೆಟಲ್ಮೆಂಟ್ ಅಲ್ಲಿ?
Yeah, my lord.
ಸೆಟಲ್ಮೆಂಟ್ ಎಲ್ಲಿ ಅಂದ್ರೆ ಅಲ್ಪ ಲೇಟ್ ಆಯ್ತಾ?
ಇಲ್ಲ.
ಮತ್ತೆ ಸೆಟಲ್ಮೆಂಟ್ ಎಲ್ಲಿಂದ ಆ ಕಡೆ ತೋರಿಸಿದ್ರೆ ಲೇಟ್ ಆಗಿದೆ ಅಂತ. ಹಾ, ಎಸ್. offenses ಇನ್ನೂ ಒಂದು ಮಾಡಿದ್ದೀನಿ 3 months husband and wife ಅಲ್ಲಿ ಈಗ ಸೈನ್ ಮಾಡಿದೆ.
Morning of memo, my lord, reporting settlement, my lord.
ಕೊಡಿ. ಮೆಮೊ ಮೂವ್ ಮಾಡಿದ್ರ?
ಹೌದು ಸ್ವಾಮಿ.
ಬರ್ಬೇಕಲ್ಲ ಸರ್ ಫೈಲ್.
2:30 ಗೆ ತಾವು ಆರ್ಡರ್ ಮಾಡಿದ್ರಿ.
ಬಂದಿದ್ಯಾ? ಬಂದಿಲ್ಲ. 6 ಗಂಟೆ ಆದ್ರೂ ಬಂದಿಲ್ಲ ಅಂದ್ರೆ ನೀವು ಇವತ್ತು ಬರೋಣ.
Order.
Yes, my lord, may be taken up tomorrow, my lord.
ಟುಮಾರೋ ಆಗಲ್ಲ ಸರ್.
Day after tomorrow.
ಡೇ ಆಫ್ ಟುಮಾರೋ ಯಾವತ್ತು ಹಾಕಿದ್ರಿ ಮೇಡಮ್? ಅಲ್ಲ ಬರ್ದೇ ಇರೋದೆಲ್ಲ ಟ್ಯೂಸ್ಡೇ ಬರುತ್ತೆ 2:30. ಹೇಮಂತ್ ಕುಮಾರ್ ಏನ್ ಮೇಡಮ್ ಇದು?
Tuesday, my submission, my lord.
ವಿಡ್ರಾಯಲ್ ಆಲ್ ರೈಟ್. ಶೇಷಗಿರಿ ರಾವ್
Sheshgiri.
The right of the victim to
ಅದ್ ನಾಡಿದ್ದು ಬರುತ್ತೆ. ಸೆಟಲ್ಮೆಂಟ್ ಅವ್ರ ಹೆಸರೇನು? ಇರ್ಲಿ ಬಿಡು.
Same settlement. Yes, senior citizens are there. The file has not come.
Where are they from,
Morning I
sir?
have mentioned.
Where are they from?
They are from native here, it's 50 kilometers away.
ಹಾ, ಫೈಲ್ ಬರ್ಬೇಕಲ್ಲಪ್ಪ, ಇಲ್ಲ ನಾನು ಏನ್ ಮಾಡ್ಲಿ? ನೀವು ಮೂವ್ ಮಾಡಿದೀರಾ, ಆಲ್ ರೈಟ್. ಫೈಲ್ ಬಂದಿಲ್ವಲ್ಲ, ವಾಟ್ ಕ್ಯಾನ್ ಬಿ ಡನ್?
Please let those parties not come.
ಫೈಲ್ ಇಲ್ದೇನೆ ಸಿಗ್ನೇಚರ್ ತಗೊಳಕ್ಕಾಗುತ್ತೆ.
Wife present.
ಕೀಪ್ ದಿ ಹಸ್ಬೆಂಡ್ ಅಂಡ್ ವೈಫ್ ಪ್ರೆಸೆಂಟ್, ದಟ್ಸ್ ಎನಫ್.
See, they are
498 ಏನಾ? 498. ಲೆಟ್ ನಾಟ್ ದಿ ಎಲ್ಡರ್ಸ್ ಕಮ್. ಅವರಿಬ್ರು ಬಂದ್ರೆ ಸಾಕು. ಆಲ್ ರೈಟ್, ಡೋಂಟ್ ವರಿ ಅಬೌಟ್ ಇಟ್. ಎಸ್,
That's the
ದೇ ಆರ್ ಲಿವಿಂಗ್ ಟುಗೆದರ್ ನೌ.
living together.
ಫೈಲ್ ಬಂದಿದ್ರೆ ಐ ವುಡ್ ಹ್ಯಾವ್ ಕ್ಲೋಸ್ಡ್ ಇಟ್. ಆಲ್ ರೈಟ್, ನಾಟ್ ಕಮ್. ಎಸ್.
Not the right of the victim to contest a bail petition, my lords, in terms of the law laid down by the apex court in Jagjit Singh, my lords.
ಏನಾಯ್ತು?
That has been refused by the sessions court. My lords, it pertains to a gruesome road traffic accident, my lords, where
ಟ್ರೂ, ಬಟ್ ಇದರಲ್ಲಿ ಅಸಿಸ್ಟ್ ಮಾಡಕ್ ಮಾತ್ರ ಕೊಟ್ಟಿದ್ದಾರೆ.
only assist, my lords. I have not, my lord, I have gone there. It is not that I am asking that he must be implicated at the inception. When when I go there, my lords, the law on the point is, when I go there, an opportunity of hearing can be granted to me. That is what, my lords, the apex court said.
ವೆನ್ ಇಸ್ ದ ನೆಕ್ಸ್ಟ್ ಡೇಟ್?
My lords, tomorrow is the next date where the prosecution.
ಎಲ್ಲ ಟುಮಾರೋ ಇವತ್ತು ಮೂವ್ ಮಾಡಿದ್ರೆ ಹೆಂಗೆ?
Yesterday, my lords, this order has been passed and it has not yet been uploaded apart from the summary there.
Yesterday. it's gone to
Then
tomorrow.
Jagjit Singh permits,
It says, my lord,
then no problem.
as
Yes.
is the public prosecutor. through his
List the
counsel.
matter on 19th in the fresh matters list. Till such time, the concerned court shall defer its proceedings.
I am there.
Bail proceedings pending.
Huh?
Bail proceedings. sir.
Bail, ಅದಕ್ಕೆ defer its proceedings. Monday I will dispose here.
Please.
Bail
Lord,
proceedings.
reporting sir.
ಅವ್ರದೇ ತಾನೆ bail. Bail proceedings of the accused.
I am for the victim there.
I know victim.
Victim.
That's the reason.
No, ಹಾಗಾದ್ರೆ Monday ಬೇಡ. List day after tomorrow ಅಂತ ಮಾಡಿ.
Very
Day after tomorrow in the fresh matters list.
Please.
Because complainant coming and stalling bail petitions. Yes.
My lord, reporting settlement may be taken on 20th, my lord, my request.
ಮೆಮೋನಾ ಸರ್?
ಅಲ್ಲ.
ಇನ್ನು 6 o'clock, 7 ವರೆಗೂ ವೇಟ್ ಮಾಡ್ಬೋದು.
Matter, morning I mentioned, my lord, file has not come. Therefore, any date may be given. my
It
lord,
will come,
19th
sir, Tuesday.
Tuesday.
At least now it's enough, I guess.
6 or
Yes, madam. What to do? ಏನು ಉಳಿದಿದೆ? ಅಷ್ಟೇ, ಅಡ್ಮಿಷನ್ ಯಾವ್ದು ಸ್ಟೇ ಇದೆ ಎಲ್ಲ 2 weeks out. 23rd, 22nd. Hearing matters will be on 22nd. ಇದು ಮಾತ್ರ ಮೇಡಮ್, ಇದು ಗಾರ್ಬೇಜ್ ಅರ್ಜೆನ್ಸಿ ಇದೆ. Tomorrow ಆಗಲ್ಲ ಮೇಡಮ್.
My lord,
Day after
serial
tomorrow.
number 67, the date is not been given.
If we'll see. Admission
My
matters.
lord,
But-
57, I have a submission, my lords. I only need a minutes of this honorable court's time. My lords, on the last date of hearing, the matter pertains to Nayara petrol bunk, where the investigating. officer
Exactly.
was
What
kept
is
present.
that? There was an order, intimation from the magistrate to do
There
so.
was no order, my lords. There was no order. I have obtained the complete order sheet, but that is not the crux of the matter, my lords. What has happened is there is a settlement between the parties. And ultimately, in one of the connected matters, the second respondent has approached this honorable court, obtains an interim order on the sole ground that there was a memorandum of settlement.
Which is that?
I will give the matter, I will give the
Number
of the
ಕೊಡಿ,
reference. It may be
number.
connected along with that. And it may be
ನಿಮ್
taken-
serial number ಯಾವುದು?
See, 57 minutes. In criminal petition 1159, we both the petitioners and the.
Orders ಆಗಿದೆಯಾ?
In criminal petition 1159.
57 ಇಂದ ಬರ್ಬೇಕಾಗಿರೋದು?
57 ಇಂದ ಬರ್ಬೇಕಾಗಿತ್ತು, admission matters.
ಕರೆದ್ಬಿಡಿ. Yes.
57.
Hidekebedu.
57, it may be connected with criminal petition 6523 of 2024. minutes.
Tag this petition along with 6523 of
But
2024.
date may be given, my lords.
List them both on 10th December. Yes.
My lords, there is urgency, my lords. There is
Don't
there is
worry.
a connected check bounce matter in which
It's
I
all
am
right.
as an accused.
10,
My
no
lords,
sir.
my lords, one small submission. In 65623, petitioner approaches this honorable court, says that there is a memorandum of
That's
settlement.
all right. List the matter on 3rd December. ಅಷ್ಟೇ, ಅದ್ರ ಮೇಲೆ ಆಗಲ್ಲ. 3rd December, next.
So, like, much
Okay,
obliged.
next.
Still 6532.
ಇವರು ಇದಾರೆ, ಶ್ಯಾಮ್
Madam,
ಸುಂದರ್,
number ಬರ್ಕೊಡಿ.
ಗಾರ್ಲ್ಯಾಂಡ್.
Garland, 15 cases, not some 10 different.
Ah.
I don't want to trouble you a lot.
I heard as Carland. Yes.
Garland.
All right. 58. List after 2 weeks, interim order subsisting shall continue to the next date of hearing. Yes.
59.
Interim order ಇದೆಯಾ? ಇದ್ರೆ ಕಂಟಿನ್ಯೂ ಮಾಡ್ಬೋದು. List after 2 weeks. ಮೇಡಮ್ ಇದು ಸ್ವಲ್ಪ ಇದು ಡೇಂಜರ್ ಇದೆ. ಡೇಟ್ ಕೊಡಿ ಇದಕ್ಕೆ. 59 ಅಲ್ಲಿ ಡೇಟ್ ಕೊಡಿ. There is some serious allegation. 59 list on 10th December. Yes. 60.
Appearing for petitioner, my lord. Petitioner, my lord. 60, 60.1 connect ಆಗಿದೆ sir.
If 60 ಹೇಳ್ಬಿಡಿ ಸರ್ ಆಮೇಲೆ ನೋಡೋಣ.
60.1.
List after 2 weeks, interim order granted earlier stands extended to the next date. 61, Latif. List after 2 weeks, interim order continue ಮಾಡಿ.
62.
Appearing for petitioner. There is another petition.
Attack this petition along with so and so. Interim order subsisting shall continue till number ಬರ್ಕೊಡಿ. There is another petition ಅಂತ ಏರಲ್ಲಿ ಹೇಳಿದ್ರಾಗಲ್ಲ. Yes.
63.
Anandram. 2 weeks, yes.
64.
My lord, 64, the appeal for the petitioner, my lords, and the last date, my lords, are asked to tender the synopsis, just file the synopsis.
Please gives. Yes. Yes. List after 2 weeks, interim order subsisting will continue to the next date of hearing. Next.
65.
ಇದ್ರೆ ಮಾತ್ರ.
For respondent number 2 and 3, filing objection.
Registry lackey. Yes.
My lord, interim order may.
It may be taken on 26th, my lord.
List the matter, not on 26th. List the matter on 5th December. Yes, next. Interim
Lordship
continue.
at 27th, my lordships.
It's 27th. 27th December.
No, ma'am.
November.
November.
All right, yes.
Interim order.
No, 5th December only, yes. That will continue, sir. If you mention, I'll vacate.
Then urgency, my lord.
Yes, no, sir. Yes, next.
66.
2 weeks, yes.
67.
Petitioner, my lord.
Interim order, yeah.
Interim order is there.
Yes, 2 weeks.
December 10th can be, my daughter marriage is there, my lord.
ಅದಕ್ಕೂ interim order ಏನು ಸಂಬಂಧ?
December 10th, maybe next date of hearing, my lord.
So it's ಆ ಥರ. All right, sir. List on 12th December.
No, 10th, whatever the date.
10th is the marriage.
Please, no, in fact, marriage is on 6th of December.
I finish everything and comes. Yes,
Please.
12th December.
Much.
Yes.
68.
PSI matter.
ಇರ್ಲಿ ಬಿಡಿ,
For the
so what?
respondent.
PSI scandal. ಇರ್ಲಿ ಬಿಡಿ, ಮಾಡ್ಲಿ. ಏನಾಗುತ್ತೆ? No, I am hearing the petition. No,
We make an application, not asking the court to defer.
you make whatever.
That may kindly be part of.
No, no, sir. Yes, you know, sir, what to do.
I know that, my lord, but the court, my lord, is quite bent upon, my lord, framing.
No, I have not said anything, sir. Not in this, not in this case. Yes.
Great grounds, my lord, I convince you.
Great grounds.
Yes.
Wow. ಏನ್ ಗ್ರೇಟ್ ವಾಲ್ ತರ ಹೇಳ್ತಾ ಇದೀರಾ? ಗ್ರೇಟ್ ಗ್ರೌಂಡ್ಸ್. ಎಸ್.
In fact, my lord, I will be able to see that as much as declogging can be done.
ಎಲ್ಲಿ ಡಿಕ್ಲಾಗಿಂಗ್? ಎಲ್ಲ ರೀಕ್ಲಾಗಿಂಗ್ ಆಗೋದು. ಎಸ್. ಎಸ್. ದಟ್ ವಿಲ್ ಡೂ. ಮೇಡಮ್ ಇದು 68. 21st, ಸಾರಿ. 6th ಆಗ್ತೀನಿ. ಅರ್ಜೆನ್ಸಿ ಇದೆಯಾ? ಫ್ರೇಮ್ ಮಾಡ್ತಾ ಇದ್ದಾರೆ ಅಂದ್ರೆ.
There are, my lord.
You're already framed, but charges are being framed.
No, madam. There are 43 accused persons. Not one of them has, my lord, filed a discharge application yet, my lord.
ಯಾಕೆ ಇದು ಫೈಲ್ ಮಾಡಿ ಡಿಸ್ಚಾರ್ಜ್?
ಯಾರು ಹಾಕಿಲ್ಲ. Not one of them, my lord.
All right.
The entire case is, my lord, it's a bundle of charges.
Bundle of?
Palace.
Yes, sir. List on 22nd. Yes, 22nd.
Prisoner reading 69.
For petitioner, my lord, one short date may be.
Short date.
Please.
Madam, 29th, yes.
Operation.
B group, adjourn it by 2 weeks. Yes.
Further hearing. 20.
ಅದೆಲ್ಲ 22nd.
Day after.
ನಿಮ್ದು ಡೇ ಆಫ್ಟರ್ ಮೇಡಮ್.
2:30.
ಮೇಡಮ್ ಗಾರ್ಬೇಜ್ ಮ್ಯಾಟರ್ ಮಾತ್ರ ಡೇ ಆಫ್ಟರ್. ಸಾರಿ, ಅದು ಟರ್ಮ್ ಮಾಡೋದು ಹಂಗೇನೆ.
My lord.
Interim order may be extended.
ಇಂಟ್ರಿ ಮಾಡ್ರಿ ಎಲ್ಲಿದೆ?
My lord, kindly excuse, my lord.
2:30.
Morning, my lord.
ಎಕ್ಸ್ಕ್ಯೂಸ್
Please, my lord.
ಇಷ್ಟೊತ್ತಲ್ಲಿ?
ಅಲ್ಲ ಅದಲ್ಲ, ಅಲ್ಲಿ ಮಾರ್ನಿಂಗ್ ಮದುವೆ ಇದೆ ಅಂತ ಹೇಳಿ ಹ್ಯಾಂಡ್ ಡೆಲಿವರಿ ಮಾಡಿ. ಅದೇ.
ಸಿಗುತ್ತೆ. ಪಿಕಪ್ ಹೇಳಿದ್ವಿ. ಪಿಕಪ್ ರೆಡಿ ಇರುತ್ತೆ. ನಾನು ಹೋಗ್ಬೇಕಲ್ಲಪ್ಪ ಸೈನ್ ಮಾಡಕ್ಕೆ. ನೀವು ಬಿಟ್ರೆ ನಾನು ಹೋಗ್ತೀನಿ.
My lord,
Yes.
serial number 83, my lord. The matter is set down for framing of charges, my lord. Against accused number 2, your lordship already directed to.
ಈಗ ಮೆಮೊ ಮೂವ್ ಮಾಡ್ತಾ ಇದ್ದೀರಾ
ಇಲ್ಲ,
ಸರ್?
memo ಅಲ್ಲ ಸ್ವಾಮಿ.
ಮತ್ತೆ
In serial number 83,
ಹಾ.
my lord, offense under 7A, PC Act.
7A.
7A.
So what, sir?
My lord, it's set up for framing of charges in the trial court, my lord. Against accused number 2, your
6
lordship.
o'clock ಅಲ್ಲಿ ಆರ್ಡರ್ ತಗೊಳಕ್ ಹೋಗ್ಬೇಡಿ. ಯಾವತ್ತಿದೆ ಅದು?
30th.
Yes, 27th I have posted all those cases.
Friday at 2:30.
Perfect. Just ಮಾಡಿ smart. ಅದಕ್ಕೆ ಇವತ್ತಿಷ್ಟು.
Friday at 2.
Covered matter, your lordship had directed to for 4 o'clock today.
Now it is 6 o'clock, sir. What to do? It will take.
My lord, Friday at 2:30, my lord.
ಯಾರು?
Friday at 2:30, my lord.
Friday.
Obliged.
Sirajuddin, you have been troubled.
Solitary confinement.
ಅದು ಏನಾದ್ರೂ ಮಾಡ್ತೀರಾ ಇಲ್ಲ ನಾನೇ ಒಂದು ಸೀರಿಯಸ್ ಆರ್ಡರ್ ಮಾಡ್ಲಿ? ಸಾಲಿಟರಿ ಕನ್ಫೈನ್ಮೆಂಟ್ ಅಲ್ಲಿ ಇಟ್ಟಿದ್ದಾರೆ ಬಿಕಾಸ್ ಇಸ್ ಗಿವನ್ ಇನ್ಫಾರ್ಮೇಶನ್ ಅಂತ ಹೇಳ್ತಾನೆ ಇದ್ದಾರೆ ಅವರು.
Secure.
No, I have taken to hospital.
I'll secure the records.
But 24 hours locked in my violation of fundamental rights.
Seriously, the case I will impose exemplary cost.
And because, my lords, a gun and bullet has been passed in the prison that I have projected for that prison, I have been locked in the 24 hours lock from last 4 months, my lord, when the lordship was hearing. Till now, there are so many things, no prison will come forward to.
What is passed into the prison, guns and roses?
No, my lord, that day, I have submitted some photograph that the bullet has been passed in prison. Bullet and the gun is with the jailer. And I have filed an affidavit to that effect also. From that day I have been locked. I am not permitted to meet my wife and my family members also. Now, I filed an application for transfer me to another prison.
Bus, sir. Yes.